documents and my lord, list of documents. And all the formalities are completed, my lord, pursuant to purchase. So kindly let it be listed.
Lordship, it is a PLA matter. For amendment, one line order required. I am waiting for 4 months, Lordship. After amendment, the matter can proceed. Now it gone to monthly list, Lordship. I have mentioned several occasions for upgradation.
Lordship, in this matter, Lordship, seeking leave to file Vakalatnama, because by your Lordship's order, service of summons was dispensed with as a defendant appeared. By your Lordship's order, service of summons was dispensed with as a defendant appeared. The Lordship, I went to the department to file some application. They are again asking for some Vakalatnama. So leave me.
You are not filed Vakalatnama on earlier occasion?
Yes, earlier occasion at the time of giving the G I filed, but in suit I could not
in
file.
the suit.
And the suit I could not file.
So you have to file.
Yes, grateful Lordship.
Leave is granted subject to scrutiny.
May I have your Lordship's kind leave to mention a matter, my lord? I'm mentioning upon notice. My lord, the 120 days, my lord, is for filing written statement is expiring day after tomorrow. My lord, the application is ready along with the district.
Your written statement is ready?
Ready, my lord. It has been
Affirmed.
But I was.
So affirm it.
Kindly grants us the leave to, my lord, file the application with.
When you receive the writ of summons?
17th of September 2000.
So 120 days is over.
It is expiring day after tomorrow, my lord, on 15th of.
So file tomorrow? Today?
Kindly
file it today.
Kindly grants us leave to file.
With regard to the application, I am not counting any leave. You can file application at any point of time. With regard to the written statement, if your written statement is ready with the affirmation, I am granting leave to file in the department subject to acceptance by the court. Give it.
With my lord's kind leave.
Leave is granted to file the written statement in the office in course of the day, subject to acceptance by this court.
With my lord's kind leave.
Not scrutiny.
May I be permitted to mention a matter? My lord, in CS 14 of 2024, my lord was pleased to pass an order dated 2nd January 2024. However, my lord, there are certain typographical errors. My lord, may this be listed under the head to be mentioned.
Commercial?
No, non-commercial.
Non-commercial matter.
My lord.
Wednesday to be correction.
Grateful, my lord.
My lord, may I leave to mention a commercial suit, my lord? This is assigned matter, my lord. And your lordship on last November 28, 2024, my lord, evidence is closed and has fixed for argument on 15th of this month, my lord. My lord, here, my lord, before that, your lordship had passed an order on December 13, 2022, my lord. There an application was pending, my lord, regarding the jurisdiction. Your lordship's
regarding jurisdiction of?
Jurisdiction, territorial jurisdiction.
Of this court?
Yes, my lord. And lordship passed an order on that application. That application is pending, my lord. May I hand up, my lord, this order? Para 2 of the page 2, my lord.
Yes.
So my humble submission is, my lord. My humble submission is this, my lord. Before argument, my lord, your lordship kindly take up.
Why? Kindly see, it is clear. Framing of issue, I will frame one additional issue and I will decide it along with the suit.
If I am not wrong, I am remind Malura sitting at court 41. Malura is very specific that Malura will take up this issue at the time of final.
Correct.
Final hearing is fixed for 15.
In the argument, you argue the matter. At that time, because you have to argue the matter with regard to the jurisdiction also. You argue the point. I will frame the additional issue, and if the at the time of filing, yes, if the final hearing of the suit, if the court find that it is not, this court is not having duty, automatically appropriate order will be passed. What is the necessity for filing? You could have been taken this application initial day when you before the starting of your trial. Even though now, as per the division bench, our division bench order, preliminary issue is to be decided during the trial only.
The application, in fact, was taken up before this.
You filed. That's why this court has passed an order. See, you have to argue why twice. I will decide all the issue together.
On 15, my lord, matter has been fixed, specifically fixed. So, my lord, I am in the process of written argument, making written argument, my lord. But, my lord, I will start on 15th, my lord. I may not conclude on that, my lord.
Okay, come on the 15th, we'll see to that. Come on that. I will take this issue along with all. No problem. I will. Yes. First is already there, then
There by Justice Saraf.
that
He
is
was not there, some other person.
no problem. Hmm.
This is that matter where Lordship will allow that amendment application. A point was taken by Mr. Somrat Singh that you have to serve a section 80 notice again.
Acha, acha, yes, yes.
He went up before the Supreme Court. On Friday, Supreme Court passed the judgment dismissing the SL. Now, what I was praying, Lordship, the matter has been the order passed by that court that liberty has been granted to mention upon that SLP being in. I will only request Lordship to fix it before the regular court has to be mentioned based on the Supreme Court.
One day matter, what is the Supreme Court?
Because Lordship's judgment.
That's why.
That is why I thought that
Initially, its stay was granted, no?
initially, not stay was not granted. The suit will proceed, but the
But
second
with regard to yes, amendment.
but thereafter, upon final hearing, the SLP was dismissed. Detailed judgment, dealing with all the points that have been raised by your Lordship.
Give a copy. You give the copy to me.
Yes, yes.
So what you want now?
Only listed as to be mentioned
For what? When?
more because to suit to proceed immediately upon
When?
because the
कब
suit
तक है
has-
मेरा determination? Justice Majumdar.
the regular court.
He will come tomorrow. It is only today, one day. If it is not, if it regular, then I will see.
Your Lordship, may I mention a matter?
Give the copy of the judgment. That's
May I please mention a matter? Your Lordship, in PLA number 116 of 2024, on 17 December 2024, your Lordship was pleased to grant a probate. In the order, there are certain typographical errors. It's written that 3 of the heirs had not given their consent, whereas only 2 of them had not given. I have marked the order copy with in pencil.
Hey,
If
is-
I may submit.
Wednesday to be mentioned for correction.
Grateful, your Lordship.
The interim order extending today, this matter was appearing before your Lordship, Gautam Majumdar.
Yes, 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 yes.
My lord, I am for the defendant.
Order.
Extension of interim. It is going to expire today.
Yes.
My lord, today it's expiring, my lord.
Give the last order.
But you would remember that this matter pertains to the Gold Star market.
My lord, the Parley and SAS Foods.
Hmm.
The interim order is still today. The matter was made to be returnable today.
Hmm.
But Mrs. Mujumdar is not sitting. The Lordship.
So it is an interlock. This IP matter.
IP matter.
IP
is pending,
matter.
yes. Because Justice Kapoor had released it. on
Acha,
personal.
acha. So what is the prayer? What is your submission?
Kindly extend the interim order.
Hmm.
It is expiring.
When is the last date? Last order?
My lord, it's 16th December, my lord.
16 December.
16 December. May I hand up?
On the prayer appearing for the application adjourned till 13 January. Interim order original cause it will continue till.
Please.
My lord, only one accommodation, my lord, I'll be praying for, my lord. We are supposed to file our affidavits, my lord. My affidavit is ready, my lord. The person who will be affirming my affidavit, my lord, was not available last week. Lordship will kindly extend 1 week. I'm praying for 1 week extension, my lord, so that I can complete the.
The matter is mentioned by the learned advocate appearing for the plaintiff and submits that the interim order granted originally on 11th of July 2024 is going to be expired today and prayed for extension of the interim order. Full stop. Learned counsel for the defendant prayed for time to file affidavit in opposition.
Affidavit in opposition to GA number
Prayed
2
for
and 4, my
extension
lord.
of time to file affidavit in opposition in connection with GA Com 2 of 2020
And 4, my lord.
2024.
My lord, GA 2 and GA 4, my lord.
GA 2.
Learned friend has filed a vacating application. That could be treated as an AO to my application. I can just file the reply to.
My lord, that they have not indicated on the last occasion.
My learned friend is consenting right now, then we can do that.
My lord, I need to take instruction. My lord.
What is the GA4? Also your
My lord,
application?
GA 4 is extension of time to file writ of summons, my lord.
My
Yeah,
learned
Buddha.
friend is opposing that.
J as well as J4 of JCOM 4 of 2024. Considering the submission made by the counsel for the defendant, time to file affidavit in opposition in both interrogatory application is extended for a further period of 1 week.
1 week.
1 week from date. Full stop. As interim order is going to be expired today, accordingly, interim order is extended till आज क्या date है? Till 24th of January 2025 or until further order, whichever is early.
But you would also grant liberty to the plaintiff file the AO to their vacating application in this case.
अच्छा, you are not filed. Full stop. Counsel for उससे पहले आएगा. The counsel for the plaintiff press for extension. Extension.
That
Extension.
direction was there, my lord.
Extension. You want extension.
Direction was
My
always
lord.
there to
My
file
lord.
affidavits.
My
but
lord.
granted
For
to
time, I'm prayed for
as an AO.
extension of time to file affidavit in
GA3.
opposition in connection with GA3. Let affidavit in opposition be filed within 1 week.
10 days, your lordship.
Within 10 days. So all 10 days karo.
10 days.
All 10 days. Reply, then reply will come. Reply will
Exactly.
be
That is why I was suggesting
reply if any will be in
AO.
reply if any there to be filed within a week thereafter. Full stop. The interim order granted early, so 10 weeks. And the interim order granted early is extended till 6th of February 2025 or until further order.
Great.
Lordship, the parties would be at liberty to mention before the original.
The
Automatically,
AIP.
it's an assignment.
It's a non-contentious probate matter. Certain assets are
LLO.
located outside the state lordship, so we have to take out an application and rejection to reach
Mm.
lordship. So,
So what do you want?
lordship, I'm praying for issuance of citation from this court. I mean, directly.
It is not listed.
It's not listed, your lordship. It needs to be listed a non-contentious court.
List matter.
My lord, I have a similar prayer, my lord. This is a probate matter of 2022, my lord. It is a non-contentious matter, my lord. The heirs have given their consent, my lord. Let it be listed, my lord.
Lord, may I have your lordship's leave to mention one commercial suit of 2021? I was praying for inclusion in your lordship's list, my lord. Deeply.
What is the stage?
My lord, no WS has been filed, my lord.
Okay.
Nothing has been filed. They have filed 2 applications, my lord. One under section 5 and 8 of the Arbitration Act and one for dismissal of the suit. Those are pending, my lord.
Yes. Next.
Lordship, this has come up at my instance
Mm.
for correction.
Yes.
My lord had passed a decree on it to Devan. Achha. My lord has passed a decree on December 3rd, 2024. Lordship kindly comes to the last page of the decree. It has been mentioned that in view of the above, this court finds the plaintiff has proved the case and is liable to get an amount of rupees 9,52,920. Lordship, however, the 18% interest was previously agreed upon, and while dictating, Lordship has dictated it accurately. But I have seen it over the live. But however, the typographical error has been made that it has been mentioned as 9,52,920. However, it ought to have been as per the first page, 3rd paragraph. The plaintiff has filed the suit for recovery of an amount of rupees 12,24,440.
That's why you have a plaint.
Yes, yes.
Give the plaint. Yes.
Prayer
Kindly, yes, kindly come to the paragraph 10. You are having a plaint, copy of the plaint.
Yes, I have.
Kindly come to the
Paragraph 10.
paragraph
Yes,
18.
Lordship, that is
Paragraph 18.
18.
Yes. Paragraph 18.
Yes.
Then come to page 7.
Page 7.
1. Total price amount 10 lakh. 10 crore 2 lakh 90
10
10 lakh 2,920.
Lordship.
Correct. thereafter paid up to the interest 27 September.
That interest
Then
is agreed upon.
That's why 9,52,920.
Yes.
Correct. So thereafter you have calculated this interest. I have not given this interest. I have given the interest of 9,52,000 from 28 September. So same thing.
Lordship, then if that in calculation of the interest is not mentioned,
Kindly see, in view of the above, this court find that the plaintiff has proved the case and is actually entitled to get the amount of rupees 9,52,920 as on itna, and the plaintiff is also entitled to get the interest per annum.
Interest, but your lordship had also dictated it 12 lakhs 24,440.
12 lakhs is your total amount. So along with the interest, you have calculated the interest up till.
Yes.
You have calculated the interest up till 10th of January 2024.
10th of January.
I have not calculated that. I have passed an order. This court has passed an order. You are entitled 9 lakh along with the interest from the day 28 September 2020 till realization.
Lordship had actually granted that. I had
mentioning. Yes. Next call.
Lordship, the only reason I have said
The
that
matter is listed as to be mentioned for correction, but after going to the
Lordship, the
judgment
only reason
passed by this court dated
kindly hears me out
that
once.
3rd October, 3rd December 2024, this court did not find any reason, and this
Lordship,
court
if
did
that
not
is
find
not
any.
mentioned, the pecuniary jurisdiction will get hurt. That is the reason
What
I have.
pecuniary jurisdiction?
Because this honorable court has a pecuniary jurisdiction of 10 lakhs. My agreed interest was 12 lakhs 24,444. That is the reason I was able to file the suit. Now, if
you faced your consequence, sir, you have made very intelligently drafted. I caught that. I don't want your suit should be dismissed. That's why you have passed this order.
Lordship, but the
very cunningly you have drafted. That's why I'm not interested and not tell to open my mouth here by sitting here. क्या बोला? Reason only in paragraph 4, in page 4, paragraph 4, 1, 2, 3. Line number 2, the word libel is to be read as entitled. This order may be incorporated.
Number 5. Great.
I am opposing this application on behalf of my lord, the defendants.
Yes. Affidavit completed?
No, my lord, lordship may.
Think they will file any affidavit.
Lordship may deal with the my lord application without the affidavit. My lord, they are praying my lord to disclose additional documents. There are some documents, my lord, which were my lord available with them, my lord, because they had filed a prior suit in the city civil court.
What is the application?
This is an application, my lord, only to leave to disclose and rely upon some additional document. But the additional document in the sense, my lord, which are my learned friend's document, because I am complaining of breach of the covenants of the lease. I am showing from this document that he has executed deeds with third parties and have brought them in the property. So these are all his documents, registered documents, my lord. He has nothing to, and this has come, my lord.
Why you not filed the
I'll show, my lord. Actually, there has been a change of management of the company and change of advocate. There was a previous suit before the learned city civil court at Calcutta. The erstwhile advocate who was dealing with it, he had all probably the original documents. And now after the change of management, because there was an urgency in filing the suit and we had taken leave also, my lord, we could not wait for that time to get those. I have explained, my lord, in my petition also, my lord. And at the first available opportunity, even before any written statement has been filed, just before even service of the summons, we have come up with this application, my lord, just to disclose his original documents. Paragraph 9, your lordship will 7 and 9. Here, my lord, I had tried to explain, my lord.
Yes, Mr. Doctor.
My lord, kindly sees the plaint which they have filed. My lord, the plaint is, my lord, an annexure to this application. It starts at page, my lord, 14. Kindly comes to, my lord, at page 26.
Yes.
My lord, 26, last para, 9.
Yes.
They had alleged, my lord, initially that there was a default in payment of rent. My lord, kindly turns the page, comes to page 27. My lord, after that, my lord, in para 10, they refer to a proceeding instituted in 1998, same plaintiff. My lord, in respect of the same property, pursuant to, my lord, the same lease document. So, my lord, this explanation which has been given, that, my lord, the lease deeds were, my lord, at the time of institution of the suit not available, possibly is not
No,
correct.
that is a subsequent lease deed which the defendant has executed to induct sublessees. I am talking about those lease deeds now. I am bringing on record because this is the evidence of breach of covenant. And paragraph 7,
What is the date of the lease deed?
84. My lord, documents, if
No.
your lordship sees from page 5.
No, what they are relying upon?
Kindly come to paragraph 9. I have given the documents which I have read. Kindly see lease deed in favor of such and such, which my learned friend has executed. Then all these B to F, these are the persons whom he has inducted in the property on the basis of these deeds. Now in the suit, it will be examined whether this amounts to breach
Now,
of
with
the
regard to the paragraph 10, the suit, title suit number 1076 of 1998.
That is with regard to my parent lease, which I had granted in favor of the defendant.
In that suit, this documents were not disclosed.
No.
No, my lord, I am
That
not on
was on a
that.
different
My
ground
lord,
altogether.
kindly takes the plaint. My lord, I was showing your lordship the city civil court suit, which was, Mr. Sen is correct, which was instituted on the basis of the deed executed by this plaintiff in favor of my client in respect of that premises. Now, subsequently, that lease deed contained a covenant giving me a right to, my lord, erect by demolition of building and also transfer without taking any consent. Now, possibly, my lord, these documents which he now tries to introduce are those documents. My lord, twofold objections. One is documents are of 84, 85, lordship sees the dates. So, my lord, these were, my lord, if they wanted to, they could have obtained certified copies and they could have relied upon them in the plaint at the time of institution of the suit. My second point is, my lord, lordship will not find reference of these documents in the plaint. There has to be a foundation in the plaint with regard to, my lord, these documents, because you are trying to introduce these documents in support of your plaint case. Now, my lord, kindly, if your lordship permits me to, my lord, read the plaint, my lord, 2-3 paragraphs.
I'll just indicate paragraph 16(1).
I'll come to that. I'll come to that, my lord. I was on para 10, my lord. Kindly turns the page, my lord. He refers to, my lord, the city civil court decree of dismissal, then the appeal, and what transpired before the division bench up to para 15 at page 29. Then para 16, my lord, the only averment is, besides aforesaid, defendants have committed further breach and acted in violation of the terms and conditions in the lease deed inter alia as follows. Defendants had purported to sell various spaces in the building constructed at the suit property contrary to and or in violation of the covenants of the lease. Being lessee, the defendants being lessees could not have transferred or conveyed ownership right in Schedule A property which the defendant itself did not have. Now, my lord, no reference of any of the documents of transfer, my lord, which, my lord, if they would have exercised, my lord, exercised due diligence, and, my lord, they could have obtained this. Now, why do they, my lord, suddenly, my lord, come up with this application with reference to all these documents which have been now referred in para 9 of this application? Kindly sees the explanation. Kindly comes to, my lord, page 5 of the application. This, my lord, explanation is not matching. Kindly sees para 9 at page 5.
Yes.
It was only after filing of the instant suit that the representatives of the plaintiff could reach out to the advocate who was appointed by the erstwhile management to conduct the suit, being TS1. So, my lord, this is that suit in the city civil court. It is stated that plaintiff thereafter from the advocate obtained copies of the deeds in connection with the suit. Now, my lord, I pause here for a moment. If these were documents which were there, my lord, before the city civil court in respect of that suit, and you are obtaining, my lord, your explanation is I obtained it from the advocate. Then what prevented you from obtaining it, my lord? The decree was passed, my lord, by the city civil court, my lord, 10-15 years back. If you wanted to institute the suit, you could have, my lord, got these copies from the advocate. This is only, my lord, an explanation offered to, my lord, come out of the rigors of Order 11, Rule 5.
Yes.
So, my lord, the explanation in the application and the averment in the plaint is not matching.
Okay.
So, my lord, I have not filed affidavit, but I was trying to, my lord, persuade your lordship not to allow this application, my lord, for disclosing, my lord, all these additional documents. And if, my lord, without prejudice to this argument, if lordship is still, my lord, willing to, my lord, allow, well, the conditions are, my lord, that there has to be, my lord, reasonable explanation plus costs. So I leave it to my lord thereafter, my lord. But my first submission is it should not be allowed.
Yes.
But first is word, I have come to your lordship at the first available opportunity, even
No,
before.
that's correct, Mr.
No, but
Chair.
then kindly come to the explanation, my lord.
Hmm.
What, my lord? The first suit was filed on the condition of breach of covenant of non-payment.
Correct.
There was no condition of regarding the
Transfer.
dealing with the property.
Correct.
That thereafter, my lord, after the division bench conferred that I am the absolute owner, because the earlier proceedings got dismissed because the city civil court held I am not the owner. That now ownership was vested upon me. Then the cause of action for the second suit arose when it came to my knowledge that third parties are in possession. Now I have no occasion to find out how they came into possession because I was not the management when the earlier city civil court suit was filed. Kindly come to paragraph 4 once of page 4 of the application.
Yes.
Present management of the plaintiff came in control of the company in the year 2017. At the time the present management came in control of the company, the suit such and such pending before the city civil court at Calcutta. However, in terms of the understanding with the earlier, they would take care of the then pending proceeding. Present management did not take part involved in the proceedings of 1998, which was dismissed on 5th July 2019. It was only after the said suit was dismissed that the present management took control of the litigation, proceeded to prefer an appeal. In the course of the appeal and in the pleadings filed therein, it was contended on behalf of the plaintiffs that the defendant illegally executed conveyance in violation of the lease deed. Such statement was made in view of the fact that the present management who were in control of the company at the relevant point of time came to know of existence of various deeds by which defendants had transferred various portions to third party, but no deed was in their custody at the relevant time. That is when the appeal was going on. Representatives of the erstwhile management were time and again requested to hand over such documents evidencing execution of deed of conveyance, but the same were not made over to the plaintiffs. Plaintiffs were also unable to obtain such document, certified copy, because details of the transaction was not available with me. Prior to filing of the instant suit, plaintiffs made several attempts to contact the Jalans who were in charge of erstwhile management, who could not persuade them to hand over the documents. It was only after filing of the instant suit that the representative plaintiff could reach out to the advocate who was appointed by the erstwhile management to conduct the suit, being TS number such and such. Plaintiff thereafter from the said advocate obtained copies of the deeds in connection with the suit property, which had been executed by the defendant number 1 from time to time. Plaintiff prayed for decree. Plaintiff intends to rely upon a certificate issued by the chartered certifying that such time plaintiff in addition disclose the deeds executed in favor of the third parties as also the chartered accountant certificate. Yes. Now what my learned friend is saying, if your lordship comes to the plaint, that there is no foundation in the plaint for this, this probably cannot be correct because in the plaint I am not required to plead evidence. Plaint I am only to state the foundational fact.
Yes.
Paragraph 16, Roman 1. This is the foundational fact. That the breach has been committed by the lessee. How? They have purported to sell the spaces in the suit property.
Yes.
In violation, could not have transferred or conveyed ownership right. That is my case.
Okay.
You can sublet, sublease, but no ownership right. And these documents were with the advocate. I did not get it from the erstwhile management. Okay. And now I have got it immediately after filing of. Kindly have a look at the date when the suit has been filed and when this application has been moved. And that also I've said in paragraph 11 that the plaint filed contains necessary pleadings in support of the transactions evidenced by the sale deeds.
Yes. Hey, Manu, to show the consumer commercial court type.
But before service of the summons also I have filed this. Okay. At the stage of scrutiny when after admission of the plaint when it was going on.
কোন ডেটটা চাইছো ভাই?
Filing it. Plaint was admitted on 10th of July by the learned master. And kindly see when the master summons have been taken out.
10 July 24.
10th July 24. Well, I'll show you, Lordship, from the affidavit verifying the petition. And it is on 11th September 2024. The application has been taken.
18 September. Yes. That's all.
Yes, my lord. So I'm saying, my lord, at the first available opportunity, my lord, I have come to the court, my lord. And it is all their document. They will not suffer any prejudice, not a third party document.
So and so appearing for the plaintiff. So and so appearing for the defendant. The plaintiff has filed the present application being GA Com 2 of 2024, praying for allowing the plaintiff, praying for leave to the plaintiff to disclose and rely upon additional documents as mentioned in paragraph 6, prayer, paragraph 9.
Prayers of the plaint.
Prayer of this application. Additional document I mentioned in paragraph 6
9.
or
It should be-
paragraph
it should be-
mentioned in paragraph 9 of the present application. Full stop. Counsel for the plaintiff submit that initially the plaintiff had initiated a case before the London Court of City Civil Court, being title suit number title suit number 1076 of 1998 against the defendant number 1, but the London trial court has dismissed the suit filed by the plaintiff. Accordingly, the plaintiff has filed an appeal against the judgment and decree passed by the London City Civil Court. And in the decree, in the appeal, it was held that the plaintiff is the owner of the property in question. And subsequently, the plaintiff and thus a new cause of action arose after the order passed by the appellate court, and accordingly, the plaintiff has filed the present suit against the defendants for recovery of possession and main profit. Counsel for the plaintiff submit that. Counsel for the plaintiff submit that at the time of filing of the suit, the document as mentioned in paragraph 6 within bracket small a to small g, small k, were not in possession of the plaintiff, and as such, the plaintiff could not file the said document at the time of filing of the suit. Counsel for the plaintiff submit that the representative of the erstwhile management were time and again requested to hand, and the counsel for the plaintiff submit that the plaintiff has requested the erstwhile management to hand over all the documents evidencing the execution of the deed of conveyance by the defendants, but the same was not made over to the plaintiff. Full stop. After filing of the suit, the representative of the plaintiff has approached the erstwhile advocate who has filed the suit before the London City Civil Court, and from the said London advocate, the plaintiff could get managed to get the said document, and accordingly, the plaintiff has filed the present application. Also, counsel for the plaintiff further submit that the suit was admitted on 10th of July 2024 by the London Master of this court, and immediately when the plaintiff got the document from the erstwhile advocate, has filed the present application on 18th of September 2024 without any delay. Full stop. He submit that the document which the plaintiff intends to bring on record and rely at the time of hearing of the suit is very much necessary for adjudication of the present suit. Full stop. Counsel for the defendant raised objection. And
No affidavit has been filed, no affidavit that your lordship will look at, because it will now be, therefore there is no denial of this factual aspect.
Counsel for the plaintiff further submit that the defendants are also not filed any affidavit in opposition in spite of opportunity granted by this court, and thus it presumed that the defendants have admitted the contents made by the plaintiff in the application. Full stop. Per contra, learned counsel appearing for the defendant raised objection and submitted that the contention made by the plaintiff is not correct. He submits that initially the plaintiff had filed the suit against the present defendant before the city civil court for eviction, and the plaintiff had the knowledge with regard to the said document, but the plaintiff has not disclosed the said document. Counsel for the plaintiff further submits that in paragraph 9 of the present application, the plaintiff has stated that the document has been obtained by the plaintiff from the erstwhile advocate who has filed the who has defended the erstwhile management of the plaintiff, which shows that the documents were in the hand of the plaintiff, and as such it cannot be said that only after filing of the suit, the plaintiff has got the said document. Counsel for the defendant further submits that in the pleading of the plaint, the plaintiff has nowhere mentioned about the contents about any fact with regard to the said document, and as such only by bringing the said document on record, the plaintiff intend to bring a new case. Full stop. Heard the learned counsel for the plaintiff use the materials on record. Full stop. The plaintiff has filed the present application with praying for leave to disclose the following documents. Paragraph page 5, paragraph 9A to page 5 to page 7. 7 of the present application. Italic small pen. The only point which the defendant has raised in the present application, you do one thing. Come. The point raised by the defendant by opposing the present application is that the plaintiff had the knowledge with regard to this said document, which the plaintiff now intend to bring on record. Full stop. The defendant has relied upon the earlier suit filed by the plaintiff against the present defendant and submitted that the said suit was filed in the year 1998, and the document which the plaintiff intend to bring on record are of 1985 onwards, and thus it cannot be said that the plaintiff had no knowledge with regard to the said document. The defendant has also pointed out with regard to paragraph 9, wherein the plaintiff has taken the stand that the plaintiff has obtained the document from the advocate of the erstwhile management of the plaintiff company, who has proceeded with the suit of the earlier suit. Full stop. This court find that the plaintiff in paragraph 7 has categorically mentioned that the initially the erstwhile management was taking care of the plaintiff company. Subsequently, now the plaintiff has taken over the plaintiff company, and the plaintiff company has requested the erstwhile management of the company for handing over the document, but that said document was not handed over. But the documents were not handed over. After filing of the suit, the plaintiff has managed to got the said document from the erstwhile advocate who had represented the erstwhile management of the company. Who has represented the erstwhile management of the company. Full stop. It is a specific case of the plaintiff that this said document has been obtained by the plaintiff after filing of the suit. This court also find that the suit was filed in the month of July 2024 and this application is filed in the month of September 2024. Counsel for the plaintiff further submit that the September 2024. Full stop. The counsel for the plaintiff further submit that the plaintiff has filed the present application before issuance of the writ of summons. And as such, if this court allow the application, the plaintiff will not suffer any irreparable loss and injury, as the plaintiff will get an opportunity to deal with the document which now the plaintiff intend to rely upon. Considering the above, this court finds that it is a specific case of the plaintiff that the document which the plaintiff intend to bring on record was not with the hand of the plaintiff, and the plaintiff has got the said document only after filing of the present application. And taking into consideration of the said statement, which was not denied by the defendant in filing any affidavit in opposition, in spite of giving an opportunity to the defendant to file affidavit. In spite of giving an opportunity to file affidavit. Considering the above, the plaintiff is allowed to disclose the document as mentioned in paragraph 9 within bracket A2K by A2K full stop. GA comes so is disclosed.
My lord, some costs, my lord. That is, my lord, the statute provides.
No, what, where?
My lord, kindly seize, my lord.
For some delay that can be.
My lord, kindly seize, my lord.
Yes, show me. Show me which portion.
If the court has come to a conclusion that there is no default and the ground is a sufficient cause, then
Which
that
portion?
discussion
That's
cannot.
why you have asked for the cause. That's why I have asked for the act. It is not the written state.
In the next matter, Mr. Doctor, not this matter. Obligable.
Disposed of. आज क्या तारीख है? 10 तारीख आ जाता है. Yes.
I am the plaintiff petitioner in this matter.
Yes.
But there is another application which has been taken out by my learned friend for rejection of plaint. So perhaps that my learned friend would want to press before I press my injunction.
What is the application? Where GA number
The
3?
application was being heard, if your lordship recalls. This would be GA. Should be GA2. GA2.
Commercial Court Act.
Yes, ma'am. Our application, my lord, and our contention is confined to the fact that this is not a commercial dispute within the meaning of section 21C, and as such, my lord,
attracting the commercial jurisdiction of this honorable court does not arise. So the suit must fail on that ground. Now, if your lordship will kindly take the plaint which is a part of my application.
It is GA2 or J3 is, I
GA
think.
2, subject to correction, it should be GA2.
No, GA1, J2 is the injunction.
GA3, then they are GA3, my lord.
GA3.
Stand.
No affidavit filed.
It's not
Filed.
Not necessary.
point of law, man. It's fine.
On the other day, they had specifically said that they don't wish to use an affidavit. Now, my lord, if your lordship will kindly take, my lord, I'll give your lordship the basic background on the basis of which the suit has been filed. Thereafter, I'll take your lordship to some of the relevant averments made in the plaint. My lord, the defendant is a bank. My lord, there was a credit facility that was advanced by the defendant bank, my lord, to the plaintiff number 1.
Yes.
There was a default in repayment of loan. So the account was classified as a non-performing asset. Thereafter, my lord, proceedings were initiated by the bank. My lord, at this stage, my lord, an offer for settlement was made by the plaintiff, borrower, principal borrower. Now, this gave rise to a offer which was accepted by the bank, and a one-time settlement offer was given. Based on the one-time settlement offer, they were required to pay the agreed settled amount in the manner specified in the one-time settlement, the default. So the one-time settlement, the terms of the one-time settlement, my lord, thereafter we proceed, and thereafter, my lord, we sell the secured asset. My lord, thereafter, based on the one-time settlement, there was a compromise decree before the debt recovery tribunal where the proceeding was pending. One-time settlement decree. So now once they defaulted, my lord, we wanted to rectification of the decree so that we can execute so far as the rest is concerned. That is one aspect. Now, what is under challenge? Well, this is the basic background on the basis of which, my lord, that is the other proceeding. Now, what the relief that they seek in the present suit and the averments made in the plaint, if your lordship will kindly take once, well, your lordship will find the plaint we've annexed to the application. There are 2 paginations. Lordship will kindly take the pagination which is in the middle, not the bold on the right. So the plaint starts from page 9. Yes, my lord. Lordship kindly comes to, I'll just take your lordship to some of the relevant pages. My lord, kindly take paragraph 2. Plaintiff number 1 had availed of credit facilities. Your lordship found that at page 11.
Yes.
Running page 11 of the application.
Yes.
This will give your lordship the chronology of the events, from which I'll show your lordship what is the cause of action in the suit and what is the relief claim. My lord, availed credit facilities. Then your lordship can to para 3. Plaintiff number 2 and 3 had given personal guarantees. Then, my lord, 4, facts and circumstances more fully particularly stated. Defendant bank initiated proceedings for recovery of dues being owed under section 19 of the Debt Recovery Tribunal Act, praying for such and such. Then para 5, during pendency of OA filed by the defendant bank, plaintiff had approached the defendant bank for settlement.
Yes.
Para 5.
Yes.
The offer of settlement was duly accepted by the bank, and the defendant bank sanctioned OTS in respect of the accounts of the plaintiff number 1, vide letter of 15th September 2018. My lord, kindly make a note of this date and the letter. My lord, this 15th September letter is annexed here to and marked as annexed here. So it forms a part of the plaint.
Yes.
By such and such, the plaintiff acknowledged and accepted the terms and conditions of the OTS. Then, my lord, in terms of the OTS sanction, the plaintiff, para 6, was required to pay a sum of 12 crores in 4 installments. Then such and such, in lieu of the outstanding of 23 crores. On a joint compromise petition, para 7, my lord, filed by the plaintiff and the defendant bank, a compromise decree was passed by the debt recovery tribunal on such and such, directing issuance of recovery certificate in favor of the defendant bank for a sum of 12 crores. Then, terms of the OTS had several payments. My lord, kindly take para 8 once. In terms of the OTS, the plaintiff had several payments, made several payments aggregating to a sum of rupees 4 crores.
Out of 12.
Out of 12. Then, furthermore, in terms of the compromise para 9, passed by the debt recovery tribunal, recovery certificate was issued. Then, my lord, para 10, it is relevant to mention here that the credit facility availed by the bank from the was inter alia secured by mortgage of properties belonging to the plaintiff number 1. Property details are given. Para 11. Defendant bank had obtained a valuation report in respect of the mortgage property measuring 299 decimals, such and such, in respect of such and such. Then, my lord, from a perusal of the valuation report, it will appear that on 8th January 2018, the mortgage land was valued at such and such. Then, my lord, para 13, my lord, your lordship will see there's a unconnected pleadings. Then, my lord, OTS, if the OTS has happened because 4 crores, so there's a default in the OTS, that's not mentioned there. My lord, kindly take para 13 now, because the question of sale of the secured asset will arise only if there is a default. Para 13, Onkar such and such, vide letter dated such and such 2019, addressed to the plaintiff number 1, had expressed interest in purchasing the said mortgage land measuring 299 together with the building shed structure situated for a sum of 6 crore 25. So this is a third party is writing a letter to them offering to purchase the secured asset at a sum of 625. This is their case. Then para 14, plaintiff number 1 had also mortgaged the following properties to secure the credit facilities. Then, my lord, kindly take para 15. Onkar, which is the third party, had also issued a letter of such and such, expressing his interest to purchase the mortgage properties of 9 such and such for a sum of 7.5 crores. This is the other property which they just mentioned in the previous paragraph.
This paragraph 15 property and paragraph 13 property are different.
Different. And the two offers made by the third party.
Okay.
One for 4.5 crores and para 14 property.
6.25 and 7 crores.
My lord. And then, my lord, para 16. In the aforesaid circumstances, the plaintiffs wrote to the defendant bank on 1st April requesting for permission to sell the mortgage land measuring such and such and such and such. So both the properties respectively, and for the proceeds from such sale to be directly credited to the OTS account of the plaintiff and or permission for assignment of the mortgage property to Phoenix ARC towards the OTS account. It is pertinent to mention herein that the defendant bank never responded to the letter deliberately and with an ulterior motive to play fraud upon the plaintiff. So, well, what they say in para 16, in my limited understanding, is that.
So, you are not allowed.
No, naturally not. Now, well, 4 crores paid under the settlement. For the balance sum, they said that these are 2 secured assets. I have got a buyer. Give me permission to sell these 2 secured assets. From the proceeds, I will pay you.
Correct.
This is one aspect, and they also seek permission to assign the debt. So, my debt, they are seeking permission to assign, well, which is contrary to Section 5 of the Securitization Act. Be that as it may, I am not going into the merits. Well, kindly take paragraph 17. The defendant bank was well and fully aware that the value of the 2 mortgage properties was in excess of the OTS value claimed from the plaintiffs. Had the defendant bank acceded to the request made by the plaintiff by its letter, Lordship will see the sentence starts with, had the defendant bank acceded. So that means we did not accede.
Correct.
Request of the plaintiff bank by his letter seeking permission to sell the mortgage property and to appropriate the proceeds therefrom and or permission for assignment of the mortgage property to Phoenix towards the OTS amount of the plaintiff, the entire dues payable to the defendant bank as per the sanction OTS rule could be liquidated immediately. Despite receipt of the plaintiff's letter of 1st April, the defendant bank, however, failed to either respond to or comply with the same. So that permissions, the letter to seek permission to sell the mortgage property by the mortgagor and the permission to assign the debt, since I am not responding, so that is what they are saying, para 18. Thereafter, they proceed, my lord. Second sentence is para 18. The failure of the defendant bank to consider the request made by the plaintiff by its letter dated such and such for the permission to sell the two mortgage properties and to credit the proceeds from such sale for assignment of the mortgage property to Phoenix resulted in the failure of the plaintiffs to honor their repayment obligation under the sanctioned OTS, and the compromise decree dated 1st March 2019 leading to the OTS scheme being cancelled and withdrawn by the defendant bank by the letter of 22nd July 2020.
So you are liable. You are liable.
As if. Yes, but now that is also not their case. Now kindly see what. It is thus abundantly clear that the defendant bank refused to consider and accede to the request made by the plaintiff by the letter of 1st April for permission to sell the mortgage property. They continue. This is a repetition. Then, let kindly come to para 20. After making payment of 4.10 crore in terms of the OTS, there was a delay by the plaintiff in making the payment towards the installment of OTS. And the defendant bank proceeded to issue the letter of July 2020 purporting to cancel the OTS and calling upon the plaintiffs to pay the balance outstanding dues under the OTS scheme, which naturally could not have been any other step that the bank could have taken at that stage. Despite having obtained recovery certificate for 12 crores, which was the entire amount sanctioned under the OTS, the defendant bank further filed an interim application in such and such to seeking to obtain recovery certificate of 51 crores. Why? Because there was a default in the OTS. So the OTS ceases to exist. So my original claim revives. Upon purporting to cancel and withdraw the OTS para 22, the defendant bank filed an interim application before the Debt Recovery Tribunal for 51. Then, my lord, kindly come to para 23. Such application filed by the defendant bank for modification of the recovery certificate was rejected by the order of such and such. Thereafter, my lord, kindly come to para 24. The defendant bank has preferred an appeal. Para 24. This would be running page 23, yes. Last sentence. Being appeal number such and such before the Debt Recovery Tribunal, Debt Recovery Appellate Tribunal from the order of such and such, for setting aside and cancelling the order of July 2022 inter alia seeking. So then, my lord, kindly take after the quoted portion, my lord, this would be running page 25. The appeal such and such preferred by the bank is presently pending consideration before the Debt Recovery Appellate Tribunal. Then para 25. It is stated that the defendant bank finally proceeded to sell the mortgage properties measuring 299 decimals for a sum of such and such. A copy of the sale certificate issued with regard to the defendant is annexed hereto and marked as such and such. From the aforesaid, it is evident that the bank had purportedly sold the mortgage property measuring 299 decimal at a gross undervalue. Just, Lordship, will kindly give me a moment. Now, my lord, kindly see. So this sale which had happened, if your lordship see para 25, this sale was conducted by the bank in exercise of their power under the Securitization Act. After issuing notice under 13(4) sale notice. Yes. So this sale, which they now say undervalued, could have been at best challenged in a statutory appeal under Section 17 of the SURFACE Act, which they did. And subsequently they withdrawn. They withdrew that challenge. Thereafter, the defendant bank proceeded to sell the mortgage property of 977, which is the other property. For a sum of rupees 5 crore, the plaintiff are in the process of obtaining a copy of the sales certificate issued by the defendant bank in respect of the mortgage property and have filed a right to information RTI application seeking a copy of the sales certificate, a copy of the RTI application filed by the plaintiff such and such, measuring such and such, as informed the plaintiff. Then, my lord, kindly take para 27, mortgage property measuring 977, situated at 10 kilometers in the vicinity of such and such. These are pleadings to allege undervalue. Then, my lord, as stated herein above, plaintiff had paid 4.10 crore to the defendant. This is under the settlement. Para 28, thereafter the sale of the mortgage property, the defendant bank has recovered a total of such and such. Accordingly, the recovery certificate obtained by the bank against the plaintiff stands satisfied and the plaintiffs are entitled to a no due certificate. Because they say 4 crore paid, then subsequently by sale of the two properties, I have realized 7.94 crore plus so 12. The OTS amount is over. So I am, according to them, not entitled to claim anything beyond OTS. My lord, kindly take this. So my original claim, according to them, disappears. So I have to restrict myself to OTS, though there is a default by them in the OTS, which is an admitted pleading in the averment in the plaint. My lord, kindly take para 29 once. Notwithstanding the fact that the recovery certificate issued in favor of the bank has been satisfied, the bank is wrongly and unlawfully withholding the no due certificate from the plaintiff and is continuing to make wrongful. Then the defendant has wrong and unlawfully issued notices of 2024 to the plaintiff number 2 and 3 purportedly under Rule 7(1) of the Insolvency and Bankruptcy Code, claiming a total amount of 81 crores. Well, basically what they're trying to say that, my lord, this is a notice under section form B. My lord, before initiation proceeding under section 95 of the Insolvency and Bankruptcy Code and against the principal guarantors. Your lordship is aware, my lord, there's a statutory form B which is required to be issued prior to initiation of proceedings under section 95 against the personal guarantors. So this is the notice that they are referring to. Though it's not very clear from reading para 30. But kindly take para 31. It is reiterated that as far back as on 4th of February 2019, the plaintiff had interested buyers for the mortgage properties and had accordingly requested the defendant in 2019 for permission to sell and assignment of the debt to Phoenix ARC. Then, my lord, para 32, deliberate and malafide intent of procuring breach of sanctioned OTS and the compromise decree by the plaintiff, the defendant bank refused to consider or acquiesce to the plaintiff's request to sell the mortgage property. Then, my lord, para 33, malafide wrongful unlawful act and its attempt to extort wrongful and unlawful gains to the expense. Then, my lord, by procuring the breach of the sanctioned OTS para 34 and the compromise decree of 2019 in the aforesaid manner, the defendant bank has proceeded to seek amendment to the recovery certificate, which we have already indicated in the previous paragraphs. Thereafter, your lordship will kindly come to para 37. It is stated that such wrongful and unlawful refusal by the defendant bank to grant the plaintiff's permission to sell the mortgage property and assign such and such, when the plaintiffs had ready and willing buyers at hand, was motivated by the fraudulent mechanism of the defendant bank to procure breach of the OTS sanction in favor of the plaintiffs and the compromise decree with the malafide intent to extort wrongful and unlawful gains. Then, Such wrongful, unlawful, fraudulent act of the defendant procuring a breach of the OTS sanction in favor of the plaintiff and the compromise decree, refusing to consider or grant the permission to the mortgage property as far back as in April 2019, has caused loss and damage. Lordship has found that, my lord?
Yes.
Caused loss and damage to the plaintiff, which the plaintiff reasonably estimates at 655. The plaintiffs are accordingly entitled to a decree for a sum of 87 crores, a schedule providing the particulars of the plaintiff's claim for damages. The plaintiff are further entitled to post-decretal interest on damages. A dispute complained of in the instance suit arises out of, well, kindly make a note of para 41. The dispute complained of in the instance suit arising out of wrongful, unlawful, fraudulent refusal of the defendant bank to grant the plaintiff number 1 permission to sell the secured asset and to credit the sale proceeds and the permission of the assignment of the mortgage properties to Phoenix ARC towards its OTS account, thereby procuring the breach of the OTS proposal sanction in favor of the plaintiffs and the compromise decree constitutes a commercial dispute. Is the lordship found that, my lord?
Yes, meaning.
Then, my lord, on the same breath, they say two things. If I may just place this paragraph, because this is the paragraph which, according to them, this is how they attract the commercial jurisdiction of the court. Para 41, my lord.
Yes.
My lord, may I place para 41 once again, my lord? The dispute complained of in the instance suit arising out of the wrongful, unlawful, and fraudulent refusal of the defendant bank to grant the plaintiff number 1 permission to sell the secured assets and to credit the sale proceeds and the permission. This is the sale proceeds is one part. So they say that this is a wrongful and fraudulent act, that I have not given them permission to sell the secured assets. Then the second part, they say, and or permission for assignment of the mortgage properties to Phoenix ARC.
Yes.
This is the second part, second cause of action.
Assignment.
That I did not give them permission to assign.
Correct.
They will assign the debt. My debt, they will assign. Very good. Towards its OTS account. So again, back to OTS. So everything is OTS. That 12 crore OTS.
Correct.
Thereby procuring the breach of the OTS proposal sanction in favor of the plaintiffs and the compromise decree of 1st March 2019, constitutes a commercial dispute within the meaning of the Commercial Courts Act. The plaintiff claims in this suit in excess of rupees 10 lakh and therefore the relief claim. Now, my lord, the point is, my lord, now if your lordship will kindly come to the reliefs that they claim in the suit, running page 34.
87 lakh.
87 lakh, which your lordship has just seen.
87 lakh 50. Huh?
Yes, my lord, that this para 39 and 40.
No, but prayer it 87 crore 59 lakh.
Yes, 87 crores, 87 crores. Para 39 is also 87 crores, which according to them is the damage that they suffer for breach of OTS.
Yes. Because you are not allowed to sell them, that's why.
Yes.
So this is the simple case.
This is the simple case. Now the question is that whether this constitutes a commercial dispute or not. Now, my lord, kindly take the act once.
Yes.
My lord, if at all, if they come, they will come under, my lord, 2C, 21CI, if at all.
Ordinary transaction of merchant, banker, financial.
So commercial dispute means a dispute arising out of. My lord, lordship will kindly make, your lordship has seen this possibly 1,000 times by now. My lord, kindly bear with me, my lord. Allow me to, my lord, place the definition in context with the present suit. Well, kindly read this with commercial dispute means a dispute arising out of one ordinary transaction of merchants, bankers. So it should be ordinary transaction of bankers. Here we are talking about a bank, finances such and such as those relating to mercantile documents, including enforcement and interpretation of such documents. So, my lord, in order to qualify as a commercial dispute within the meaning of 21C, well, it has to be an ordinary transaction of a banker relating to a mercantile document, including enforcement and interpretation of such document. So, well, the OTS, well, what is his cause of action is that there has been, according to him, a breach of the OTS by the bank, for which he has suffered damages. How in my respectful submission?
Whether it is a commercial.
Okay. No, so how would that constitute a commercial dispute or a commercial transaction? A OTS offer and you seek, what do you seek? You seek damages based on that breach. So it's an action of breach. So at best, if the court comes to a conclusion that there are certain terms and conditions in the OTS and there has been a breach, so they would be entitled to a claim for damages. Now, this is not arising out of the loan transaction or the credit facility or the terms and conditions of the credit facility advanced by me. He doesn't talk about a breach of that. So that would have been an ordinary, if your lordship will see the definition, that would be ordinary transaction by banker. My regular credit facility, terms and condition that I have committed breach. Hypothetically, my lord, I had under the terms I had agreed, or I was under an obligation to disburse to them by 100 crores by way of cash credit or fund-based, non-fund-based. I did not. I gave them I gave them less than what I had promised under the sanction letter. Disbursement was less than sanction. Possible that they have suffered a breach. So that would be terms and conditions of a ordinary course of transaction. Now, the entire complaint in the suit, your lordship will see, is based on a OTS. Now, my lord, if your lordship will see here.
That's why their contention is that in the OTS there is a transaction, then you are not allowed to sell the property, due to which they cannot deposit the amount in terms of the OTS. So OTS is the main document which can be treated as a mercantile document. Might be.
Yes. Because if your lordship will see para 41, though they do not say it in so many words, but effectively, if your lordship, in order to, my lord, attract the jurisdiction of the court, 41. Now 41 says OTS. That now I cannot take your lordship to the merits of the OTS, because I have to proceed on the basis that the averments made in the plaint is true and correct. So we have to look at the way it appears at para 41. Now there is the OTS. They say there is a breach of OTS. They sought permission. Now permission is not in terms of the OTS.
No.
If your lordship will see.
That's why now what is the time period he has to pay the amount?
All elapsed. Long past. They admit default. 12 crores, they paid 4 crores. So they admit default, but they say.
So they requested for selling of the property.
Secured properties.
That's why secured property, that is after the time period is over.
Absolutely. So before the time period was over. So now he is asking the mortgagee, who's the secured creditor, to permission to sell the secured asset. So I will not sell the secured asset in exercise of my right as a secured creditor under the Securitization Act, but he sought for that permission. And he said that I will sell it because I have a buyer and adjust the sale proceeds and pay it to you in potential satisfaction of your claim under the OTS. And since he had a buyer and I did not give him permission to sell, he now says that's a breach. That is one part of the breach according to him. And the other part of the breach is that he also sought for permission to assign the debt, that is also, there is also a rider there, not the entire debt, the OTS debt.
Correct, OTS debt.
He said that this OTS debt ought to, they made a request that I should give them a permission to assign this OTS debt to another asset reconstruction company, which I did not. So these two breach that they complain of. So these two breach, if at all, according to them, arises out of the OTS, nothing more than that. So even if I proceed on the basis of that, that's para 41. See, it cannot travel, his cause of action cannot travel beyond OTS.
Yes.
And a letter of the permission, which is at best a letter written after the OTS. Now, if your lordship reads this with 21C, my lord, ordinary transaction of merchant, bank and finances. So, my lord, this, in my respectful submission, does not constitute either an ordinary transaction of a banker or does not relate to a mercantile document and does not call for any other interpretation or enforcement of that. Well, there is a division bench judgment of our court. But recently, this division bench, I came across this division bench judgment. But exactly, my lord, a situation like this has arisen. Whether it was a suit filed by a non-banking financial company seeking recovery of money. Now, the defendant filed an application saying that this is not a commercial dispute. Well, the commercial court held in favor of the defendant. Then it came up in appeal before this court, before the commercial division, commercial appellate division. Commercial appellate division, my lord, interpreted what would constitute a mercantile document, and in the subject matter of that proceeding held that it is a commercial dispute. So that would be relevant because here, whether OTS, whatever, whether it constitute a mercantile document or not, for that purpose, may I give your lordship?
You have a citation?
Yes, I do. Yeah. It is 2022 SCC Online Calcutta 3010.
2022 SCC online.
SCC Online Calcutta 3010.
This is what is the name?
Well, it is Venkatesh Vincom Private. Venkatesh Vincom Private Limited versus Spice of Joy.
Justice Tandon.
Yes, Justice Tandon's division bench. Yes, well, can I?
I'll give a
airdrop
to your lordship, man. The airdrop করে দেখতে পারবেন আমি একটা আইপ্যাড দিয়ে দিচ্ছি
Paragraph 11 or paragraph 13, I think.
Yes,
दे दो that's आपको दे दो तो काम खत्म होगा
yeah, I'll airdrop it.
Yes.
I'll just try and airdrop this. পুরোটাই airdrop করতে হবে। It's in my liquid text.
In that case, the Lady Moon has been relied upon, and the judgment of the Bombay High Court has
Everything has been considered.
upon, and in that case, with regard to the defendant was running the business under the bar and restaurant.
Absolutely.
And this that I.
তুমি জানো না?
नहीं तो उसको भेजो चैम्बर से मंगा दी।
There, my lord. Now দিয়ে দাও। 2022 3010 জজ সাহেবের আইপ্যাড আছে? Print na. Actually, it's in my liquid text, so I can't airdrop it.
मेरे चैम्बर से मंगो जल्दी।
I'll just give it to you, lordship. 3010.
मैं चैम्बर से मंगो।
Well, by the time it comes, I'll just give your lordship the back. I'll just place a one or two paragraphs. We'll just give it to your lordship right
ये तो लैपटॉप से प्रिंट करके देना।
Well, I'm grateful to my learned friend. My lord, kindly take para 1. Appeal arises from a judgment and order of such and such passed by the Commercial Court Alipur in money suit, whether the application order 7/11 was disposed of. Shorn of unnecessary details, the suit was filed by the appellant for recovery of money, along with interest, till the realization of the amount before the Commercial Court Alipur. The plaint proceeds that the plaintiff is a non-banking financial company and engaged in lending money for business. Art 2 and 3 carrying on business for a multi-cuisine restaurant and bar in partnership approached the company for accommodation loan such and such at an agreed rate of interest. The amount was given through an account pay check in favor of such and such, which was duly encashed, letterhead such and such. Then, my lord, the amount of 25 lakh was further paid through such and such. Then, my lord, I'll just trouble. Then, my lord, if your lordship kindly comes a few lines after that in para 2, the plaintiff further proceeds that subsequently the checks were issued by the defendants were dishonored and insufficient funds has been initiated simultaneously. The suit was filed before the Commercial Court for realization of money lent in advance to the defendant, together with an agreed rate of interest. It is pertinent to record that TDS and such and such, such and such. Then Order 7/11 application, and a similar point was taken that it does not satisfy the definition of commercial dispute. My lord. Now, my lord, kindly take para 4. My lord, court proceeds. What is Commercial Courts Act the object? Global economy environment. Then, my lord, 2(1)(c), commercial dispute is set out. Now, kindly come to paragraph 5. My lord, kindly takes paragraph 5(1). Where, my lord, the submissions are recorded as to what is a mercantile document. Black's 8th edition has been placed. Thereafter, my lord, your lordship will see in paragraph 5 only, Lady Moon was placed, and thereafter Ambala Sarabai, and then court proceeds to consider the application and based on the submissions made by the parties from paragraph 6. At the very outset, we must record that the primary question involved in the instant appeal is that the dispute raised in the said suit and the commercially claimed thereunder whether satisfies the definition of the commercial dispute. Then, my lord, kindly take para 7. Reverting to the core issue of eventuality enshrined in clause I of 2(1)(c), postulate that the dispute arising of an ordinary transaction of financer relating to mercantile document, including its enforceability and interpretation, are the important factors to be borne in mind. The said clause can be segregated into 3 parts. Firstly, the dispute must arise out of an ordinary transaction of financer. And secondly, such ordinary transaction must relate to a mercantile document. And thirdly, the enforceability and the interpretation of such document is involved. Admittedly, the appellant is a non-banking financial company, which would be evident from the averments made in the plaint and the certificate of incorporation. The primary function of a NBFC or a non-banking corporation is to extend financial support and can regard an ordinary transaction of finances. We find no ambiguity in this regard that the lending money by the appellant is a fundamentally the transaction which it does and can be regarded as an ordinary transaction. Now, the parties are not ad idem on the expression mercantile document, appearing in the said clause for the reason that there was no agreement in writing nor any document evincing the money given as loan to the respondent. The mercantile document is not defined in the Act. However, the Act defines document. 2(1)(f) to mean any matter expressed or described upon any substance by means of letters, figures, marks, electronic means, or such and such, intending to be used or which may be used for the purpose of recording that matter. The definition of a document is expansive and not restrictive to any agreement to any executed by such and such. Then, my lord, kindly come. The definition is wide enough to include any expression or a description or any substance by means of a letter, mark, figure, electronic means, which will be sufficient to bring clarity. The word mercantile is ordinary parlance, means a document relating to a merchant or trading, or a document which is commercial in nature. Black's Law Dictionary, then, my lord, kindly comes to, since the word mercantile includes the transaction which is of commercial nature, the commercial paper is also defined in Black's Law Dictionary as an instrument other than the cash for payment of money, and include negotiable instrument in a particular kind of. Then, my lord, commercial paper has been defined. Then para 9 goes to Stroud's Judicial Dictionary. Then, my lord, kindly come to paragraph 9 once. Second sentence, a construction of a mercantile document. It does, second sentence, it does engulfed within itself any action or undertaking with an object to make a profit therefrom. My lord, such and such 2015 2 SCC, then, my lord, Lady Moon, single bench of this court, has relied upon various judgments of Delhi High Court, Bombay High Court, Madras High Court, as well as Calcutta High Court to ascertain the meaning of mercantile document. It has been held therein that all suits of recovery of money may not come within the purview of 21C, if not based on any transaction relating to mercantile document. The view of the Bombay High Court has also been noticed to the effect that the suit cannot be treated as a commercial suit unless the transaction has occurred between the merchants, traders, bankers, such and such, including is extended to any transaction of two individuals in extending a friendly law cannot be regarded as commercial dispute. Then, in view of the Madras High Court as relied upon by the single judge in Lady Moon, was that if the plaintiff have not transacted in the capacity of a financier, it cannot come within the view. Then, my lord, kindly skip a few lines and come. There's a sentence starting, though the aforesaid judgments,
Yes,
when noticed by the single bench in the above referred cases, but ultimately it was held that the suit for recovery of money lent and advance friendly loan does not satisfy the definition of commercial dispute. Then, my lord, a few sentences thereafter, your lordship will find there is another sentence, taking a cue.
taking a clue from the definition.
Clue from the, I think it should be cue, be that as it may, my lord, from the definition of merchant, what was a conservative view at one point of time have been a radical change with the varied varieties of transaction which can be manifestly seen from the expansive definition of the commercial dispute under 21C. By advancement of technology, the mode of nature and transaction have also changed. What has earlier been known as a negotiable instrument is a primitive stage, has been gradually taken out of practice, and the mode of transaction in electronic means RTGS transfers. Nowadays, my lord, usage of check has become limited. Then, my lord, Ambala Sarabai is para 10. Apex Court, while considering a case when an agreement for sale was executed in respect of a land in favor of respondent number 2 therein, would later on assign the such and such, purchase the property. Then, my lord, Ambala Sarabai.
Yeah, that was discussed.
Yes, my lord, discussed, held. Then, my lord, para 11. We do not find that the aforesaid judgment can be of any aid in the instant matter except the proposition that unless the dispute satisfies the definition of commercial dispute, well, that is an undisputed situation. It has to, that test has to be, my lord, applied in every case. My lord, then it comes to the facts of that case. Appellant is not a banking company, is a non-banking company, and exchange in a business of financing of extending such and such. Any money given on a loan in the ordinary transaction of the non-banking financial company, provided it augments income from such transactions. The respondent number, have your lordship noticed that, my lord?
Yes, yes, yes.
Yes. Any money given on a loan in the ordinary transaction of the non-banking financial company, provided it augments income from such transactions. The respondent number 1 who is selling the product for profit is a merchant, and therefore the transaction between the plaintiff who is engaged in a finance business extending loan for profit is a transaction between a financier and a merchant.
So the money is to be used for the Purpose of?
That if there is a dispute that arises out of money lent in advance,
Yes.
then my lord, there's one more paragraph I wanted to show your lordship. Oh, it's come. Oh, I'm so grateful, man. I'm so
Thank you.
grateful. Now, my lord, at para 12, if your lordship will kindly take, there is towards the middle of the about that internal page would be 9. If your lordship will take para 12 where it starts, about 8 lines from the bottom of that paragraph.
As indicated.
At paragraph, as indicated above.
Yes.
The lordship found that, my lord?
Yes, yes.
Yes. As indicated above, there is no condition laid down in the said definition that the mercantile document must be executed the beginning or before the transaction having been executed rather than a moment of 21F into the matter expressed or described among the substance and means of letter such and such. We therefore have no agreement. Then it holds in the subject matter of that case that there is a commercial dispute. My lord, applying this test to the facts of our case, and if your lordship once again goes back to paragraph 41 and the previous paragraph where they claim damages, my lord, the entire cause of action and the suit and the relief claim is restricted to, my lord, 2 breaches. OTS offered, according to them, they said
not allowed to sell and assign.
This was a request made by them, not a part of the OTS. Not a part of the OTS.
Correct.
My lord, in order to ascertain what is the cause of action and applying the test,
yes,
to ascertain whether it is a commercial dispute or not, my lord, in my respectful submission, the court needs to consider what exactly is his case of breach, his action for breach, or his cause of action pleaded in the plaint for breach is that there was a OTS, but subsequently he has given 2 letters making 2 requests. Those requests were not adhered to. That gave rise to a situation where he has suffered a damages.
Correct.
Simplicity case for damages. So, my lord, if your lordship comes back to 2-1CI, my lord, it does not satisfy either of the situation where division bench just said there are 3 limbs in I. None of the 3 limbs in my respectful submission stand satisfied. So, my lord, this fails to be a commercial dispute within the meaning of 2-1C, and accordingly, my lord, there is no scope of transferring a commercial suit to regular. Well, it is the other way around, it is permissible. So the suit must fail. And if they have any cause of action, they're open to take steps in accordance with law. These are my respectful submissions.
Thank you. Fiction. Come tomorrow. Come tomorrow.
The next matter.
Yes. Expenses when suffering for the plaintiff, expenses when suffering for the defendant. Defendant has filed an application being GA3 of 2022, praying for rejection of the plaint on the ground that the suit filed by the plaintiff is not a commercial suit. Counsel for the defendant has argued the matter, has concluded his argument. Can expect GA 3 of 2024. Due to paucity of time, counsel for the defendant could not argue the matter. According case adjourned, let the matter appear tomorrow.
In its position in the list, ma'am. Your lordship has directed to
tomorrow.
Wait.
Yes. Well, may I take off from where I've not stopped on the last day? Just one quick reminder, the suit for passing off an infringement filed by my learned friend. I've showed your lordship the registered mark. The registered mark is a label mark and with a condition that it is only with regard to the particular color in which that label is. I also showed your lordship my label. There is nothing in comparison, no similarity at all. Now, the next thing which I had started off on was that my learned friend has no title to the trademark at all. And I showed your lordship from the affidavit in reply, one page from the website, which says that the page 13 of the AR, not the website, saying that Dr. M. Idris was the founder of the plaintiff company. Now, from here, if I may just take your lordship to 3 paragraphs of his plaint, or petition, which your lordship will find annexed to my vacating application. Or please take the injunction application, 3 paras, to show how he claims title.
Yes.
Now, his case is Dr. Ilyas. His case is not Dr. Idris, but Dr. Ilyas, who is son of Idris, had started this mark. And then, how it has come to the company is a mystery because no documents have been given. So his pleading is this, if your lordship, please take para 8 at page 5.
Yes. Page 5.
Page 5 of the injunction application, para 8.
Yes.
Now, this is the crux of the matter. Thus, the entirety of the business of selling homeopathic medicine drugs by the said Dr. Ilyas came under the banner of the plaintiff, which became the principal proprietor of such business, including the goodwill attached thereto. So, thus, the entirety of the business set up by Ilyas comes to the plaintiff. How? Not clear. Which became the principal proprietor of such business, including the goodwill attached thereto and the tangible and intangible assets thereof. Now, the next line is very important. Not the entire case will hinge on this, in my humble submission. The said Dr. Ilyas, by his conduct, please mark it by his conduct, not by a document, effectively waived his rights associated with over the said moniker and a trade name and a brand name and a housemark, which became the valuable asset of the plaintiff company. So, mark started by Dr. Idris, Mr. Ilyas has waived his right and therefore it becomes that of company.
Yes.
Now, I've showed your lordship from his own affidavit. I'll show that once more. Where he has said it starts from Dr. Idris's family and all branches are using it. So, 3 points arising out of this. Please note this by saying by conduct. It means that there is no agreement, whether oral or in writing.
Yes.
And none has been produced.
Yes.
No document in support, and it's clear that this is an admission that there is no document because he says by conduct. Number 1. Now, number 2. Will a waiver by him give the company, the plaintiff company, any right, title, or interest in the mark is the question then before your lordship. Now, assume for a minute Dr. Ilyas was the owner. Now, will this waiver by him operate and give a right to the company? This is the first point. My learned friend is to establish that. I'll show it can't be done. Number 2, going by his own case, the case before the Delhi High Court, which I'll show your lordship. But if Dr. Idris is the founder, then no amount of waiver by Ilyas will do. Everyone else must waive and give their. Everyone else's waiver is required. One waiver will not do, assuming that a waiver is good enough. Because my submission was, your lordship will remember that assignment of a mark must be in writing. In this case, admittedly, no writing. or not the three alternatives, or it could have come by will,
This no will.
not there, because from Ilyas it will go to his sons, including myself. Or thirdly, not a business of Dr. Ilyas is taken over by the company, which would have showed in his memorandum and articles, admittedly not there. So, not assignment to the company has not happened at all. So, plaintiff has no right, title, or interest in the mark. Now, allowed the others to use auto record.
Yes.
Now, the other thing, if your lordship now, my lord, goes back one paragraph to paragraph 7.
Yes.
So, my lord, one leg is he got it by waiver.
Yes.
Now, title by waiver, my lord, concept that I have not heard of. Now, the other part is he has to explain now why all these other people are not using the mark, because if they are, he has no title. So, he attempts to cover that up in para 7. Many of the other heirs of Dr. Ilyas became shareholders in the plaintiff company in order to consolidate the family business having the name New Life and the mark New Life under the mother concern. Relatives of Dr. Ilyas who had been permitted by him to carry on business with the mark New Life entered into arrangements with the plaintiff for sharing of profits with the plaintiff instead of Dr. Ilyas, thereby becoming sister concerns of the plaintiff. Management of the plaintiff was initially under so-and-so, so-and-so, so-and-so. Now, two things here. But when he talks about family of Dr. Ilyas, is he also referring to his brothers, Dr. Ilyas's brothers? This is one part. The other part is he referring to his immediate family, i.e. his children? Now, given this situation, not first, please see this, that he says there was a profit sharing agreement, which shows that there was a license granted to these people.
Correct.
He's talking about a license. Now, not under the Trademark Act, not this has to be in writing. That's the definition of the Trademark Act. Kindly see section 2. First, please see 2B.
Section 2.
2B. But I'm covering both assignment and license together, since not your lordship has the act. But please take section 2B.
Yes.
Assignment means an assignment in writing by act of the parties concerned.
Yes.
So this is one part. Now, my lord, also please see section 2R.
Yes. Permitted use.
Permitted use.
Yes.
So, my lord, permitted use also your lordship will find 2R2 is the applicable one here. Permitted use in relation to a registered trademark means use of the trademark. Now, my lord, 2 is by a person other than a registered proprietor and registered user in course or in relation to the goods or services with which he is connected and in respect of which the trademark remains registered for the time being, and by consent of such registered proprietor in a written agreement. So, my lord, even a permitted user will require this. Now, coming. No, don't. Let
Yes.
the concept. So now, my lord, he says he permitted others to use it, but no document disclosed at all. Now, this fact is also not completely contradicted by two things. My lord, your lordship remembers that chart. My lord, please see that chart, which he annexes to his, or which he makes part of his affidavit. Page 318. 317, volume 3 of this, of GA2, vacating.
GA2.
GA2, volume 3, I showed it on the last day.
The Delhi High Court affidavit.
Yes.
317.
316. Now, if your lordship comes to 316, I've shown it earlier. Not, let me take your lordship very quickly through it. Last few lines of 316.
Yes.
Moreover, the family chart prepared by the defendant number 1 showing details of the family members of Dr. Idris along with the business is not up to the mark and is incomplete. The complete chart is produced below. So this, according to him, is the correct position. Now, Dr. Idris family chart. But please go to the next page, 317. Item number 2. Dr. Ilyas, New Life Homeo Store, 1970, now closed. Then we'll take item number 5.
Tariq.
Dr. Tariq, so another son of Dr. Idris, New Life Ayurvedic Store from 1993. Then, and I understand this company, plaintiff company, was set up 1995. So, this is prior to the plaintiff company being there. Then, please see item number 7. Dr. Mugish Siddiqui, New Life Homeo, Cure Clinic. So, there are others in Idris's branch who are carrying it on. But I don't need to trouble your lordship. I've given the numbers. Then, come to Dr. Ilyas's family chart. Now, look at the number of people who are using this. Now, look at item number 1, New Life Homeo Store, New Life Era. Then, item number 2, Zaki.
All are using that.
All of these people are using it, even according to him, for long years. Long years. Please turn the pages,
Yes.
All of them.
319.
So many people using it, so many different things. Now, please, now in this connection, please take again GA2, page 90 onwards.
Of this application?
Yes, GA2. Page 90 will be volume 1. Now, what he suppresses wholly is that these shops are also carrying on business side by side. Side by side.
Yes.
Now, please see page 90. 2 shops side by side. On the left-hand side was the defendant's mark. Right. Oh, sorry, not some other brother. No. New Life, and right next to it, your lordship has found homeopathic medicines. On the left of homeopathic medicine is that New Life logo. Registered mark. So 2 shops side by side.
And these are the both.
Oh, there are 3 shops there. I'm sorry.
New Life Ayurvedi also.
Yes. So 3 shops side by side.
These 3 are the 3 different persons.
Yes. Names are given on top. New Life Homeopathy, Mohammed Zaki. New Life Homeo, owner Salman Mohammed, brother of Zaki. New Life Ayurvedic and Unani, Mohammed Tariq, uncle of Mohammed Zaki.
Yes.
And this is the one which was established in 1993. Now, complete suppression. Now, turn the page. Page 91.
Yes.
2 shops again side by side. New Life Polyclinic, New Life Pharmacy, and Dr. Zakaria New Life. All of them, next to each other, been trading for years.
Yes.
Please turn the page, Millard. Again, page 92. 2 shops. Sorry. So, this is another person, not side by side, another shop. We've given photographs of all these shops.
Zakaria.
Yes. Then 93 is Mohammed Tariq. Then 94, New Life
So you
Homeo.
mean to say the other persons are also running their shop?
Yes, they are all running it and they're side by side and they've been doing it for years.
It is not that they have started new.
Yes. But
It is up till?
But this is going on till page 97, till page 100. Till page 100. Now, Millard, please see page 94, for example. Mugish. Uncle. So, Millard, Idris's family. Not descendant of Ilyas.
97.
And from 97. So, Millard, this story, Millard, based on complete suppression, he has no title, he suppresses these. And, Millard, there's an affidavit given by Millard, this Mr. Dr. Mugish Siddiqui, which is at page 110.
Of J2?
Yes.
Volume 1.
Again, my lord, in but please see para 2. I say that my father, Dr. Idris, adopted and starting using the mark New Life Homeo in 1952.
Yes.
When he practiced homeopathy for 52 years till his death. The said clinic continued for a considerable period of time. That later in the year 1970, my older brother, Dr. Ilyas, opened his clinic under the trademark New Life Homeo Store in Bhopal, where he practiced homeopathy. His registration number is so and so. Thereafter, he opened several homeopathic clinics inside the shops being run by family members of Dr. Ilyas. I say I started my homeopathic practice in 1996 with my father under the name New Life Homeo Cure. I opened a new clinic of homeopathy in the name New Life Homeo Clinic in Bhopal in 2023. I say that
You have given the total details.
yes, I say trademark and trade New Life has been in use by all family members. Now, Mlad marks this para 5. I say that the trademark and trade name has New Life has been used by all family members of Dr. Idris, including all his sons, Ilyas, Tariq, myself, Dr. Muhammad Mughis Siddiqui, and their children as partners, proprietors for running their retail wholesale shops for the past few decades. I say as on date, there are around 20 retail clinics being run by members of the family, etc. By members of family of Dr. Idris selling pharma medicines without any objection by anyone in the family and under the trademark New Life. Everyone in the family of Dr. Idris is well aware, including myself, that Mohammad Faizan is running his shop cum clinic under the name New Life Medicos since 2002 and Mohammad Zaki under the name New Life Homeopathic Store since 2017. Some of the shops are next to each other. I say that the trademark and trade name New Life is a family-owned trademark in which every member of the family of Dr. Idris has a right to use. Now, Mulad, please see how he deals with this. Or before that, let me just finish with this affidavit, not just a few more paras. Para 6, I've read out. Then, Milord, please turn to the para 7. I say that the contents of para 2, 5 to 7 of the plaint are absolutely incorrect, where it has been stated that Dr. Ilyas permitted his relatives and his other sons of Dr. Idris, including myself, to open outlets, trademark and trade name on sharing of profits accruing from such outlets with Dr. Ilyas. I say there has never been such understanding with Dr. Ilyas, and in fact, there has been no such understanding between any of the family members of Dr. Idris, and there has never been any sharing of profits. Plaintiff is put to challenge to show any such sharing.
Yes.
Now, Milord, in response, your Lordship has not found any document showing this. So, Milord, this entire story is concocted. Now, Milord, in reply, so that was that para one that you wanted. Now, in reply, let me just show your Lordship what he says. I'm sorry. But page 10 of his reply.
Give the reply.
Not the same one with the website, not
Page 10.
page 10.
Reply of Zaki.
I'm sorry.
This is the affidavit in opposition.
Not this is the affidavit in opposition. I'm sorry. Not to our vacating application being GA2.
Affidavit in opposition of GA2. Page 10.
Page 10. So now, my lord, he is really giving up his case for passing off. I'll show your lordship how. Page 10. Not about 8 lines from the top, just where that mark is not there.
Yes.
While it is true that no family member could claim exclusivity over the trademark and name. So, my lord, no one has exclusive right. They all have the right to use it exclusively. Now he says, why does he get a right? Could claim exclusivity. It is true and correct, both in fact and law, to say that such exclusivity can be claimed and is claimed by the respondent plaintiff as a consequence of being or having a registered such mark. So his only right now is coming via registration. Not this transfer of title, etc. Nah. gone. Everyone has an equal right, but I am claiming exclusivity now because of registration. So, my lord, action in passing of gone. Only registration remains. Now, if it is only on the basis of the registration, please remember, not there had to be an assignment in writing and permitted user in writing. Going back now. The point is important. Multiple points.
Yes.
So, my lord, now I only have to meet this case that he is claiming infringement of a registered mark. That is all. So, my lord, now please, my lord, go back to the pages where the two marks are. The registered mark 376 of GA1 and compare it with mine. Now, before that, let me give your lordship a little history with regard to the litigation. Now, my lord, he filed a suit against me in Delhi. Now, my lord, at that point of time, my lord, my name was New Life Homeo and Herbals Limited.
Dr. Ilyas.
Dr. Ilyas New Life Homeo and Herbals Limited. I'll show that to your lordship. So he filed a suit challenging that. Dr. Ilyas New Life. I'll show your lordship the orders. The court considers it over several days. Objections are filed, written statement is filed. After several days, he still does not get an interim order. Then the court raises a question of jurisdiction. Because in one of my written statements, I said, look, I'm selling in West Bengal and I'm selling in Bhopal. I'm not selling in Delhi. So the court raised the issue of jurisdiction. How do you then have jurisdiction? But matter was heard for a couple of days thereafter. They felt they could not satisfy the learned judge, so they withdrew the suit. Suit is dismissed as withdrawn. Now, in the meantime, please remember there is no suit for 10 months. Now, my mother then, Lord, persuades me, look, why do you get into a fight with a brother? Change your name. So, Lord, I changed my name to the present name which your lordship has, Lord, injuncted. So, from Dr. Ilyas's New Life Homeo and Herbals, Lord, I change it to NL Care Private Limited, which, Lord, in my humble submission has no similarity at all with the registered mark. So, Lord, for that, now please go to the registered mark, volume 3. So, my lord, I was earlier Ilyas New Life Homeo. He asked to stop that. He did not get it.
Page number?
Or 377 or 376, minute. 376, volume 3.
Yes.
What I've showed your lordship, TM applied for was device of leaf.
Yes.
So it's a device mark of leaf. And then, my lord, goods and services your lordship has got. Then, my lord, your lordship sees. Please, my lord, also see, lord, it's a class 35, trading, marketing, advertising, business management of pharmaceutical preparations, including class 35. Now, please see the condition. Mark shall be limited to the color as shown in the representation. So it is limited only to that color of the label, nothing more. Yes. Now, my lord, please see page 377. This is his mark. Now, when he came in Delhi, my mark was Dr. Ilyas New Life Homeo.
Yes.
And Herbals. Then, my lord, I changed to this, page 382. At the time of the filing of this suit, this is the mark he is challenging in his suit.
370?
382. 382. So please compare these two now, my lord.
NL.
NL.
So now this 376 is of the plaintiff.
Yes.
He is using.
Yes. Yes. That's his registered mark. Mine is Dr. Ilyas NL. Now, my lord, what is he claiming a right over, my lord? Let me understand this.
Page 382.
Yes, 382. My lord, please just keep the same side by side.
Or 381. 381 is the register.
That's the application made by me.
381 is the 381 and 382.
Yes. So, my lord, 382 versus 377.
Yes.
Now, he is a leaf. Please see the manner in which leaf is done. The device.
Yes.
With the writing New Life Laboratories Private Limited. Now, your lordship knows under section 17, he can have no right over the words New Life Laboratories.
Private Limited.
He can have no right over it unless he has separately registered it. This is a device mark. I'll show the section. So he has no right over New Life Laboratories.
Yes.
Now he may have had something to say if I was using New Life Laboratories. But I'm not even using that. Please see now 382. What am I using? I'm using 2 leaves done in a completely different manner. There is no new life on it. And it's a nice artistically done label which is not even similar. Now, New Life he has no right over. I'll assume he had a right for a second. Even if he did, he could not have stopped this because I don't have New Life written there. Now, therefore, a purchaser on the road will have to jump to the conclusion when he buys NL that this stands for New Life Laboratories.
Correct. Private limited.
Private limited. Now, this is not jumping too many steps because, let us say, look at the picture of the leaf. Can one say it means new leaf? Dr. Ilyas's new leaf? It could be anything. NL could be anything. It could be anything. Why should one assume that this is Dr. Ilyas's New Life Laboratory Private Limited?
And the mark shall be limited to the color.
Yes.
What is the color of the print?
Correct. Not if he uses a green label and I use a green label, let us say, then he may have something to say. But he is not doing that. He is not
What
saying.
color you are using?
Radha, I'll have to find out.
Red.
Tell me. Radha, I'll just. So, yeah. Yeah. What color was he in? Yes. Registration is in which color? Check it. Green. Green.
That's mine.
That's mine. That NLK which I showed you, Lordship. And Lord, this is his, also in green. But that would apply if I was using this label, but I'm not. So, Lord, please see, Lord, look at what his registration is. From there, Lord, he jumps in. Lord, I gave him half an inch. Even though there was no order against me, his suit failed. He had to withdraw it. Lord, I changed my name because Lord, he was objecting to using New Life.
Yes.
I changed it to NLK. And I changed my label. And then he files this suit, Lord, 10 months later, and comes and gets an ex parte order. Suppressing, Lord, all of these facts. Everything. Shop side by side. Others from other branches using it. That is his own admission in Delhi. And then, Lord, he runs a case which he did not run before Delhi. He was aware, Lord, he'll have that problem. So he put in that para. Lord,
Yes.
so, Lord, in Delhi, when he filed the suit, surprisingly, this story of waiver and permitted all those other people, not there. Lord, comes to Calcutta, comes to the hands of perhaps more experienced lawyers. They realize there is no title. So these 2 paras, Lord, come in those 2 paras which I read. Lord, para 7 and 8. These 2 paras were missing in Delhi. Permitted everyone else to use, profit sharing arrangement, and then, Lord, waiver by Dr. Ilyas, by which, Lord, plaintiff becomes the owner. So, Lord, all of this is made to give it a semblance of. Now, Lord, please see what delay he has come after. And after I have changed my label mark, Lord, as a measure of goodwill to avoid, Lord, battles in the family. At the instance of my mother. I have said so on affidavit. But also, I'm being purely argumentative here. It's not my client's case. But this NL could be anything. It could have been New Leaf. It can be Nature's Leap. It could be Nature's Life. It could be anything, Lord. Yes, sir, we will.
You change the color.
Madam.
Change the color.
Lord, he's got that label in green. I'm not using that. Your Lordship wants, Lord, I can take that instruction. Just give me one moment. And it doesn't matter, yeah. Come on, it falls from the judge. You have. Okay, that's all right. Lord, if that falls from your Lordship, I understand. We may be willing to do that, but not the problem would be there's huge stocks of this lying there. So your Lordship will have to.
We'll see. After hearing, we'll see to that.
So, Lord, this is that. Now, my lord, please also see the orders passed in the Delhi proceeding once. Not what? GA2 volume 1.
How much time will take, Mr. Prachad, for
But I'll finish today. 25 minutes I have, I think. Lord, your lordship has given me 1 hour. I'll finish. Huh?
Tomorrow also fixed.
Oh, I see.
Come
Yeah,
tomorrow.
I'll do that. I'll do that. Oh, shall I about it only?
Expenses suffering
Arey,
for
then
the
I would have speeded up. You had told me, na, because otherwise you won't.
expenses suffering for
No,
the plaintiff, expenses suffering for the defendant.
didn't.
Mr.
Yeah,
Counsel,
so
the defendant has argued again,
Take a leaf out of your
but due to paucity of time, hearing could not be completed. It is funded. Matter is already fixed tomorrow. Let them.
Well, Mr. Banerjee here wants to turn over a new leaf.
Taking the cue from Mr. Bashar.
But he
This
doesn't.
is-
But I hope he doesn't turn into a new leaf. He's got a good life as it is. He doesn't need a new life.
No, but my matter does need. Believe me.
But he is happy with his lovely cars and jeeps. But he graces our court once in a while. But
नहीं सुनो पैक करके रखो
But those can remain, Lord, in case your lordship has.
Yes, I will.
In case your lordship has a cough.
That's why I seen with regard to the manufacturing date and the expiry date.
Now, my lord, as a
First
matter.
you have gone through the expiry date.
Now, my lord, as a matter of fact, I tell your lordship, I never used to believe in this. Now, my wife really believes in homeopathy. And I'm talking about since the time we've been married. So when we had children, Lord, children get cough and cold all the time. Now, there's two things. Either you go to a pediatrician, their only job is to pat the mothers on the head and say, don't worry, nothing will happen. Or you go to a homeopath and they give those tasty drops and it works. And I always thought this whole thing is a joke for years. And then one day I had a major problem. I woke up in the morning, I was bent like this. Sort of desperation, I went to Lord, a homeopath who my wife's family had been using for 20 years. Happened to be well related to Mr. Banerjee. Yeah. Now his wife. So his wife's close relative, uncle or something. Now he said, he spoke to me for an hour and I thought he diagnosed it better than not any doctor in Calcutta. And he said, I'm giving you some drops. It's going to work by today. If it doesn't, come back tomorrow. I thought the man is being very cocksure. So he opened some bottle and he put 3 or 4 drops on my tongue. And I sat in the car, I drove home. By then, the pain I could see was going upwards. It was vanishing. Next morning, it was gone. After that, I started believing a little bit. And whenever I've traveled after that, this gentleman, well, his wife's relative, but I'll say this, a little greedy because most homeopaths not give the name and they give the medicine.
They will not.
He would not, he said. So all I had to do is call him and say, uncle. So he'd say, oh, only because you are so-and-so's husband, only because you are so-and-so, I'm sending it to you. No, it was to do with my wife.
Knew how much he earns.
So, and one pudiya he would not send me and I would carry it on my travels everywhere.
Good.
And not 30 years, it's not. Whenever it comes, 1 drop.
Lovely. Lordship, my matter, I come for caveat discharge, Lordship, as per the rules of the High Court.
Yes.
Now, my probate petition is filed prior to filing of the caveat. Now, there are 2 distinct rules. One rule is when you file the petition post filing of the caveat, and one is when you file the petition and the caveat is filed. So, Lordship, my case is that I filed my petition, then the caveat was filed 6 or 7 months after that. And now, of course, another 8 months has gone by. And I have applied for discharge of the caveat and grant of probate. Now, that's as per the rule. There is no lacuna, there are no latches on my part. But, Lordship, I must say, as I said, that I will try to turn over a new leaf from the last matter. Lordship, these are typically middle-class households, families. There was mother and there were 4 daughters. Now, the father, in his wisdom, gave the movables to the mother Although this is not relevant, this is just out of my experience and everything I'm saying, Lordship, if Lordship permits. And immovables to the son. Now, all mother, who's now deceased, and the 3 elder sisters all agreed. They all gave consent, and it's part of the probate petition. Now, only the youngest had a problem and didn't want to agree with the whole family, etc. Now, obviously, they can ill afford litigations, particularly in these kind of things. And my brief was, when I actually took it, was that, is everybody giving consent? Because I don't want to, because what happens is the attesting witness is also well known to the family. He's a senior lawyer practicing in the criminal courts in Bangshal. He and his junior prepared the will, signed it. He's the attesting witness. So if need arises, he will have to be put to the box and everything else. Now, whether they have got a copy of the will, knows about the will, because my client says my instructions are that they know about the will, they're aware of it, they even have a copy, probably through somebody or the other.
Who are they?
But I prepared a copy.
Who are they?
Sorry?
I'm the
Who are they?
youngest daughter.
Only one daughter.
One of the daughters.
One.
Yes, ma'am.
Youngest daughter who has not consented and who has objected and who has filed a caveat but not taken any steps thereafter. So I am suggesting, out of my subject to lordships, that I have seen wonders being worked out when, you know, the court starts a little bit of, you know, orders, etc. and observations. So if this matter can be settled between them, I think I will be the happiest and the parties will be happiest, because there are now, mother is waiting for the, you know, agreement between all the the elder brother and all the sisters has expired. Now all the sisters are up in arms because, you know, one sister has objected. The movables are were supposed to go to the mother. So obviously the mother has died, as far as I know, without a will. So that's an intestate succession, which again gets divided into. So if they may sit and try to work out something, Lordship, at least this will not go the way, because these kind of litigations, Lordship, I have seen from my experience, they can ill afford. They can ill afford a blown out litigation with witnesses, with costs are prohibitive nowadays. So this is my suggestion, Lordship. And I, as far as the technicality is concerned, I say I have rightfully applied for discharge of the caveat because no steps have been taken by the caveatrix after filing of the caveat, because my petition is filed prior to. If Lordship wants, desires, I will read out the provisions.
Okay. Yes.
My lord, the caveat, my lord, has been filed, my lord, without, my lord, the knowledge that there is any application of or grant of probate. My lord, in such a case, my lord, I would also have to place some provisions of
No,
the
it's
original
correct. I will
titles.
go to the law subsequently.
My lord, however, my lord,
with regard to the settlement, what is the chance of settlement?
my lord,
What your client want?
my lord, I'll have to seek instruction. My lord,
What your
however,
client want?
my lord, to at least file the affidavit in support of caveat.
That's see.
My
if
lord,
it-
after that, my lord, I will take instruction, and my lord, if settlement is
that I will
possible,
go
my lord,
through. You take instruct what your client actually want. Only one sister is objecting, other I don't think so.
my lord, let me take instruction on that,
So-
my lord.
so
Till
you
then, my lord,
you satisfy your client. See, and this court, in this is a PLA matter, testamentary matter, this cannot be sent to the mediation.
yes, my lord.
Yeah, it is out of the court. You can settle then as per the will, and what are the settlement, that will be subsequent event.
Yes, my lord.
And whether your caveat is to be accepted or you have to be discharged, then I will that. If it is not settled, the court has to go by the law.
Yes, my lord.
What the law provides for. Correct. But once it has come from their side, they are also ready, and you are also, see, with regard to what maximum you want your share.
Yes. That
Right.
would be
It is a Hindu law, though.
yes, my lord.
You sit together, go together. What is the demand? If not, then court will take the matter. There will be no problem. You are already also the sister.
Yes.
So there will be no problem by sitting the sister together. In
And
a
all
round
the
table.
sisters can join. They are out of Calcutta. Nowadays, voice, that video and all that is facilities there.
Or otherwise, a picnic, arrange a picnic, come and settle that.
No, it should
I
be,
shall do that.
Lordship. My experience,
My
this
lord, I'll
is
seek
again,
instruction.
Lordship, this is out of my experience. I'm again repeating, not that my client has instructed anything. I am saying this as an part of this honorable court, because I have been doing testamentary matters since childhood, since I've joined the profession, and it's been quite a few years now. Now, these matters just drag on. They don't end. witnesses are all known to them, etc., etc.
And
If they want, they can just finish it.
Your persons are very benefited of the original side. If you go to the civil court, then it will be difficult in the testamentary. Yes,
That is the reason we file in the original side, Lordship.
That's why.
Because of this advantage.
Because of the advantage in the original jurisdiction, you all people have got the good advantage.
Absolutely.
Disposal of the testamentary matters. Otherwise, in the civil suit,
And
you
I,
know.
I must also mention, for 3 days, the third day I'm very thankful, Lordship, that Lordship has allotted a time, not that after 2:30, 3:30, but Lordship has given the 12:30 time for testamentary matters. After a very long time, we are having this.
No, all the matter is to be touched.
Have just
But the determination is given to this court. This court has to.
I never speak out against the department. And look at the registrar should have taken steps. If they are saying that they have not got notice, I should have got notice.
Okay, how much time?
My lord shall keep it next week, my lord.
Within a week, settle it. Not, I will take the matter. I will not record anything. So and so appearing for the petitioner, so and so appearing for the tested executrix. Executor, so and so appearing for the cavitrix. As per the prayer made by the consul for the parties, the case is adjourned for a week. Let the matter appear on on 22nd January under the same heading at the top.
Grateful, my lord.
Deeply obliged.
Sit together.
I shall do it.
Next.
Deeply obliged, Lordship.
My lord, this is my application for probate, my lords. My lord, all the legal heirs have given their individual consent affidavit for grant of probates.
Where is the will?
My lord, annexure E, my lord, original will, annexed with the applications. My lord, it is annexure A of the application.
Examine the witness.
Yes, my lord. So what happens that all the witnesses have expired.
This is the original will.
This is the original will, my lord.
And you have not taken care of it. It is going on.
My lords, I have filed.
That's why I find from here. So
Yes,
it is original. So that's what I'm telling.
A very old will, my lord. I should have.
But you persons, please take care of it. It is not provided in the original schedule or in any. But you have to file the original. Please give the original in either in the cover.
Yes.
Or in laminated.
Yes. Well, sometimes when we file
what you will do? What the department will do with this?
Well, if your lordship kindly grant permit, then I'll get it lamination and refile it, because if it is condition, it will go now.
So you examine the witness.
My lord, if your lordship kindly come to the order dated lordship's 23rd April. The 19th August 2024, my lord Justice Bivas Pattanayak, when the Learned Advocates Commissioner has been appointed for taking evidence of the attending witness, because all the attesting witnesses have expired. So, my lord, I have filed the death certificate. Okay. If your lordship kindly find the report of the Learned Advocate Commissioner, my lords.
Where is report?
My lords, Srimati, Mrs. Kanika Roy. Sorry, I made a mistake, my lords. Chandrei Dotto. If you lordship kindly come to page 4 of the internal page, lordship kindly. The evidence on part of the Srimati Konika Roy, internal page 4, question number 14. Mrs. Roy, I'm going again showing, please tell this, what is the document? This is the will of my mother in Konikawala Roy, since deceased.
She is the daughter?
Sorry, she is the daughter-in-law. She is the daughter-in-law. And testatrix is the mother-in-law.
Correct, mother-in-law.
My lord.
And
My lord, has been exhibited A.
Who is the executor?
The executor is the two nephew. Two nephew.
Yes.
My lord, then question number 15. Then the signature of the testatrix has been exhibited. Question number 15. Then lordship, question number 16. that the signature of the all three attesting witnesses has been exhibited.
Yes, where is the will?
My lord, will the annexure A, lordships?
There's no translated copy.
Yes, a translated copy. It has been translated, my lords. Otherwise, the proceeding should not have done.
Where is the translated copy? No translated copy is there. Okay.
It has been translated by the department, my lords.
Yes. What is the date of the will?
My lords, this is date, my lords, 7th July, 1968.
7 July 1968.
Yes, it's too old, my lords. It was not available.
Then, where is the name of the
my lords?
Executor.
This the my lords.
I appoint my son-in-law, Shriman Sailendra Majumdar, the only executor of this will.
Yes, my lord. Sorry, I made a mistake. The executor has expired. Now, the beneficiary under this will has made this application for letters of administration with will annexed.
This is letters of administration.
This is a letter of administration with will annexed, my lords. Sorry, my lords.
And where is the name of the beneficiaries?
My lord, my lord. My lords, the beneficiaries.
My sons of my.
Yes, he has also.
Mine shall be the owner of the property in equal share after the death of my younger son. He said two sons of mine, Sriman Manas Roy and Sriman Sambas Roy.
Yes.
Or their substitute shall be the owner. So who are the petitioner here?
I am the son of Manas Roy. Because under the will, the property should go to the Manas Roy.
Sons of mine, namely Sriman Roy and Sriman Tapan Roy, or their substitute shall be the owner of. Manas Roy.
Manas Roy. My lords, this is the second para of the will, my lords.
Yes.
That's
no. With all conditions mentioned above, three sons of mine shall be the owner of my movable and immovable property.
Yes. Now,
in equal share after my death.
Yes.
After the death of my younger son, the two sons. Younger son, who is the younger son?
Yes. Younger son has died, as I have pleaded in the application.
Who is the younger son? Manas?
No. Younger son is my lords. Oh, 1 minute.
So where the Manas has come?
Is Manos, the three sons, namely Sri Tapos Ranjan, Paras Ranjan, and Manos. First name is three sons, Manos.
Sriman Manas Roy, Sriman Tapas Roy.
Yes.
Yes. Okay. So he is the son. They are the sons of Manas.
Yes.
And what about the Tapas Ranjan?
Other is one is husband of Konika. They are the childless. He is expired.
Tapas died.
Tapos was the handicapped, my lord. He is also died. I have annexed the death certificate in the applications, my lord.
Yes. Where is the death certificate of the testator? Tapas Ranjan Roy. Who is the testator?
Testator is Konika Valara.
Testatrix
is Konika Valara.
Konika, where is the death certificate?
My lord's annexure B.
Kamla Bala Roy died on 1286.
Yes.
1286. Then Manas died on 94.
My lord.
Then Tapas died on 2008. Who is the Ira?
Ira is the daughter of one daughter, my lords.
So where is the legal heirs you mentioned?
My lords, paragraph 4, my lords.
Nika Roy,
Yes.
Sanjay Roy, Sujay Roy, Anjana, Rani, Amita. Yes. Where is the attesting witness?
Milos, as I
Attesting witness.
submit all the attesting witness have expired.
Only attending witness examined.
Attending witness examined through the London.
What about the legal layers?
Legal years, they have given all consent. My lord, individual affidavit of consent affidavit.
Where is that?
My lord, all this filed with the application. my
Ranjana
lords.
Goa.
Yes, my lord.
Then
First is Konika Roy. Konika Roy, you want to see also the attending witness. Filed her affidavits.
Yani.
Sanjoy and Sujoy, both are the applicants here. Anjana, Piali, and Ranjana.
Kanika.
Kanika is, yes, Kanika also filed the consent and she is also the attending witness.
Sense opening for the petitioner. The petitioner has filed the present application for grant of probate with will. Grant of letters of
administration. With will annex.
Administration of the last will and testament of the deceased Kamla Bala Roy, dated 7/7/1968. Where is the delay? Why delay have you
My lords, it was not made available, my lords. Delay, I have made one paragraph, my lords.
Counsel for the petition submitted. Counsel for the petition submitted. The testatrix has executed her last will and testament by appointing her son-in-law, Shriman Sailendra Majumdar, as the executor of her last will and testament. But Sailendra Majumdar has expired, and in the said will, the testatrix and in the said will, the sons of the testatrix have been made as beneficiaries of the assets left behind by the testatrix. Full stop. The petitioners are the sons of the son of the testatrix. Full stop. Counsel for the petitioner submit that at present, altogether 6 legal years are available. Out of 6 legal years, 2 are the petitioners before this court who have prayed for grant of letters of administration, and the other legal years have filed their affidavit of consent stating that they have no objection for grant of letters of administration to the petitioners. Full stop. The counsel for the petitioners submit that the will is of 1968 and both the attesting witnesses also passed away, and as such it is not possible for the petitioners to bring the attesting witness before this court to prove the will. Accordingly, the petitioner has proved the will by examining one attending witness, namely
Konika Bala Roy.
Namely,
sorry, I'm a mistake. Yes. Konika Bala Roy.
ये रिपोर्ट दिया था ना
Konika Roy.
namely Kanika Roy. Namely Kanika Roy. K-A-N-I-K, Kanika Roy. Police. This said witness was examined on commission as per the order passed by this court. And in her examination, the said witness had categorically stated that the Kamla Bala Roy, the testatrix, was the fit state of mind and has executed her last will and testament in her presence and in presence of two attesting witnesses. She has submitted that full stop. In her evidence, she has identified the will, signature of the testatrix and the signature of the attesting witnesses. Full stop. As the said witness has identified the will, signature of the testatrix and the signature of the attesting witnesses. Accordingly, the will was marked as Exhibit A. Signature of the testatrix were marked as Exhibit A1 collectively, and the signature of the attesting witnesses were marked as Exhibit A by 2, A by 3, and A by 4 collectively. Full stop. Consider the submission made by the counsel for the petitioner. This could find that though the will counsel for the petition submit that though the will is of 1968, but the petitioners have filed the said application for grant of letters of administration only in the year when you filed,
My lord, this is
the year 2022, on the ground that in the meantime the executor appointed by the testatrix has expired. Subsequently, one of the beneficiaries has also expired. Full stop. And thereafter, the will was not traceable. And after getting the will from the petitioners have filed the present application. Full stop. Consider the submission made by the counsel for the petitioner. Peruse the original will as well as the translated copy of the will in English, affidavit of consent of all the legal heirs, affidavit of the attending witness and the evidence of the attending witness, the death certificate of the testatrix who died on 12/12/1986, death certificate of Manas Roy who died on 28 June 1994, death certificate of one Tapas Ranjan Roy who died on 9th August 2008. Considering the above, this court find that by examining the attending witness, this court find that the will was of 1968 and none of the attesting witnesses are available. And as such, the petitioner has examined the attending witness, and the attending witness in her evidence has categorically stated that the testatrix has executed her last will and testament in her presence by possessing good health and fit state of mind and in presence of the attesting witnesses. She has also identified the will, signature of the testatrix and signature of the attesting witness. Considering the above, this court finds that the petitioner has proved the case and is entitled to get petitioners and entitled to get the probate, entitled to get the letters of administration of the last will and testament dated 7th July 1968. Accordingly, the department is directed to grant letters of administration to the petitioners of the will dated 7/7/1968 upon furnishing surety of rupees 5 lakhs with 2 sureties. 5 lakhs with surety on compliance of all formalities.
5 lakhs jointly.
5 lakhs joint. 5 lakhs with 2 surety within bracket 2,50,000 each. 2,50,000 on compliance of all formalities. At the time of grant of probate, the copy of the will be made as a part of the grant letters of administration. Okay. PLA number 7 disposed of. Yes, next.
Lordship, I appear for the petitioner in this matter. This is an application for grant of probate of Honorable Justice Amrabu Sengupta, who was a judge of this honorable court.
Yes.
Lordship, Lordship, this is an application for grant of probate.
Correct.
And Your Lordship, in this, on the last occasion, 26 July 2024, directions were passed for issuance of general and special citation.
Correct.
The mode of service, Your Lordship, shows that out of all the legal heirs, one has returned unserved. If Your Lordship directs paper publication, then we can, Your Lordship.
Paper publication was not made.
No, Your Lordship.
General and
General
special
and
both has
special
been
citation.
given.
Lordship.
To whom it was not served?
Your Lordship, Jadab Dasgupta, that is party number 7.
Altogether,
There are
10 legal heirs.
10 legal heirs, Your Lordship. Lordship will find from paragraph 18 of the petition.
Jadab Dasgupta neither postal acknowledgement received nor undelivered packet. Party number 1. लिखते यार. Undelivered packet with postal remark DL. In respect of the party number 7. Neither the postal acknowledgement nor the undelivered packet was cited the party. For the cited party number 1 to 6 and 8 to 10. Yes, only one it is not delivered.
Yes, Your Lordship.
Where he is residing?
Lordship, number 7, Maniktola Main Road.
In Calcutta only?
In Calcutta.
So and so appearing for the petitioner. Counsel for the petitioner has handed over. No, counsel for the petitioner submitted in terms of the order passed by this court dated 26th of July 2024. The petitioner has taken appropriate steps for issuance of general and special citation. Accordingly, full stop. The petitioner has handed over the service report issued by the Deputy Sheriff of the Calcutta dated 28th of October 2024, wherein it revealed that notice were duly served to all the legal heirs except the legal heirs namely Jadab J-A-D-A-B Jadab Dasgupta. Full stop. Counsel for the petitioner prays for leave to publication of the notice for the information of Mr. Jadab Dasgupta in the English and Bangla newspaper. Accordingly, the petitioner is granted leave to publish the notice of this case in the English daily newspaper. Which paper? The Hindu?
Lordship, direct any English newspaper.
The Hindu and Bangla newspaper. What paper? Bangla newspaper?
Anandabazar.
Anandabazar Patrika. Or Sanma. Or this Vartaman.
Vartaman.
Vartaman. Full stop. The petition is directed to take appropriate steps. The report submitted by the petition be kept in the record. Yes, next.
I'm for the petitioner, my lord.
Huh?
I'm for the petitioner, my lord. My application for probate, my lord. It is a register will, my lord.
But your document,
yes,
your case file is not, case record is not traceable. Bear we for the 1 week. If it is traceable, if it is not, I will call for the report from the department. Then the reconstruction will be done. Your original will is also there.
Yes, my lord. Original will, my lord. 2 of the attesting witness, my lord. The advocate.
Let the matter, so and so appearing for the petitioner. Let the matter appear on 24th January 2025. Come on, 24th?
Yes.
बोल देना अगर नहीं मिलेगा कि रिपोर्ट दे दे। लेकिन ओरिजिनल विल है क्या करेंगे? Yes, next.
Lord, we have filed an application here, Lord. We have paid for letter of administration since no Lord, in this will, no executor has been appointed. Now we have filed an application in this Lord for inventory of 2 lockers. Inventory has been completed and the inventory report has been submitted. In the inventory report, Lord, it is found that there are some certain ornament and there are documents, Lord.
What application you filed? GA3?
GA3, Lord.
So what you want?
Lord, the
You want to bring
ornament
the,
mainly
you want
belongs
to amend the affidavit of assets?
No, Lord. The ornament mainly belongs to the wife of the testator, Lord. So we want that the ornaments may be released to the wife of the testator. I think they will not have any objection to that.
You are appearing for?
I'm appearing for the Caviatrix one daughter.
Daughter. Wife of the testator is alive?
Yes, my lord.
You are appearing for
She's
them
an
now.
aged lady, Lord.
She is an aged lady.
And she has also given consent.
So this is not the affidavit of assets with regard to the gold ornaments. It's not the part
No,
of the
it is
affidavit.
not in the affidavit of assets, Lord. Because it was in the locker, not so it could not be found.
These are all Sridhan, my lord. All
They are all
belong-
Sridhans, Lord, and that is an admitted fact, Lord. All belonging to the wife, Lord. So that may be released to the wife, Lord, without.
So how the wife will come? Who is appearing for the wife?
I am appearing for the Caviatrix. If necessary, I can appear for the
That is better. You did better. You come with the wakalatnama.
my lord.
Come with the wakalatnama or sort application.
Lord, we have given a
because they are asking. The court sumoto cannot. You file an application GA in terms of this. You have you the copy to have.
Special officer is there, Lord. So it
He
may
has
be
been
released to the.
He
has been discharged.
He has been
Another special officer may be appointed.
That's why let them come. Let the mother come.
Mother may not come, my lord.
Mother may not come, Lord. See the aged lady, Lord.
Aged
This is the
lady and
problem.
very much ailing, very much suffering. She's practically bedridden.
So.
And she has given a consent to the entire process, Lord.
Consent, my lord.
He consent this with regard to the will. With regard to the ornaments, what is the ornaments? It is the value.
List we have made.
List has been given by the special officer.
My lord, I was present at the time of the inventory. Whatever ornaments was found there inside the locker of UCO Bank all belong to the mother. That is admitted fact. Now they have made this application with some multiple prayers. Amongst one is
Another is not the LIC policies are there, Lord. Now, mainly the LIC policies they are in the name of the nominees are also specified in the LIC policies, Lord. Mainly the wife name is there, Lord, which may be released in favor of the wife, Lord.
So that's why, sir, see, you will say release in the favor of the wife, and this is now it has come as a court property. The court has to take precaution of that.
Yes.
If I will pass an order, release, and this will not be there. Let anybody, it is not necessary she should come in person. Let she appear through an advocate. You serve the copy to them. If they file an application for release in our favor, then I will
serve a
release.
copy upon the mother, upon the wife.
Let something is come on record. We don't know in between the court and the house of the house
That
of the
I will
mother
do. That I will do.
where it will go.
That will be better, but I will do that.
That will be better.
That will
Either
be better.
you do one thing regarding this, you forward it to the wife
Yes.
by a letter, and the wife will engage any other advocate, or you will.
As per our choice. As per our choice.
as per her choice. That will be done, my lord.
So these are the gold ornaments and the
LIC policies
My,
are there.
my lord, there is one policy which is in the name of his son, Dhrubajyoti Roy, who has already
Who is
passed out.
predeceased.
Passed away.
Yeah, yes,
But
my lord.
his
So
nominee-
his nominee is now this nomination is no longer valid, my lord. In that case, this all the legal heirs are entitled for that amount of that policy, not only his son.
So that will be decided in the probate.
My lord.
That at this stage it cannot be. Only with regard to the mother, wife.
And one policy is there in the name of the applicant of this particular, that is the grandson. That may be released.
No. You have to include in the affidavit of assets.
Yes.
You have to include first. See, by sitting here, I cannot give advice to you. You have to amend your application along with the affidavit of assets.
My lord.
My lord, one prayer, my lord. These ornaments should not be included in the affidavit.
No,
of
that's why.
assets.
Not with regard to what he wanted. If he wants anything, then he has to include in the affidavit of assets. If he didn't want to include that, then I will pass a appropriate order. So and so appearing for the petitioner. You are appearing for the cavator.
Caviatrix.
So and so appearing for the cavatrix. Full stop. Counsel for the petitioner submit that in terms of the order passed by this court, the locker available which bank?
UCO Bank, my lord.
Two lockers are there, my lord.
My lord, the State Bank locker, it
There
contained
was
only
nothing.
100 rupees note.
There was nothing.
The locker available in the UCO Bank which branch?
That is
UCO Bank.
Shaurapuli branch.
Shaurapuli branch.
Hooghly.
District Hooghly. Hooghly. What about the other?
State Bank of India branch.
Where is that? Where is that? Which page?
Mankundu branch, my lord.
Where is that? In
That is
your
also in
application?
Mankundu. Page 3, my lord, paragraph 6. The numbers and details are given.
And another locker available in the State Bank of India. State Bank of India, Mankundu branch, were open in presence of the special officer appointed by this court. And in the locker of State Bank of India, only 100 rupees.
100
My lord.
Where you mention?
It was mentioned, my
It has been mentioned in the application as well as in the report also.
Only 100 rupees was found, and the locker available in the UCO Bank,
Paragraph
being
9.
locker number 72/2, 72/2, in the said locker, gold ornaments as well as LIC policies were found.
And certain deeds also.
Certain deeds
And
also, my
certain deeds and LIC policies, gold ornaments and certain deeds were
and
found.
some other valuable materials also.
What are the materials?
Some gold coins and medals.
And gold coins as well as medals, as well as medals were found. Full list of counsel for the petitioner submit that the gold ornaments. What about the gold coins? That will be given to the mother. No.
That will be included
The
in the
counsel
list
for
of
the petitioner submit that the gold ornaments is the Istridhan, and as such the gold ornaments is to be returned to the wife of the testator.
My lord.
Wife of the testator. Full stop. Counsel for the petitioner submit that the wife of the testator, being the one of the legal has already given the consent, and as such the gold ornaments be released in favor of the mother. Full stop. Consider the submission made by the counsel for the petitioner. This court find that the mother has not come forward for release of the said gold ornaments. This court is not known whether the said whether it was informed to the mother of the testator that the gold ornaments were found in the locker of the testator, and as such it would be proper that the petitioner would be directed to send the report of the special send the inventory made by the special officer while opening of the report of the locker of the UCO Bank as well as the State Bank of India to the mother of the testator, and on receipt of the same for the information of the mother of the testator,
Wife of the testator.
wife of the testator, State Bank of India, to the wife of the testator for the information of the wife of the testator so as to enable her, if she is interested to get this gold ornament back, comma, then she can take appropriate steps for release of the said gold ornaments.
My lord, she has to be represented by
Gold ornaments. In view of the above, the petition is directed to send the copy of the inventory to the wife of the testator, informing about the available of the gold ornaments in the locker of the UCO Bank within a week. Within a week? Within a week from date. Within a week from date, and to file affidavit of service on the returnable date. The wife of the testator is at liberty to take appropriate steps for release of the said gold ornaments.
my lord.
Let the matter appear on.
My lord, regarding the other prayers, it is to be considered.
Let the matter appear on 28th of January 2025.
Grateful.
Next.
This is my probate application, my lord. They have filed a caveat, and pursuant to your lordship's order on the last occasion, my lord, they have filed the affidavit of caveat and they have served us. Now this application has to be converted into a testamentary suit and the caveat has to be discharged, your lordship.
Have you filed the caveat affidavit in support of caveat?
Yes, yes.
So suffering for the petitioner, so suffering for the caveator, full stop. It is submitted that the caveator has caveator or caveatrix? Caveator?
Caveator.
Caveator has filed the affidavit in support of caveat after serving the copy to the learned counsel for the petitioner. Full stop. Now the caveat affidavit of caveat is on record. Thus it is to be treated as a contentious cause. Full stop. Department is directed to assign the testamentary suit number within a week from date. Please the matter on 29th of January 2025.
Grateful.
My advocate on record has a surgical procedure in his eyes. If it can be taken up on February, for which he has some difficulty.
No, only testamentary let come, then I'll pass an order for inspection on all these things. Presence is not required.
That's my duty.
The document and inspection and documents all required and the framing of issues. Next.
My lordship, this is my application. My lordship, by an order dated 26th July 2024, there was an directions for general citation and special citation, my lordship. After that, we have obtained a report from the office of the sheriff, my lordship. No such person is found at the address, my lordship. I'm praying for directions for notice to be published in the newspaper, my lordship.
Where is the report?
My lordship,
have you obtained report?
Yes, my lordship. With an annex to the page 6 of the application, my lordship.
You filed the application?
Yes, my lord.
Master Saman?
Yes, my lord. Page 6 of my GA1 application, my lord.
On the record as per the instruction of advocate on record, census speed post due to the one undelivered packet with the postal amount, no such person address in cited name. What about the Sarif report? What about the personal service? No.
No, my lordship, this is a service which is to be
So offering for the petitioner. The petitioner has filed the present application being GA1 of 2024, praying for gist of the special citation. So it should be published in the filed an application praying for leave to publish the gist of the citation in the English and Bangla newspaper, as the citation could not be served upon the legal heir.
Yes, my lord. She's the daughter of the.
Only sole legal heir.
No, my lordship. There's two daughters, my lordship. One of the daughters has given consent.
Only this.
Yes,
upon
my
the
lord.
legal heirs, namely Nini.
Biswas.
Nini Biswas.
Yes, my lord.
Upon the Nini Biswas. Full stop. Consider the submission made by the counsel for the petitioner. Prayer A of the master summon is allowed. G8 2020 disposal.
Great match.
Yes. Yes.
I'm led by Mr. Rachit Lakmani, who will be appearing virtually, my lord, in this matter.
Which was the plaintiff?
On last occasion, plaintiff sought for time.
Examination in chief is deferred. Anjit Mukherjee.
Apologize, my lords. I appear for the plaintiff. The witness is here, my lords.
What's your name, sir? Manish Babu. M-A-N-I-S-H B-A-G-R-I.
So keep resume, huh? Keep resume.
The lordships, kind leave, may I show the witness three documents which are already tendered? Few questions on the same, my lords. Exhibit C type to the hand. My lords, I'm showing the witness Exhibit C, which is appearing in my lord's judge's brief at pages number 3 and 4. And corresponding question is question number 42. The 42 question number 2. PD3, man. 42. Question number 42.
Page number?
Page number 3. Page number 3 and 4. The exhibit number C. Mr. Bagri,
yes.
Showing you exhibit number 3, exhibit C.
Yeah.
So tell me, what is the document?
This is the e-way bill.
Kindly see the answer.
E-way bill. Dash way bill.
Mr. Bagri, kindly see your answer to question number 42.
Yes.
What have you done after downloading the document?
I had downloaded the document and then I have printed it with the computer. I've downloaded it with the computer in my computer. In my working printer in my office.
Mr. Bagri, what have you done after printing the document?
I compared it with the material sold and the invoice.
Sold and with the invoice, yes, slowly.
After, then I took a printout of the same and gave it to the client along with the invoice.
Mr. Bagri, in question number 42, you have said you have downloaded this document.
Yeah.
Then you have printed this document.
Yes.
What have you done after printing the document? E-way bill.
After printing the e-way bill, I had compared it with the invoice.
I'll show the
and handed it over to the customer along with the invoice.
I'll show the next document. With my lord's leave, can I show the witness exhibit D, which is the test certificate? It's in page 6 of my lord's judge's brief of documents. Right. I'm showing Mr. Bagri. I'm showing you exhibit D. Can you tell me what is the document?
This is the Xerox copy of the test certificate.
How did you obtain the document?
The original document or the Xerox?
The Xerox copy.
This one.
This document.
I had done the Xerox from the original documents, and I saw that this is the original replica, and saw that this is the original replica of the original, and got it Xeroxed, and then we signed it and handed it over. Then I signed it and handed it over to the customer.
Speak slowly so that we can write.
My lords, I'll come to the next document. Few of the documents. Last the document is last document is exhibit C. Exhibit. Last document is letter. Letter. Document number to document F. My lords, I'm showing document F, which will be there in my lords judge's brief of documents, page 16.
Exhibit F. Huh?
Exhibit F. This was tendered and was question 75. This was going on the last occasion, my lords.
Yes.
Kindly tell, Mr. Bagri, kindly tell the court what is this document?
This is the official, this is the original office copy of the letter.
Kindly come to page 2 of the document. Do you find any signature?
Yes.
Mr. Bagri, kindly tell the court whose signature this is.
This is my lawyer's signature, Mr. Amit Sharma. Amit Sharma, Advocate Amit Sharma.
Amit Sharma.
Mr. Bagri, kindly tell the court, how do you know this is the signature of Mr. Amit Sharma?
Mr. Sharma has signed it in front of me. Earlier also he has signed, and I have seen him signing in several documents in various occasions.
Mr. Bagri, can you turn the page, come to the third page of the document? Lordship, this is
Yes.
page 18 of my lord's document, judge's brief. This is PD 13 as my lord's brief. Mr. Bagri, what is this document?
This is the tracking report of the speed post sent to the client.
How did you obtain this document, Mr. Bagri?
This was downloaded through the official website of Indian Post by my computer.
What did you do after downloading it, Mr. Bagri?
I compared it with the receipts, whether they are okay or not, and I handed it over to my lawyer. Before that, I took a printout in my working computer printer.
Before that, I took out a
Printout of the same with my working office printer.
This entire is bunches. Right? Open to that. Mr. Bagri, what do you say about the content of the letter?
This letter contains a true and correct.
Yes, next.
As I'm handing over these two may be marked together. This is PD 14 and 15 if my lord's brief, page 19 and 20. Handing the originals over. Hmm.
19 and 20.
19 and 20. Mr. Bagri, kindly tell the court what are these documents?
These are the original envelopes in which it's written refused. It's written refused by the director of the
Mr. Bagri,
company.
Can you find out who was the addressee, as in who was the letter sent to?
The letters were sent to the directors of Surya Electricals and Engineers Private Limited.
Mr. Bagri, how did you obtain these letters?
These were given to me by my advocate, Mr. Amit Sharma. He had shown it to me.
Humbly request that these letters be marked. These are originals. These be marked as exhibits, my lords.
What is the true court? What is the endorsement appearing in the said postal letter?
It says refused by the directors. Both the envelopes have said refused.
What is exhibit?
G, my
Exhibit G collectively. Yes, next.
Lordship will kindly come to the last document, which is PD 16 in my lord's brief, showing this document to the witness.
Shown PD 16, page 21.
Mr. Bagri, can you tell me what is the document that I have shown you?
This is the mediation report. Mediation report.
How did you obtain a copy of this document?
I went personally to the mediation center and got it from there.
Can you tell us, Mr. Bagri, what is the sum and substance of this document?
What is?
What is
What
is the sum and substance of the document?
The client means the director or the client, Surya Electricals and Engineers Private Limited, didn't turn up. For mediation.
And what is the nature of the document, Mr. Bagri?
This is the original copy of the mediation report.
Lordship will kindly take this
Exhibit
and mark this.
H. Yes, next.
So two more documents, the affidavit of evidence and the 65B.
Sure.
Kindly 65B type to the 65B.
Affidavit of evidence will not be exhibited. You
Not
can only
required. My lord, 65B at least.
65B show.
Copy may be given to us.
65B daini.
Not served.
Not served, my lord.
My down your copy 65B. They're saying it's served.
Show the service. Show the service.
The service. Show the service of 65B. Now, other side के service को key of the 65B. Lordship, on the last day it was served during the proceedings. Lordship had recorded. They've got a copy. It seems. Kindly. This is the 65. Kindly see what is this document, Mr. Bagri.
This is the affidavit under section 65B of the Evidence Act 1872.
Whose document is this, Mr. Bagri?
Pardon?
Who has affirmed this document, Mr. Bagri?
These are my signature over here.
You find your signatures in which page, Mr. Bagri?
Page number 4 of this affidavit.
Can you kindly encircle your signatures, Mr. Bagri?
The witness encircles read these. His signature in red.
Where have you affirmed this document, Mr. Bagri?
In front of the Commissioner, High Court. Calcutta.
What do you say about the contents of the document?
The contents of these documents are true and correct.
My lords.
Exhibit.
I.
Huh?
I.
No.
Yes. Anything?
My lords, nothing more.
That's all.
We are done with the examination of witness. Cross-examination may begin.
Yes.
Lord, I'm been led by Mr. Rachit Lakhmani. Today he's in certain difficulty, my lord. So I asked for another date for cross-examination.
You know, today is especially fixed.
Yes, my lord, I understand.
That
but
is the
he's-
problem.
But I thought my learned friend will take some more time
No,
to
There's
finish.
not much documents to show.
The deferrals had happened because I was humbling my own.
My lords, we shouldn't come in the way, but maybe one question can be asked for the formality purpose and then they may. If that comes.
I need to have a copy of the deposition as well, my lord. I don't have the copy.
You not file the written statement.
No.
Filed?
No.
No, not filed.
Only the cross-examination.
Only cross-examination is left.
When you will available?
I'm available any day post 16, subject to the convenience of.
You are available, sir?
आप उतर जाइए.
On? उतर जाइए.
Oh,
thank you.
Sense appearing for the plaintiff. Sense appearing for the defendant. Dependent witness is present for further.
Milord, I'm sorry, Milord, I represent the defendant, Milord.
Yes.
I've already indicated that you are in another court.
Milord, if your Lordship allows, I can ask one or two questions so that, Milord, we can continue on the next.
Now witness has gone.
Oh.
Stepped out of the witness box. Sense appearing for the plaintiff, sense appearing for the defendant. Plaintiff witness is present for further examination in chief, and during his examination, कितना document exam में हुआ? Three documents were marked as exhibit G, H, and I. G and J. The plaintiff witness is concluded. Police counsel for the defendant prays for time to cross-examine the plaintiff witness number 1. Accordingly, case is adjourned. Let the matter appear on 7th March at 3 p.m. for cross-examination of the plaintiff witness number 1.
Much obliged, my lord.
Grateful.
7th month. Grateful, my lord.
Next.
Adjourn motion item number 7. Item number 7.
Well, for the respondent, kindly pass it over, sir. Pass it over. Short pass.
Item number 8.
Pass over. Next. Pass over.
Item number 9.
My lord, I'm appearing for the respondent.
Item number? These are 9. Yes. Who is for the petitioner?
My lord, petitioner is not there.
Pass over. Next.
Item number 10.
My lord, I'm appearing for the plaintiff in item number 10. I beg to appear online. My lord, I'm praying for 2 weeks accommodation. My lord, Mr. Shah is leading me. There's a bereavement in the family.
Your lordship,
I'm
I
praying for
appear
2 weeks accommodation.
Attendance, petition, your lordship.
At least 2 weeks accommodation. My lord, there's a bereavement in the family of Mr. Shah.
As per the prayer made by the counsel for the suffering for the plaintiff, suffering for the defendant. As per the prayer made by the counsel for the plaintiff, the case adjourned. Let the matter appear on 5th of February 2025. No, the commercial, na?
Your lordship, commercial.
Yes, my lord.
7th of February 2025.
My lord. Grateful.
Undefended suit item number 11.
Please, your lordship. My lord, I am for the respondent because, my lord, I am a plaintiff in the matter. A petition has been filed under section 10, my lord, for stay of proceedings, which I am, my lord, defending.
Who is for the plaintiff? You are for the plaintiff. You are.
I am for the plaintiff, my lord. Mr. Tapan Kumar, they was appearing for the defendant. So, my lord, it is his application. Saurav Ganguly and Tapan Kumar, they, my lord, from 22nd November's order, my lord, I find that they had appeared. The point is very, very short. I can argue, my lord, and try and, my lord, dispel the kind of submissions that perhaps they'll come up with. Only one point, my lord, whether the previous suit, my lord, I'll indicate what the premise of the matter is. If they come in between, my lord. Very briefly, I'll indicate. It's goods sold and delivered and money not received.
Yes.
That's my plaint.
Yes.
My lord, their plaint prior in point in time filed before the, my lord, city civil court is a very interesting, my lord, plaint. They filed because they apprehended, my lord, that we are coming up with a plaint. We'll make a challenge to, my lord, their illegal action. Now, the challenge that they have made is that these transformers, when they received, they were faulty transformers. So they sent it for repairs. The repair amount, an imaginary amount without any documentation, that repair, this much amount was spent in the repair. So their case is this, my lord, that we gave them the goods for which they did not make the payment, admitted. They say we don't need to make that payment because after we received, we realized that the goods were not proper. So we sent it for repairs. We have incurred this much expense in the repair. So this, from the amount which we were required to give, minus the repair cost and the damages, is what we now claim. So the damages they have quantified unilaterally. Unilaterally without any. So it's interestingly, my lord, it is not a special damage. It's a general damage which they have quantified in the plaint without any documentation, saying that this is the amount. They have raised the amount in the manner that they don't have to make that payment to us. And they say this is the claim, this is the prayer in the plaint. That's their plaint case in the city civil court. For us, my lord, the pecuniary.
What is the prayer in the city civil court?
It's a money suit, my lord. They say that after deducting the repair cost from the amount which we were required to give, which we have not given, after deducting the repair cost was much more than the goods, plus the damages, it comes to a sum which is around 12 lakhs odd, which is
from you.
So, my lord, recoverable from us. Our case is very simple. We have given the goods, we are not getting the money. That's our plain case. Now, the section 10 is because, my lord, they have filed that before. But, my lord, my only answer to the section 10 case is this. My lord, pecuniary jurisdiction for our claim is much more, my lord. We could not have gone to the city civil court. So, the only test at this stage, which is required to be gone into by this honorable court, is if that suit is decided, whether that will tantamount to a res judicata in my suit. That's all, my lord. I will show from one judgment, there are numerous, that if that particular court has no jurisdiction to adjudicate the dispute, then by itself, my lord, there will be no res judicata. If there is no res judicata, then section 10 has to fail. That's all, my lord. I'm just waiting if they make that submission.
If that court is not having jurisdiction, that is different thing.
That's different. That court does not have the pecuniary jurisdiction. That's why commercial division of this court.
It is your case.
That's my case.
But their case is not.
Their case, and also, my lord, this is my second point. My first point is also that the premise of the two suits are very different. My premise is I've given you goods, I need money.
Correct.
Their premise is, yes, we have received the goods. Yes, we have not paid. Admission there. Yes, we have not paid. But upon receiving the goods, we found that the goods were not proper. We sent it for repairs. The amount is more than the goods. So now you have to give me money. That's the premise. So the premise are different. One Supreme Court judgment, I can indicate it, but I need to see, my lord, what they are submitting.
Correct.
Only one decision which I'll rely on, which says the entirety of the matters in issue should be the same. Part of, my lord, the case, if it is same, that is not, my lord, a section 10 case has to fail there. And also in the same judgment, my lord, it has been decided that whether the other court will have jurisdiction is a very important factor, because if the court does not have a pecuniary jurisdiction, then that will not tantamount to a res judicata in my case.
Why you are telling the pecuniary jurisdiction is the city civil court is not having?
But because it's much more, my lord, than the limit. My lord, in our case, my lord, we have prayed for 2 crore 90 lakhs. So, my lord, city civil court will not have the pecuniary jurisdiction.
Which division? Senior division? They have filed?
But they have filed, my lord, in. Kindly give me a moment.
Division.
7th bench, my lord.
7th bench?
7th bench of the city civil court.
Senior division?
Senior division, my lord.
So
it's for
senior
12
division,
lakhs, my lord. Their claim is.
What is the notification of the senior division? It is unlimited.
It is not unlimited, my lord.
Not un
1 crore, my lord, till 1 crore. So we have, my lord, 2 crore 90 lakhs, and they have a claim of 12 lakhs. So in fact, my lord, we could not have filed it in the commercial division. Also, my lord, we have stated it's a commercial dispute. So there is no commercial division in the city civil court, my lord, so we could not go in that court. So either way, my lord, that court will not have jurisdiction, and that will not tantamount, if it is decided, that will not tantamount to a res judicata in this matter. That's the only prayer. So I'll indicate that one judgment, and perhaps they will not be in a position to meet that challenge. And
the pecuniary jurisdiction is the 1 crore and 2 crore.
That's the only factor.
Regarding the commercial.
And that one, and also a commercial dispute, my lord, so they cannot really.
So how they filed before if it is also
They say it's not a commercial dispute for them. For them, my lord, it is, we have given for repairs. The expense is much more than the amount which we were required to pay for the goods. Hence, my lord, they have nullified it and then they made a claim. Very interesting there, my lord.
Okay, pass over. Let us see.
Deeply obliged.
So why Acha, they filed an application. Okay.
They filed an application, my lord, section 10.
GA3 नहीं है. नहीं है.
The previous, my lord, one more day, my lord, they had not
No,
they had not
GA3 is
appeared.
not on record. You filed affidavit, no?
They filed affidavits, my lord.
No, GA3, you have filed affidavit.
I have filed. We have filed, my lord, the opposition. They filed the reply, right?
Opposition.
They filed the reply, my lord.
Aye. Okay, I am adjourning it as the record has not come.
Lordship.
So and so appearing for the plaintiff. None appears on behalf of the defendant. Defendant had filed an application being GA3 of 2023 under section 10 of the Code of Civil Procedure for stay of the proceeding of the present suit. Full stop. It is fine. The record of GA3 of 2023 is not placed before this court. Accordingly, the department is directed to place the record of GA3 of 2023 along with CS Com 338 of 2024 before this court on the next date fix. Let the matter appear on 28th.
Deeply obliged. 20 instead of 28th, my lord, any other day, my lord. 28th, I'm not in town, my lord.
31st.
Deeply obliged, my lord. Deeply obliged. They filed the affidavit in opposition, my lord.
Record is not here. Come
Lordship.
on that.
Deeply obliged. 31st.
Yeah.
Oh, I'm so sorry, my lord. 31st, my learned junior is in some difficulty. Any other day, my lord. I'm so sorry.
7 तारीख कर दो.
February, I'm very deeply obliged.
7 March. 7 February. Yes.
7 February. I'm very deeply obliged.
Next.
My lord, I'm appearing on behalf of
defendant, my
the
lord.
plaintiff in a suit, my lord, which has been dismissed. The application is for restoration. Well, by your lordship's last order, your lordship, my lord, wanted us to, my lord, expunge a paragraph, that is paragraph number 12 of the application, through a supplementary affidavit. We have served a copy of the supplementary affidavit. May I kindly, my lord, be permitted to file the supplementary affidavit?
My lord, that incorrect statement was made on oath, my lord.
So they are not.
Yes. So, my lord, the order through which, my lord, the suit was dismissed is dated November 22, 2024. It is at page 15 of the application, my lord.
By this court?
Yes.
Not by this court.
But unfortunately, paragraph 10, which gives the reason, which is, my lord, the advocates were not available on that day, it incorrectly states that it's an order passed by Justice Arindam Mukherjee. It should have been, my lord, order passed by your lordship. The order is at page 15.
Yes.
But one thing, my lord, the reason, my lord, that has been stated, my lord, is insufficient. My lord, the reasons that has been stated, my lord, is, my lord.
Record. So and so appearing for the plaintiff, so and so appearing for the defendant. Full stop. The plaintiff has filed supplementary affidavit praying for expunging the averment made in paragraph 12 of GS6 of 2024. Full stop. Consider the submission made by the counsel. Full stop. Consider the submission made by the counsel for the plaintiff and the averment made in the supplementary affidavit. The averment made in paragraph 12 of the GS6 of 2024 is hereby expunged. Full stop. Full stop. The counsel for the plaintiff has filed the present application being GS6 of 2024, praying for recalling of the order passed by this court dated 22nd of November 2024, wherein this court has dismissed the suit for default. Full stop. Counsel for the plaintiff submit that the advocate on record of the plaintiff was on the way to this court when the matter was called but could not reach before this court, and accordingly, and in the meantime, this court has dismissed the suit for default. Counsel for the defendant raised objection and submitted that the plaintiff has not shown any cause as to why the plaintiff has not appeared before this court when the matter is called, and prayed for rejection of the present application. Had the learned counsel for the respective parties perused the application, this court find that sufficient cause has been shown for non-appearance of the plaintiff on the date fixed when the matter is called. Accordingly, the order dated 22nd November 2024 is recalled. Full stop. CS and GA number so and so is disposed of. CS 352 up to CS com 352 of 2024 within bracket old CS 251 of 2021 is restored in its original file.
My lord, now that the suit has been restored, my lord, in presence of my learned friend, may I make one humble submission? My lord, the written statement has already been filed. And well, if your lordship would be pleased, my lord, to pass directions for discovery and inspection, it would only expedite the suit.
As the suit is restored, counsel for the plaintiff submitted as the suit has been restored and the defendant has already filed written statement and paid for a direction for completion of discovery and inspection of the document. In view of the submission made by the counsel for the plaintiff, counsel for the respective parties are directed to complete the discovery and inspection of the document within 3 weeks. 2
Lord,
weeks.
kindly make it 1 week, 1 month, my lord, because
Why?
my advocate on records, mother has died, so she will
Within
be
4
joining.
weeks from date. Full stop. Affidavit of admission and denial of the document be filed within a week thereafter. In the meantime, the parties are also directed to exchange their suggested issues. List the matter on 24th of February 2025. No, 28th of February 2025 for framing of issues.
Deeply obliged.
Next.
My lord, I am appearing for the plaintiff in this matter. My lord, we have received a service report from the sheriff's office showing that all the defendant had 3 places of business in the city. They have closed
all 3.
All 3. Now that's why the summons could not be served. We are trying to find out their
Where is the
present.
service report?
My lord,
Three duplicate attempted upon the defendant. The address could not be served as the defendant was not found at the address mentioned in it. Undelivered packet with regard to ACNL is returned to sender.
Yes,
1
my
and
lord.
2 address.
We
And
had
undelivered
personally-
packet of
we had also personally inquired. They have closed all 3 offices.
So
Now
what
we are
you want?
trying to ascertain their new place of business, whether it's within the jurisdiction or outside the jurisdiction. Meanwhile, this matter be adjourned for some time. We will try to trace their new place of business and amend the plaint, my lord.
so appearing for the plaintiff. The counsel for the plaintiff has handed over service report dated 10th of September 2024, wherein it reveals that in all the 3 addresses of the plaintiff of the defendant, the defendant could not found. As regard the postal services also, the undelivered packet return unserved. Full stop. In view of the counsel for the plaintiff press for time to take appropriate steps to ascertain with regard to the new address of the plaintiff defendant. In view of the submission made by the counsel for the plaintiff, the case adjourned, let the matter appear on 10th of February 2025.
Much fully name.
Yes.
This is the suit filed by the plaintiff, my lord, for recovery of the price of goods sold and delivered to the defendant.
For recovery of
Money, price of goods sold and delivered.
price of goods sold and delivered. Yes. Then
Some writ of summons was served.
Hmm.
The report was filed. Did not turn up.
Okay.
Evidence was adduced by the PW1, my lord. If you if you come to the plaint, my lord. Come to plaint, my lord.
What is the case about?
About price of goods sold and delivered.
Yes. What is the your fact? What is the fact?
Fact in the I did not make the payment, my lord. I sold the total delivery of goods 33,61,939, my lord.
What are the goods?
Processed oil. Processes oil.
Yes. Then
evidence was used. Exhibit A is the trade license, my lord. That is page list. Affidavit of judge's brief is there, my page 6. This is my trade license, my lord.
trade license.
Yes, ma'am. That is page 6, my lord, the judge's brief.
Judge's brief fine. Page 6.
Page 6, my lord.
Yes.
After that, my lord,
This was exhibited.
Exhibited, my lord.
Exhibit
A.
Yes. Then
exhibit B, my lord. That is challans. That is from page 7 to 25. Exhibit B.
7 to 25. 7 to 25.
Yes, 7 to 25, my lord. Then exhibit E, that is also challan. Page 57 to 63. And then challan exhibits H, page 78, my lord.
78.
Yes, my lord.
Yes. These are the challans.
This is the challan, delivery of the goods.
Delivery of goods.
Yes, my lord.
Correct.
Then come to annexure C, my lord. That is bills. Bill. Can we invoice or the bill?
Tax invoice.
Yes, my lord. That is page 26 to 44.
26 to
44, my lord.
44. Yes.
Then exhibit F, page 64 to 70. Then 79, my lord. These are the bills.
Correct.
Then e-way bill are there. When the goods is to be dispatched, e-way bill is taken from the GST.
Why e-way bill?
That is, my lord, annexure D. More than 1 lakh. Value is the more than 1 lakh, my lord. That is exhibit D, page 45 to 56. Then page exhibits G, 77 to 77. 71. Then exhibit J, page 80, my lord. This is the documents. Then demand notice is there, page 81 to 83.
So what is the total amount? What was the amount total?
Total delivery was 33,61,939.
Total amount.
Total amount. Out of that, the defendant paid a sum of rupees 26,22,974. And you come to paragraph.
26 lakhs he has paid.
26 out pay.
When he has paid?
The different dates are paid.
As per the notice what amount you have claimed for?
Claim, you are noticing claimed 81. 33,61,939. Come to that is page. No.
33 lakhs.
Yes,
And what was the total cost?
Total cost was 59,84,913, my lord.
59 lakhs?
59,84,913. 913.
913.
This is the total price in 3 years, my lord.
Correct. Out of which how much amount he has paid?
26,72,974. 26 lakhs.
59 lakh was the total.
Total 59.
How much amount he has paid?
26 lakhs.
76 lakh.
26 lakhs, my lord.
26 lakhs. 26 lakhs.
72,000.
72,000.
974.
974.
22,000.
72,000 paid.
26. 22.
26, 72,
No,
974.
22. 22. 22. 974 million.
Paid.
Paid, my lord. Remaining.
Remaining
33 lakhs.
33 lakhs
61,939.
939. So this is a claim.
This is my claim. Apart from the interest.
Notice was received.
Yeah, notice was received, my lord.
What has happened?
They did not reply, my lord. Then I approached to the mediation. I get turn to page 84, my lord.
84?
Yes. $84, my lord, page 84.
Yes.
Of the judge's brief. They disputed it.
क्या है उनको क्या बोलना क्या है?
They stated business manufacturing rubber based, that was not the quality according to them, my lord. And substantial loss, that is nothing else. Page 84, my lord.
Yes, then
I approached to the mediation, my lord. That mediation annexure. Page 91, my lord.
What is the 91?
Page of the judge's brief, my lord.
What is 91?
Report of
Mediation
the
report. Okay, no problem. Yes, anything further?
No.
Any further?
No, my lord. They agreed to make the payment, but they did not make the payment.
Where?
And the last paragraph, reason for failure.
Respondent appear before the and agreed
Initially,
to
the
pay.
respondent appeared before the mediator and agreed to pay. Thereafter, he failed to appear in the subsequent dates, my lord.
Okay. That's all?
Yes, ma'am. That I pay for the degree, interest, till the realization and the cost of the suit, my lord.
So and so appearing for the plaintiff. None appears on behalf of the defendant. Para-wise jayega. The plaintiff has filed the present suit, praying for a decree for a sum of rupees 33,61,939 along with interest at the rate of 24% per annum. Full stop. Number next. The plaintiff says that in between 1st April 2020 to 31st of March 2021, defendant has placed diverse orders for supply of
Processing oil, my lord.
process oil, PROCESS, process oil to the defendant. And as per the demand made by the defendant, the plaintiff has supplied the said materials by way of challan, which was duly received by the defendant without any objection. After supply of the process oil, the plaintiff has raised invoices which were also received by the defendant from time to time. Full stop. Number next. The plaintiff says that the plaintiff has supplied the total material for an amount of rupees 59,84,913, out of which the defendant has paid only 26,22,974, leaving balance an amount of rupees 33,61,933. Number next. Paragraph, huh? Paragraph 1, 2, 3, 4 जाएगा. Then the counsel for the plaintiff submit that as the defendant failed to pay the balance amount of rupees 33,61,939, the plaintiff had issued a legal notice to the defendant, calling upon the defendant for payment of the balance amount. But in spite of balance amount, full stop. On receipt of the said notice, defendant had sent a reply denying the claim of the plaintiff. Accordingly, the plaintiff had initiated pre-mediation process, pre-institution mediation process, and in the mediation process, initially the defendant had appeared and agreed to pay the amount, but subsequently the defendant failed to pay the said amount, failed to appear before the mediator, and on 19th of June 2023, a non-starter report has been filed by the mediation center. Non-starter, NON-START, starter report has been filed by the mediation center. And accordingly, the plaintiff has instituted the present suit. Full stop. Number next. After filing of the suit, the plaintiff has taken appropriate steps for issuance of writ of summons. In spite of receipt of the writ of summons, the defendant failed to enter the appearance or also not filed any written statement. Accordingly, in terms of the report of the deputy registrar, this court has placed the matter in the list of undefended suit. Full stop. Number next. To prove the case, the plaintiff has examined one witness before this court, namely Anjani Saraf, ANJANI, Anjani Saraf. And during his evidence, altogether, how many documents have been exhibited?
Total exhibit, my lord.
Altogether, 15 documents were marked as exhibit, being exhibit A to exhibit O. Full stop. Counsel for the plaintiff submit that the plaintiff has exhibited the challans which were marked as exhibit. Plaintiff has marked one document being exhibit A, which shows that the plaintiff. What is the exhibit A?
Exhibit, that is exhibit trade license, my lord.
Which is the trade license of the plaintiff. Full stop. Exhibit B, exhibit E, and exhibit H. Exhibit B, exhibit E, and exhibit H are the challans which proves that the plaintiff has supplied the process oil to the defendant and defendant has received the said oil. Full stop. Exhibit C,
F and I, my lord. F and I.
C, F, and I are the documents with respect of the tax invoices raised by the plaintiff against the defendant for the goods supplied to the defendant, and the said the same was duly received by the defendant. Full stop. Exhibit D, Exhibit D and Exhibit G are the e-way bill.
My lord, D, G, and J.
D, G, and J are the e-way bills which proves that the plaintiff has transported the goods to the address of the defendant Full stop. The plaintiff, full stop. The notice which the plaintiff has sent to the defendant dated 20 July 2020, 20 June 2022 and 20 July 2022 are marked as exhibit. No, 1 minute. The legal notice sent by the plaintiff to the defendant dated 3rd June 2022 and 22nd June 2022 are marked as exhibit M and L. And on receipt of the said notices, the defendant had sent the reply dated 20th July 2022, which is marked as exhibit N. From the said document, it proves that the plaintiff has called upon the defendant to pay for payment of the amount dues, but in the reply, the defendant has denied the claim of the plaintiff. Full stop. The mediation report is marked as exhibit O, wherein it reveals that the defendant had initially appeared before the mediator and agreed to pay, but subsequently the defendant could not appear. Full stop. Full stop. Number 9. This court finds that the plaintiff has received the copy of the plaint and the document, but in spite of receipt of the same, the plaintiff has and the defendant choose not to appear before this court and also not file any written statement. Full stop. The plaintiff in the evidence has produced all the documents to prove that the plaintiff has supplied the materials as demanded by the defendant, and on receipt of the materials, out of the total amount of rupees 9,84,913, the defendant has paid only 26,22,974 by keeping the balance amount of rupees 33,61,939. 939. So number 9. Considering the above, this court find that the plaintiff has proved the case and the defendant is liable to pay the amount of rupees 33,61,939. Full stop. When the last payment was made?
8th April 2022.
Full stop. It is fine from the record. The last payment was made by the defendant to the plaintiff on
8th April 2022.
8th April
2022, my lord.
8th April 2022.
That is paragraph 15, plaint me.
8th April 2022, and thereafter the
Page 9.
defendant failed to pay the balance amount of rupees. Full stop. As per the invoice, tax invoices, as per the terms and conditions of the tax invoices, it is mentioned that inward comma, interest will be charged at the rate of 24% per annum if the bills is not paid on due date. Full stop. In the present case, it is admitted that the defendant has paid only part amount, leaving aside the balance amount of rupees 33,61,939 after 8th April 2022. And as such, the plaintiff is also entitled to get the interest, not for 24%, only 18% per annum. Full stop. In view of the above, the defendants are defendant or defendants?
Defendant mean only one defendant.
Defendant is directed to pay the amount of rupees 33 lakhs 61,939 along with interest at the rate of 18% per annum from 8 April 2022 till the date of realization.
And course, my lord, of the suit. I spent the court fees time.
As the suit is of the commercial in nature, full stop. The defendant has received the notice, but in spite of receipt of the notice, the defendant failed to appear before this court or to file written statement. Full stop. Full stop. For recovery of the amount, the plaintiff had to approach this court. Thus, the plaintiff is entitled to get the cost against the defendant. Accordingly, the defendant is directed to pay the cost of rupees 1 lakh. 1 lakh within a period of 1 month from the date of this order, failing which the said amount also carry interest at the rate of 6% per annum till the realization of the decree. CS number CS com है ना?
Com, my lord.
CS
Com 428
of 2024 within bracket old numbers 229 of 2022 is disposed of. Decree be drawn accordingly.
I am assured.
May I please, your lordship? My lord, I appear for the plaintiff in this matter. This, my lord, is an undefended suit for price of goods sold and delivered. My lord, the plaintiff is a sole proprietor of a proprietorship firm engaged in the business of knitted, crotched, and woven fabric. Engaged in the sale of knitted, crotched, and woven fabric, my lord. Now, the defendant approached the plaintiff sometime in 2019 for the purpose of buying the products so sold by the plaintiff herein, my lords. So verbal agreement entered into between the parties that goods would be sold contemporaneously upon verbal orders being placed upon the plaintiff and payment to be made within 90 days thereof, my lords. I'll show from the ledger that initially the defendant complied to the terms that was agreed upon between the parties and then eventually started defaulting, my lords. So on and from January 2019, parties started transacting between one another, wherein the plaintiff used to sell products for price value of money upon the defendant. Now, my lords, your lordship will, this is a note that I have prepared for your lordship's kind convenience, my lord. There are 26 invoices that were raised during the period of 3rd June 2019 up to 10th October 2019, my lords, cumulatively amounting up to rupees 11,30,307, my lord. Now, what's happened is that if your lordship will kindly have page 1 of my judge's brief of document, that is Exhibit A, my lord. That consists of the ledger that is there of the defendant maintained by the plaintiff, wherein your lordship will find that initially your lordship will see the first transaction that is there, 22nd January 2019 sales of amount 49,000 odd rupees. The next transaction receipt of that amount. Similarly, 16,000 and 43,000 cumulatively received that amount 60,000. Then 62,759 received. Or this went on, my lords, up to 3rd June 2019, wherein the price of such invoices started remaining outstanding, my lords. So your lordship will first, I'll take your lordship to the invoices that are there, page 268 of the judge's brief. This is Exhibit C, my lords, at volume 2. 268, my lord. 268 up to 293, my lords. These are the 26 invoices that remain due and outstanding, my lord. 268 to 293, my lord. This is Exhibit C, my lord. 293. Volume 2 of the judge's brief. Exhibit C. Exhibit C, my lord. Tax invoice. Yes, my lords. Now, they've made part payments. What was the total amount? The total amount against these 26 invoices amounted up to rupees 11,30,307. 307, my lord. 307. Now, your lordship will, if your lordship will kindly have, I'll trouble your lordship with the ledger once again, my lords. If your lordship will have page 2 of the judge's brief, volume 1, my lord. The last payment that has been made is 21st January 2020 of a sum of rupees 1 lakh, my lord.
Last payment 21st of June.
21st of January, my lords, of 2020, my lord. The last transaction your lordship will find at page 2.
1 lakh rupees.
My lord. Now, in terms of section 60 of the Indian Contract Act, my lord, application of payment where debt to be discharged is not indicated, it is upon the creditor to appropriate such payments against lawfully outstanding dues. So, my lord, a part of the sum of rupees 1 lakh was appropriated against the first bill, that is the bill of 3rd June 2019 that is there. So now, if your lordship will have the computation that is there at page 297 of the outstanding that is there as on date, my lord. Perhaps not as on date, as on 18th January
So your
2020.
total claim was 1130,307.
Out of this, part payment to the tune of 26 odd thousand was reduced from the first bill against the 1 lakh of last payment that had come in. And then the balance dues on principal cumulates up to 11 lakh 9,221, my lord.
So 11,30,307. In that 1 lakh and 24,000.
1 lakh, out of which a sum of rupees 24 odd thousand rupees have been reduced from the first invoice.
Where it is?
My lord, lordship will kindly have.
Have you issued the credit note?
Yeah, I have issued a demand notice upon them. That your lordship will find that.
Issued the credit note with regard to the.
No, I have appropriated a part of that 1 lakh against this
that
first.
1 lakh.
Yes, my lord. Your lordship will kindly have page 294 first. Rather, I'll place the demand letter first.
294.
Yes, my lord. This is Exhibit D, my lord. Letter dated 25th August 2022. Here, your lordship will find that I am claiming a sum of rupees 11 lakh 9,221.
11 lakh
9,221.
Correct.
This is so because I have appropriated that portion of 21,086 against the first invoice, that is 3rd June 2019. And then there remains a sum of rupees.
So what? How much amount you have appropriated?
I have appropriated a sum of rupees. I'll tell you the exact amount, my lord. 21,086 out of this 1 lakh of last payment that is coming.
So
the balance amount that remains is 1,206 against the first
amount appropriated.
21,086, my lord, against the invoice dated 3rd June 2019, my lord.
21,086.
My lord.
Appropriated.
My lord.
So remaining
1,206, the principal amount against
1,09,221.
My lord, 1,206 is the remaining amount. Your lordship will kindly have page 297 once.
I am 297 only.
Yes, so the first, my lord's amount, principal amount, 3rd June 2019, bill number 493, this is 1,206. After the appropriation of a sum of rupees 21,086.
Which date bill you are mentioning?
My lord, the first bill that is there, my lord, your lordship. 3rd June 2019, my lord.
3rd June 3rd you have stitch also.
And this bill,
June 2019.
Yes, this
that
bill.
Is that what is the amount?
This bill, the amount.
1,940.
No, I'll tell you, lordship. The amount of this bill, my lord, is 22,292.
Where it is?
268, page 268.
That's what I'm asking.
Oh, I'm sorry, my lord. Page 268, my lord.
Hmm, 268.
Your lordship will find, my lord.
Hey, 3 बजे 6 minutes है 22,292. Correct.
Of which I have appropriated a sum of rupees 21,086 from this last payment worth rupees 1 lakh that is come.
Where from you find that the 21,086 has been appropriated?
My lord, I'll show your lordship. Your lordship will kindly have page 2, my lord. I'll show your lordship the last payment that is entered the bank in terms of the ledger. Is of a sum of rupees 1 lakh, my lords. Out of that, this 1 lakh now, my lord, has been appropriated towards previous invoices that are there, and the balance amount that is there with respect to the invoices that I am claiming under in this suit, my lords, the sum of rupees 21,086 has been.
So you mean to say your total due was
11 lakh
11 lakh
30,000 odd.
Your total due was
11 lakh 30,307.
11 lakh 30,000 through 11 lakh 30,000 307.
My lord.
Correct.
My lord.
So out of which you have appropriated the 21,086.
I'm so grateful.
Correct.
My lord.
And now remaining 11 lakh 9,000.
I'm
That
so
is a
grateful.
simplicity.
This is the simplicity case. Now your lordship will kindly have page
So
297.
now what is the total claim? 11 lakh?
11 lakh 9,221 on principal and interest at the rate of 18% up to the date of 18th January 2023 that I have calculated. I've also annexed the non-starter report of the Honorable High Court Mediation Center at page 296, my lords, Exhibit E, dated 9th March 2023, instituted suit. So my lord, reliefs your lordship will find at page 19 of my plaint, my lord.
So where is the invoices?
My lord, the invoices, like I said, page 268, Exhibit C, your lordship had noted it down earlier, my
That
lord.
is only one invoice.
No, there are 268 to 293, my lord. There are 26 invoices.
268 to
3rd June 2019 up to 10th October 2019. There are 26 invoices that have been raised.
That is Exhibit 3.
Exhibit C, my lord. Yes, 3C.
C.
Page 268 up to 293, my lord.
Okay. And legal notice?
Legal notice, your lordship will find Exhibit D at page 294, my lord. Letter dated 25th August 2022.
They have given any reply?
No reply, my lord. Then there is a non-starter
notice?
I'm sorry, my lord.
Service of notice?
Service of notice perhaps is not there, but there is writ of summons had been served.
No.
No service of notice, my lord, is not there.
That postal receipt?
No, it's not there. It's
no,
not there.
the notice which you have sent.
I appreciate what's falling down. That's not been annexed to the plaint, my lord. I cannot improve upon the facts.
Okay. Hey, fixed matter है क्या? कौन है कोई है? Witness. Hearing concluded. Sense supreme for the plaintiff. Plaintiff has filed the written notes of submission. Let the same be kept with the record. CAV. Yes.
I'm so grateful, my lord. Oh.
A witness is in the box.
First witness.
Yes.
First
Started, no?
attesting witness,
attesting.
cross-examination is continuing.
Continuing?
Yes.
Continuing. I have asked some questions already.
What is your name?
Sudipta Modlik. SUDIPAMALLICK. Such cross. Only cross continuous.
Witness আগেকার question গুলো আছে? এগুলো আছে কি? Question 35 দেখাবে। Witness has shown question 35. You were asked what was the physical and mental condition of Dr. Prashanto Banerjee on 14th May 2018. In your answer, you have only mentioned about his mental condition. What do you have to say about his physical condition?
আপনি 35 নম্বর কোশ্চেনে যে অ্যান্সার দিয়েছেন
সেটাতে আপনাকে জিজ্ঞেস করা
আপনাকে
হয়েছিল
ইন্টারপ্রেট করতে হচ্ছে করতে হচ্ছিল আগে
আপনাকে জিজ্ঞেস করা হয়েছিল যে ডক্টর প্রশান্ত ব্যানার্জির শারীরিক এবং মানসিক স্থিতি কেমন ছিল এই 14 মে 2018-তে।
হুম।
কিন্তু আপনি শুধু উনার মানসিক পরিস্থিতির কথা বলেছেন, মেন্টাল স্টেট। উনার ফিজিক্যাল স্টেটের কথা কিছু বলেননি। এখন আপনার ওই উনার ফিজিক্যাল স্টেটের কি বলার আছে, উনার কেমন ফিজিক্যাল স্টেট ছিল ওই তারিখে?
মানে পার্টিকুলার ওই তারিখে?
হ্যাঁ, 14th May 2018।
আচ্ছা, দেখুন 14 মে 2018-এ আমি স্যারকে ফিজিক্যাল কন্ডিশনে যেভাবে দেখেছিলাম, উনি আগে যে এজ রিলেটেড ইস্যুস গুলোর মধ্যে ছিলেন, যেমন চলতে গেলে ওনার শ্বাসকষ্ট হতো বা উনি বেশি কোনো ওয়ার্ক চলতে পারতেন না, এই সমস্যাগুলো মোস্টলি ছাড়া আমি কোনো ডিফারেন্স কিছু দেখতে পারিনি ওনার মধ্যে।
On 14th May 2018, as I saw Dr. Prashant Banerjee, he had age-related problems like difficulty in walking, and he had difficulty in breathing also. While walking.
Where did you meet him?
And
Other than this, I did not find any.
ইন্টারপ্রেটার করছে, আমি আর কি বলবো?
Other than this, I did not find any difficulties with him. Next.
Interpreted, court interpreted করছে। Where did you meet Dr. Prashanta Banerjee on 14th May 2018?
14 মে 2018-তে আপনি ডাক্তারবাবুকে কোথায় দেখা করেছিলেন ওনার সাথে?
ওনার বাড়ির ফার্স্ট ফ্লোর কিচেনে।
I met him on the first floor at the kitchen at his premises.
Why did Ashish Ghoshal and Isha Banerjee ask you to meet Dr. Banerjee and not Dr. Banerjee directly?
কেন আশিস ঘোষাল এবং ঈশা ব্যানার্জি আপনাকে ডাক্তারবাবুর সাথে দেখা করতে বলেছিলেন, কেন ডাক্তারবাবু আপনাকে ডাইরেক্টলি দেখা করতে বলেনি?
সরি, কোন অ্যাসপেক্টে মানে উনি দেখা করতে, মানে ওনারা জানিয়েছেন সে প্রশ্নটা বুঝতে পারলাম না আমি ঠিক।
তাহলে শোন কোয়েশ্চেন 36, ঠিক আছে? আর তারপরে আমার এই কোয়েশ্চেনটা করে দিন, আগেটা কেটে দিন। শোন কোয়েশ্চেন 36 আর তারপর আমার কোয়েশ্চেনটা দিন, ঠিক আছে?
How did you come to know of today's proceedings and that you would be required to come? আপনি কিভাবে আজকে প্রসিডিং এর কথা জানলেন আর আপনাকে যে এখানে আসতে হচ্ছে?
আমি বুঝতে পেরেছি। না, এই প্রসিডিংটা তো এখানে উইটনেস দেবার জন্য আসার জন্য, মানে কোর্টে আমি
মাই মিস্টেক Do you know when Dr. Prashanta Banerjee was hospitalized?
আপনি কি জানেন কখন ডাক্তারবাবুকে হসপিটালে ভর্তি করতে হয়েছিল?
সরি, এক্সাক্ট টাইম আমি বলতে পারবো না।
I cannot tell the exact time.
If I put it to you that Dr. Prashanta Banerjee had to be hospitalized on 15th of May 2018, would you be able to contradict me?
আপনাকে যদি বলা হয় যে ডাক্তারবাবুকে 15 মে 2018-তে হসপিটালে ভর্তি করা হয়েছে, তাহলে কি আপনি উকিল বাবুর সাথে একমত নাকি?
এক্সাক্ট ডেট নয়, তবে ওরকম 15 তারিখের দিকেই হবে ওনাকে অ্যাডমিট করতে হয়েছিল।
I do not know the exact date, but it was around 15th May 2018 when he was hospitalized.
Now, do you remember within how many days of being hospitalized he passed away?
উনি 17th May-তে মারা যান।
He passed away on 17th May
2018.
What was the reason of his death?
ওনার মারা যাওয়ার কারণ কি ছিল?
আমি ওনার ডেথ সার্টিফিকেট দেখিনি, হসপিটাল ইস্যুড যে ডেথ সার্টিফিকেট, বাট যেটা আমি শুনেছি যে ওনার কার্ডিয়াক অ্যারেস্ট হয়েছিল হার্ট ফেল করেছিলেন ওই জন্য মারা গেছেন।
I have not seen the death certificate of Dr. Prashant Banerjee, but I have heard that he died due to cardiac arrest.
Hospital's death certificate issued by the hospital.
Issued by the hospital. Hospital.
Yes, next.
Now, witness, you have deposed that you met Dr. Banerjee on 11th May and then again on 14th May. Was Dr. Pradeep Banerjee present on either of these days?
আপনি এর আগে কোর্টে বলেছেন যে আপনি 11 মে আর 14 মে ডক্টর বাবুর সাথে দেখা করেছেন। সেই সময় কি প্রতীক ব্যানার্জি ওখানে উপস্থিত ছিলেন?
না, ডক্টর প্রশান্ত ব্যানার্জির সাথে তো মিট করার কথা।
হ্যাঁ, সেটাই বলছি।
না, ডক্টর প্রদীপ ব্যানার্জি ছিলেন না।
No, Dr. Pratik Banerjee was not present.
প্রদীপ,
Pradeep
PRATIP.
Pradeep Banerjee.
Would you know why he was not present?
আপনি কি
কেন
জানেন উনি কেন উপস্থিত ছিলেন না?
না, এক্সাক্ট কারণ আমি জানি না, কিন্তু ওনার সাথে সম্পর্ক স্যারের সাথে ভালো ছিলেন না এটা জানি, কিন্তু কি কারণে ছিলেন না বা কেন উনি দিয়েছেন সেটা আমার কাছে কোনো ইনফরমেশন নেই।
I do not know the exact reason why he was not present, but I knew that he did not have good relationship with Pradeep Banerjee.
With
Prashant Banerjee.
No, he's right. আচ্ছা ঠিক আছে, যেটা আপনি
With Prashant Banerjee.
Who informed you that Dr. Prashanta Banerjee and Dr. Pradeep Banerjee did not have a good relationship?
আপনাকে কে বলেছে যে ডক্টর
না,
প্রশান্ত?
এখানে বলার কিছু নেই অ্যাকচুয়ালি। আমরা চেম্বারে যারা কাজ করি তারা তো দেখতেই পাচ্ছিলাম, এবং কিছুদের কাছে শুনেছি যে ওনাদের সম্পর্ক ভালো চলছে না, এবং তারপর তো চেম্বারে যেটা দেখেছি সেটাতে হিসাবেই আমরা একটা অ্যাজাম্পশন করেছি।
You said you have heard. Who did you hear such information from?
No, let first answer be complete.
Oh, sorry. Sorry.
The persons who were working in the chamber knew that Prashanta Banerjee, Dr. Prashanta Banerjee and Pradeep Banerjee did not have good relationship. We saw them. আর কি বললেন?
মানে আমরা চেম্বারে যারা কাজ করতাম তারা এই জিনিসটা অবজার্ভ করেছি সেই
We had observed.
As we are working in the office, we observed this.
We observed this.
My lord, he had said শুনেছি ওনাদের কাছ থেকে।
We working in the office, we observed.
He said both. He had said শুনেছি also. আমরা শুনেছি ওনাদের
And
কাছ
also we learned about it. Heard about it, not learned, heard about it.
Did not have good relationship. We are saw
and heard.
And heard.
আবার আনসারটা বলে দিন লাস্ট, সরি।
Answer করুন।
The person we are working in the chamber, chamber known Dr. Prashanta Banerjee and Dr. Pradeep Banerjee did not have good relationship. We saw and heard that we had observed. We have working in the office
as we were working.
As we were working in the office.
No. Dr. Prashant Banerjee and Pradeep Banerjee were not having good terms, and we have observed from the office. We are working in the same office, and we are also heard about the same.
Chamber.
Chamber.
So who have you heard this from?
আপনি কার কাছ থেকে শুনেছেন ওনাদের সম্পর্ক ভালো ছিল?
অ্যাকচুয়ালি আমাদের চেম্বারে 50+ স্টাফ ছিল তখন, তো সবাই অলমোস্ট জানতো, এবং তাদের মধ্যে কে কে বলেছে বা কোথা থেকে শুনেছি এতদিন পরে পিন পয়েন্ট কিছু বলতে পারবো না।
We had 50+ members in the chamber we all knew about their relationship, but I cannot exactly say who had told this
After all these years.
all these years.
Well, just give me one moment. So, can you tell since when, Doctor, since when you have observed or heard of this alleged bitter relationship between Dr. Pratip Banerjee and
Since when you have observed of this alleged bitter
relationship between Dr. Pratip Banerjee and Dr. Prashant Banerjee?
আপনি কবে থেকে এই ওনাদের মধ্যে যে রিলেশনশিপটা এটা এতো ছিল, এটা কবে থেকে আপনি observe
খারাপ
করেছেন?
হচ্ছিল
খারাপ ছিল।
এটাও এক্স্যাক্টলি তো আমি বলতে পারবো না, কিন্তু উনি মারা যাবার অ্যাপ্রক্স 1 year।
I cannot tell exactly, but it was 1 year from his death,
Approximately 1 year from the date of
from
his
the
death.
death of Dr. Prashant Banerjee.
So this is your opinion. You don't have any particular proof as such. Am I correct?
এটা এটা আপনার মতে, আপনার ওইরকম কোনো তথ্য নেই, প্রুফ নেই।
না, আমার কাছে এক্সাক্ট কবে থেকে খারাপ হয়েছে সম্পর্ক সেরকম কোনো প্রমাণ নেই, কিন্তু আমি যেটা অবজার্ভ বা শুনেছি সেটা অ্যাপ্রক্স 1 বছর হবে, সেটাই আমি বলতে চাইছি।
I do not have exact proof that they had bitter relationship, but I knew that they had bitter relationship from the death, 1 year from the death of Dr.
না না, বিটার রিলেশনটা আমি অবজার্ভ করেছি।
He is telling that I am not having any proof, but I know from the last 1 year from the death of Dr. Prashant, the relationship was not good.
I have observed. I know that
Whatever
I
it may be.
have observed.
I do not having any proof. I do not
Have
have any proof.
I do not have any proof. Then
But in the form of last 1 year. In the form of last 1 year.
what you are writing, sir? But I observe for the last 1 year from the date of the death of Dr. Prashant, the relation was not good. ये दूसरे को बोलो। Yes.
What was your observation? What would you have to say about Dr. Prashant Banerjee and Dr. Pratip Banerjee's relationship prior to 1 year before Dr. Prashant Banerjee's death?
ডক্টর প্রশান্ত ব্যানার্জির মারা যাওয়ার 1 বছর আগে ওনাদের কিরকম সম্পর্ক ছিল, আপনার কি বলার আছে?
মানে মারা যাবার 1 বছর আগে দেখুন, ওই 1 বছরের যদি ব্যাপারে আপনি জিজ্ঞাসা করেন, তাহলে যেটা আমার মোস্টলি আমি অবজার্ভ করেছিলাম, স্যারের সাথে প্রদীপ স্যারের কথাবার্তা অনেক কমে গেছিল, এবং
ওই 1 বছরে
1 বছরের মধ্যে আমি যেটা অবজার্ভ
in that 1 year I had mostly observed that the communication between Dr. Prashant Banerjee and Pratik Banerjee had become less. বলুন।
আমি জিজ্ঞেস করছি। কোশ্চেনটা কি ছিল?
What was the question?
What you have to say about
Dr. Prashant Banerjee and Pratik Banerjee relationship. Relationship we have on year Prior to 1 year, before Dr. Prashanta Banerjee's death.
আর আনসার কি দিলেন?
উনি বললেন, বলো।
In that 1 year, I have mostly observed that the communication.
Not that. Before 1 year, what was the relationship?
My question was before, not during the
Before 1 year, what was the relationship?
মারা যাওয়ার আগে বলেছি।
হ্যাঁ,
ওনার মারা যাওয়ার 1 বছর,
মানে মারা যাওয়া এক বছর আগের এটা।
হ্যাঁ,
এই আনসারটা
আমি
এই
একটু
মত লিখো।
কনফিউজড হয়ে গেলাম।
আরেকবার বলবো।
বুঝে নিন,
আমি এক
বুঝে
মিনিট
নিন,
জানতে
বুঝে নিন।
চাইছি যেটা যে উনি যে 1 বছর
মানে
You
Sorry.
told that the 1 year.
হ্যাঁ,
Before 1 year, what was the
আচ্ছা মতলব
relationship between both?
মানে খারাপ সম্পর্কটা যেটা বলেছিস তার আগের 1 বছর।
Ah,
তার আগে।
আমি সরি কোশ্চেন
তার আগের 1 বছর না, তার
তার আগে কি ছিল? আগে আচ্ছা আচ্ছা আচ্ছা
প্রশ্নটা শুনে নিন আরেকবার যদি অসুবিধা
না ঠিক আছে, আমি বুঝতে পেরেছি। ভেরি সরি, আমি বুঝতে পারিনি কোশ্চেনটা। তো তখন যেটা ছিল যে অ্যাকচুয়ালি কথাটা তো হয়তো হতো, কিন্তু মানে স্যার যেখানে যেখানে যেতেন বা অ্যাটেন্ড করতেন, যেখানে ইউজুয়ালি প্রদীপ স্যার যেতেন সেখানে প্রদীপ স্যাররা যাচ্ছিলেন না, এটা আমি অবজার্ভ করেছি।
At that time,
মানে সেমিনার্স
there might be some communication between them, but seminar, তাই তো?
সেমিনার বা কনফারেন্স যেগুলো
In
অ্যাটেন্ড
the
করতেন।
seminar in which Dr. Prashant Banerjee used to attend, Mr. Pratip Banerjee
যাচ্ছিলেন না।
was not attending that particular seminars.
ডক্টর, দুটোই ডক্টর।
Dr. Pratip Banerjee, the particular seminars, as I observed. আপনি observe
হ্যাঁ
করেছেন।
সেটাই। এছাড়া ওনাদের মধ্যে কথাবার্তা মোটামুটি ঠিকই ছিলেন।
Other than this, communication between them was all right.
Are you aware of what medication Dr. Prashanta Banerjee was taking prior to his death?
আপনি কি জানেন ওনার মারা যাওয়ার আগে উনি কি ওষুধপত্র নিচ্ছিলেন?
না।
নো।
Who used to look after Dr. Prashanta Banerjee? Okay. Are you aware as to who all resided with Dr. Prashanta Banerjee at 10/3/1 Elgin Road, Kolkata 20?
আপনি কি জানেন যে ডক্টর প্রশান্ত ব্যানার্জির সাথে কারা কারা থাকতেন ওই 10/E/1
কোন সময়টা?
এলগিন রোডে?
না, কোন সময়টা?
উনি সময়ের কথা বলেন।
আপনি বলুন, তারপর আমি বলবো। জিজ্ঞেস করুন। I've asked you a question.
আচ্ছা, না আমি এখানে না বুঝতে পারলাম না যে আপনি কোন সময়টার জিজ্ঞাসা করতে চাইছেন, তাহলে আমি ক্লিয়ারলি বলতে পারতাম আর কি।
before death,
Before
who were residing in the set along with Dr. Prashant?
ডক্টর প্রশান্ত ব্যানার্জি মারা যাবার আগে প্রথমে প্রদীপ ব্যানার্জি, ডক্টর প্রদীপ ব্যানার্জি, ওনার ওয়াইফ, ওনার মেয়েরা ওখানে থাকতেন স্যারের সাথে। তারপরে ডক্টর প্রদীপ ব্যানার্জি ওই 10/3/1 এলগিন রোডের অ্যাড্রেস ছেড়ে অন্য অ্যাড্রেসে শিফট হয়ে যান, এবং তারপরে ডক্টর মারা যাবার আগে পর্যন্ত ডক্টর প্রদীপ ব্যানার্জির সাথে ওনার নাতনি ঈশা ব্যানার্জি এবং অন্বেষা ব্যানার্জি আর যারা সার্ভেন্টস অ্যান্ড মেটস ছিল তারাই থাকতেন।
Before his death, Dr. Pratip, Dr. Prasanjit. Before his death, Dr. Prashant Banerjee. Before his death, Dr. Prashant Banerjee used to reside with his wife.
না, তাহলে ওটা প্রতীক হবে।
প্রদীপ ব্যানার্জির ওয়াইফ।
Pratip Banerjee used to reside with his wife, his daughter, and later he shifted to another address where he used to reside with his granddaughters, namely নামগুলো
This is not going anywhere.
another
What are you saying?
He said the same thing.
No,
No, no.
sorry, sir.
Yes.
বলবো
Tell, repeat.
আপনি একটা কাজ করুন, আপনি আনসারটা না একটু ভেঙে ভেঙে দিন,
আচ্ছা সরি
একটুখানি বলুন, ওটা ট্রান্সলেট হোক, আবার বলুন, ট্রান্সলেট হোক।
ডক্টর প্রশান্ত ব্যানার্জি মারা যাবার আগে প্রথমের দিকে মানে এক্সাক্ট আমি টাইমটা বলতে পারছি না, উনি থাকতেন ওনার ছেলে ডক্টর প্রদীপ ব্যানার্জি।
Before his death, Dr. Prashant Banerjee used to reside with his bull.
হ্যাঁ ডক্টর প্রদীপ ব্যানার্জি,
Dr.
প্রদীপ ব্যানার্জি, ডক্টর প্রদীপ ব্যানার্জির ওয়াইফ,
wife of Dr. Pradeep Banerjee,
দেয়ার ডটার্স,
their daughters,
আর ডক্টর প্রশান্ত ব্যানার্জি এবং সার্ভেন্টস অ্যান্ড মেডস যারা ছিলেন,
and along with their along with Dr. Prashant Banerjee and servants and maids.
এবং উনি মারা যাবার এক্স্যাক্টলি মান্থ আমার মনে নেই, কিন্তু ডক্টর প্রদীপ ব্যানার্জি,
I do not remember the exact date of his.
প্রশান্ত ব্যানার্জি মারা যাওয়ার আগে কত মাস আগে এক্সাক্ট ডেট আমি জানি না,
But before the death of the Prashant Banerjee, yes.
হ্যাঁ তো ডক্টর প্রদীপ ব্যানার্জি এবং ওনার ওয়াইফ রিঙ্কু ব্যানার্জি এবং ওনার মেয়ে,
লিখেছো?
His wife and her his daughters, yes.
হ্যাঁ উনি ওনারা অন্য বাড়িতে শিফট হয়ে যান এলগিন রোড
Shifted to another house. Yes.
এবং মারা যাওয়ার আগে ঈশা ব্যানার্জি, অন্বেষা ব্যানার্জি, ডক্টর প্রশান্ত ব্যানার্জি এবং ওনার যারা সার্ভেন্ট অ্যান্ড মেড ওইখানে বাড়িতে থাকতেন।
And
At the time of death, Prashant Banerjee recorded the name.
প্রশান্ত ব্যানার্জি, ঈশা ব্যানার্জি, ঈশা ব্যানার্জি,
Isha Banerjee,
অন্বেষা ব্যানার্জি,
Anisha,
অন্বেষা
Banerjee, and
এবং সার্ভেন্টস যারা ছিলেন।
servants were with the Dr. Prashant Banerjee.
আচ্ছা, do you know where Navanita Ghoshal and Ashish Ghoshal reside?
নবনীতা ঘোষাল আর আশিস ঘোষাল কোথায় থাকেন আপনি জানেন?
হ্যাঁ জানি।
Yes, I know.
Can you tell us? Can you tell this honorable court where they stay?
ওনারা কোথায় থাকেন আপনি কি বলতে
ওনার বাড়ির অ্যাড্রেস বলতে পারবো না, কিন্তু 10/3/1 এলগিন রোড ওনার অপোজিট যে ফ্ল্যাট আছে ওখানে থাকেন ওনারা।
I cannot tell the address of their house, but they stay
Opposite to
the 10
house
by
number
10/3/1
Elgin Road. By 1.
Elgin Road. Elgin.
Elgin.
So you mean to say that Navanita Ghoshal and Ashish Ghoshal reside in a place opposite the residence of Dr. Prashanta Banerjee?
আপনি yes.
Are you aware as to how often Navanita Ghoshal or Ashish Ghoshal used to visit Dr. Prashanta Banerjee?
আপনি কি জানেন নবনীতা ঘোষাল এবং আশিস ঘোষাল কিরকম ভিজিট করতেন, কতবার?
মানে বাড়িতে না আমি বলতে পারবো না।
I cannot say.
I cannot say.
Was there any personnel from the Come to question 36. No, sorry, 36 now. Sorry. 20, 28. Was any person from the office of the एक second. Was there any personnel from the Registrar of Assurances present on 14th May 2018 when allegedly the codicil was signed?
14 মে 2018-তে রেজিস্ট্রার অফ অ্যাসুরেন্সেস এর অফিস থেকে কোনো ব্যক্তি কি উপস্থিত ছিলেন যখন এই যে অ্যালিজেড উইলটা ওটা সই হয়েছিল?
না।
Would you be able to say why no one from the office of the
How we
why?
can say, sir? It's not from the office.
Well, the one of the will is registered. Codicil is not.
That is the. How we can
Let him say. Let if
he stated that nobody was present. How we can say? Yes.
You'll give me 1 minute.
अरे मनो तो शोए का पहले पानी डाल
Do you recall if the will was read out to Dr. Prashanto Banerjee before he purportedly signed it?
আপনার কি মনে আছে যে মনে পড়ছে বা ওই যে উইলটা সেটা ডাক্তারবাবুকে সই করানোর আগে তাকে পড়ে শুনিয়ে দেওয়া হয়েছিল, শোনানো হয়েছিল?
আমি এখন মনে করতে পারছি না।
I cannot recall.
Do you recall whether the codicil was read out to Dr. Prashanto Banerjee before he purportedly signed it on 14th May 2018?
আপনি কি মনে করতে পারছেন যে সেই কোডেসিলটা উকিল ডাক্তারবাবুকে পড়ে শোনানো হয়েছিল সই করাবার আগে?
আমার এক্স্যাক্টলি মনে পড়ছে না, মেবি।
Maybe I do not exactly remember.
Lord, I will take one more day. The Lordship will keep it for any day. My Lord. Next week, I'll take one more day. I'll finish. Just I'll go through the whole. See, whatever is left, I'll ask those and finish. Any day next week, my Lord, the Lordship keeps it.
Next week. Sense appearing for the plaintiff. Sense appearing for the defendant. Plaintiff witness number 1. Plaintiff witness number 1 is present. Cross-examination resume. But the learned counsel for the plaintiff and defendant prays for time. Accordingly, cross-examination is deferred. Give the date. 10th March at 2 p.m.
I'll take 10-15 minutes.
345 or
345 है
450.
415.
दे दो.
Then this
বলে দিন আপনার উকিল
I want to just go through and see if there's anything left.
12th February at 3:45.
আমি ফেব্রুয়ারি 10th to 15th দিন থাকবো না কলকাতায়।
17th
কি বার পড়ছে একবার জাস্ট দেখুন। হ্যাঁ ঠিক আছে,
ভালো দিন সব।
very good.
17th.
Deep deep.
3:40.
Time দিচ্ছে? Yes, sir, I think so.
Yes.
345.
দেখবেন Monday 3:30 হবে।
Item number 16 of the commercial list.
Lordship, I am for the plaintiff, Your Lordship. Your Lordship has given my order dated November 8, 2024. I've closed the right to give written statement to the undefended suit, Your Lordship.
Yes.
They went to the appeal, Your Lordship, and this is the order of them.
Allowed.
Your Lordship, it is, if you will see to the operative portion, Your Lordship.
In view of the direction imping is
Right, however,
satisfied, however, it may
clear
clear reason for
setting
setting
aside
such impingement is
the
only
order
enable the court to
enable the court to
service of
decide
summon
the
upon
service of summon. There are direction upon bailiff, Your Lordship.
So appearing for the plaintiff, none appears on behalf of the defendant. In view of the order passed by the Honorable Appellate Court dated 16th of December 2024, let the matter appear on 20th January 2025
Oblige, Your Lordship.
under the same heading. Just a minute. Certificate also. The Deputy Sheriff of Calcutta is directed to comply with the order passed by this court passed by the appellate court dated 16 December 2020. The order passed by the appellate court be kept in the records.
Oblige, Your Lordship. Deeply obliged.
Order fix of 345. Item number 8 of the non-commercial list.
I appear on behalf of the plaintiff, Your Lordship.
Yes.
So I appear on behalf of the defendant. On the last occasion, there was a direction to file the written notes of arguments on behalf of the defendant in this matter. But before proceeding with the arguments for any further, I would like to file an application for appointment of forensic expert for verification of signatures. Because one can see, even one can see in his PRI, he can see that there is a big difference of signature, which is depicted in the will as well as the other document, the deed of conveyance, the property of which is also mentioned in the will, which has been sold out during the lifetime of the testator. So two signatures very much the difference. So what even one can see in bare eyes, he can understand the difference.
So the cross-examination of the attesting witness.
Yes. It
What
is there,
question you have put?
It is there because in
where is your application?
Application I have not yet filed. I have prepared. I have affirmed it. So may I pray for your lordship's leave to file that application?
Why the court can give love? If you file, otherwise I will proceed. Because today is the argument. If you proceed with the argument, otherwise I will close and I will hear the plaintiff. Nothing else. The application is not before this court, sir. Sorry. Today is fixed for argument. If you wanted to proceed with the argument, you proceed with. If you wanted to close your argument, you close it. The court cannot give a direction. Oh, okay, you come with an application for appointment of commissioner.
I understand. Now, whatever argument I am supposed to make, everything is depicted in this application itself. Because in the caveat, affidavit in support of the caveat, the defendant repeatedly mentioned that the entire will is forged. I'm reading it.
When you file the affidavit of caveat, sir?
Long time back.
When you cross-examine the plaintiff witness, sir?
Also in the last year.
Then the court is the evidence was closed. Evidence is closed.
Evidence is otherwise closed.
The last time you are argued the matter in part. Then.
So what?
There is some procedure.
There is some procedure, but a court can accept this kind of application at any stage during the proceedings.
Sorry.
There is a judgment to this effect.
Give the judgment. But there is no. At this stage, how the court can decide there is no application?
Lordship.
You please mind it.
Lordship.
Today, the case is fixed for argument.
Yes.
Correct?
Yes.
You are telling that you have not filed the application till now.
Yes.
So your application is not in board.
Yes.
Correct?
Yes.
So you have to proceed with the matter.
Seeing that even I am praying for adjournment of this case for today.
Okay, I am adjourning it.
Lordship,
Pay the cost. Pay the cost.
Yes.
Argument part heard. I will adjourn the matter, but I will give because the court time. You see, all the advocates are asking for the time. This court is not able to give the time short date because of fixing the matters for the purpose of the advocates only.
I understand.
Correct. Now this matter when the matter was taken up for hearing last
10th December 2024.
10th December after 1 month.
But it is getting affirmed.
Whatever
it will be filed in course of the
this
date,
court
sir.
is not concerned with your affirm, not affirm, filed, not filed. This court is concerned with regard to the status of the case today.
Yes, I understand.
That's all.
I understand.
And if your lordship sees, it's again my learned friend's prayer based on which your lordship had adjourned the matter.
Correct. On that day, you have stated that you are only 1 point with regard to this is ancestral property.
Ancestral property.
Correct. Second point, you raised that the testator has not executed any will. These are the 2 points you have raised.
Yes.
So this court has directed with regard to the ancestral property, and with regard to you, this court has stated that whatever the point you wanted to brought this court from the evidence, bring the written notes of argument so that the matter can be shortcut.
And we were supposed to start. I'm ready in the matter.
So today is the filing of the written notes.
Lordship, I'm sorry. In reply to question number 40, reply to question number 47, 48, 49, 50, 51, 52, and 53, and 54. The attesting Mr. Srinath Dubey could not give any satisfactory reply as to the date and place he had put his signature on the purported will.
That the court will
Moreover,
decide whether.
moreover, from question number 65 to 68, the attesting witness, Mr. Srinath Dubey, could not even identify the signature of the testator, which is depicting in the deed of conveyance, duly executed by the testator on 6th of May 2020.
Correct.
Therefore, the attesting witness himself could not recognize the signature between the two documents.
So if the attesting witness has not proved the signature, so what is the requirement of sending the matter to the expert? If the plaintiff did not prove the will through the attesting witness, so what is the necessary for sending the matter to the expert? It is your case.
Yes.
The attesting witness has not proved the signature of the testator.
Yes.
Correct.
Yes.
And only one witness was examined. If it is
Two
not
witness,
two witness, and what is the other witness?
Other he didn't say regarding the signature.
She is not. Please. If she has not stated anything, so as per your case, the will is not proved.
Yes.
Correct.
Moreover, if there is an expert opinion, it will be more beneficial for the court.
Expert opinion only a corroborative evidence. There is no expert opinion cannot be taken as a exact evidence. Please go through the judgments. Expert opinion cannot be relied. It is only a corroborative evidence, sir. Once you are telling that during the cross-examination, you brought on record that the plaintiff has not proved the witness through the will through the witness. So what is the necessity for sending?
Defendant repeatedly argued.
The court cannot grant the will only on the basis of the will. The court has to grant the will if the will is proved. How the will is to be proved? Will is to be proved from the attesting witness. You have stated that the attesting witness has not proved the will. Signature of the testator.
One of the attesting witnesses.
Whatever it may be.
Moreover, one of the attesting witnesses, along with his signature, has put the date stated to be of his chamber, not at the place of the.
Okay, you argue that.
Yes.
Give the written notes. I will take note of it. I will decide that.
In the application, I have stated all these things. In the application.
Application, I will not. Because application is not. Where is the written notes?
Now, in the event, my application can be treated at my written note of arguments.
So appearing for the plaintiff, so appearing for the defendant. The matter was listed on 10th of December 2024, and on the said date, the learned counsel for the defendant has argued the matter at length and prayed for time. Accordingly, this court had adjourned the matter and directed the parties to come with directed the defendant to come with the written notes of argument on the next date fix. Accordingly, the court had fixed the matter today. When the matter is taken up today, counsel for the defendant has taken another stand that the defendant has filed an application or is going to file an application for sending the purported will along with the signature of the testator to the expert report for examination. And prayed for it. And prayed for adjournment. Considering the submission made by the counsel for the defendant, this court finds that the suit is of 2022 and the plaintiff and the defendants have adduced their evidences. And as per the submission made by the counsel for the parties, the suit was the witness has been closed and the case was fixed for argument. And accordingly, the argument has been started. Now the defendant has taken a different stand and prayed for adjournment only to drag the matter. Accordingly, the case is adjourned subject to payment of cost of rupees 20,000 in the State Legal Service Authority within a week from date. If the defendant is paid the amount, the next date will be fixed for argument on the side of the defendant. If the defendant failed to pay the said amount within a week, the argument on the side of the defendant will be closed and the plaintiff will be given liberty to argue the matter. This is the matter on 29th of January 2024.
May I submit one thing?
Yes.
My application may please be treated as my written notes of arguments. The contents of my application.
This is High Court of origin side, not the district judiciary. Application should be taken as a written notes. Have you heard? You are a senior person, sir.
Not amount of
The
cost.
court cannot appreciate like this submission in the original High Court.
I understand.
And you are telling that the application is to be taken as a written notes of argument.
Not amount of cost may please be considered.
Sorry.
To some extent. Because he's
All
a video.
all members of the bar knows who is practicing before this. If the matter is fixed and advocates ask for the adjournment, has to pay the cost. Or you say, I will reduce the cost, I will close the chance for argument. These are the two way I am giving. Still, I am giving the chance. I will close your argument. I will hear the plaintiff. These are the two way. If you want to argue, okay, I am giving the time till 30, whatever is the date, but pay the cost. And not to the plaintiff. It is the legal aid service authority because of the wasting of the time of the court.
No, I can argue the case.
Argue the case.
But the thing is this, whatever I have written in this application, that I will place before your lordship.
Whatever it is, it is your choice. It is your choice.
In the form of argument, lordship. Then may I start arguing?
Yes, start.
Let them finish, then I'll start.
Yes, start. No problem.
That the issues in the present case involve the examination of the authenticity and or veracity of certain documents, signatures or writings that are critical to the outcome of the case. That in order to resolve the disputes concerning the genuineness of the documents, signatures in question, it is imperative to conduct a forensic examination by a qualified handwriting expert. That the application seeks the appointment of handwriting experts, scientific experts, to examine the disputed documents and to provide their expert professional opinions regarding the authenticity of the handwriting signature in question. In such circumstances, the purported unregistered will containing the disputed signature of the testator may please be sent for forensic examination to the Central Forensic Science Laboratory, New Delhi, to prove its genuinity, comparing with an admitted document containing the original and genuine signature of the testator, which is nothing but the deed of conveyance of the property, duly executed by the testator herein, which is also very, very much mentioned in the disputed unregistered will, which had been sold out by the testator during his lifetime. In the circumstances, I would like to place the copy of the disputed will, as well as the copy of that.
Has the document which you wanted to rely upon at this stage was brought on record during the examination of the witness?
Yes.
Show me which document you have brought at the time cross-examination. The conveyance deed which you relied upon.
Yes.
That was that is exhibited.
Not exhibited.
Then how it has been brought on record?
Now it has been brought on record. It has been brought on record as a document. It is brought on record. That the expert should be requested to carry out an in-depth analysis, including comparison with admitted and known handwriting samples appearing in the registered deed of conveyance, duly executed and registered by the testator himself, being none other than his lordship, the late Justice Ajit Sengupta, and if required, to collect digital evidences from the concerned registration office, being the office of the Additional Register of Assurances 1, Kolkata, in respect of the registered deed of conveyance being number 09353 for the year 2011, book number 1, CD volume number 9, pages from 6452 to 6474, and to submit a vivid report before this honorable court on the authenticity of the disputed documents on the basis of scientific comparison of the both. This is required to be done because of the fact that in the affidavit in support of the caveat, the defendant categorically and repeatedly stated that the will in question is absolutely vague, untrue, false, forged, and fabricated from its very first line to its very last line. The signatures as well as the initials as depicted on the face of the so-called will are also absolutely false and forged. The so-called will in question also does not include the details of other various properties duly owned by the testator, who was none other than a retired High Court judge. The manner or the language in which the so-called will has been drawn up just cannot be that of an eminent retired High Court judge. The so-called purported will is absolutely motivated, malified, manufactured, purported, and concocted from its very sums and substances. All these are duly stated in the affidavit in support of the caveat. The purported will in question also does not bear the signature and or authentication of the person as to who had drafted, typed, and explained the same to the testator to lend support to the genuineness of that purported unregistered will. Moreover, since the original defendant, being the only son of the testator, was a tree planter by profession and used to work in tea gardens in the district of Jalpaiguri, hence compelled to stay away quite often from Calcutta, whereas the testator was an aged person suffering from various ailments and senility and not in a sound state of mind and body and was fully dependent upon his wife, and thus the prolonged absence of the defendant from home had given them absolute liberty and opportunity to contrive against the defendant and to fulfill their sweet desire by way of practicing fraud and putting undue influence, pressure, and coercion upon the testator. Moreover, none of the attesting witnesses of the will had put any date along with their respective signatures on the purported will, whereas Mr. Surendra Deo Dubey, one of the attesting witnesses of the will, has put an address along with his signature on the purported will in question, which is other than the address, wherein the testator of the will has put his so-called signature on the purported will, which was being his residence situated at 34/2A Baliganj Circular Road, PS Goriahat, Kolkata 700019, where the testator stated to be resided last. The attesting witness had put the address as 10 Old Post Office Street instead of 34/2A Baliganj Circular Road. That apart, in reply to question number 47, 48, 49, 50, 51, 52, and 53, and 54, the attesting witness, Mr. Surendra Deo Dubey, also could not give any satisfactory reply as to the date and place where he had put his signature on the purported will. Moreover, from question number 65 to 68, the attesting witness, Mr. Surendra Deo Dubey, could not even identify the signature of the testator, which is depicting in the deed of conveyance duly executed by the testator on 6th May 2011. Now, as far as the second attesting witness is concerned, namely Mr. Gautam Kumar Mitra, he had also not put any date or place while putting his signature on the purported will as an attesting witness. In reply to question number 25 and in subsequent questions also, he also could not give any satisfactory reply as to why he had not put any date or place along with his signature on that purported will in question. Moreover, in answer to question number 47, the defendant herein has summarily denied. Moreover, in answer to question 47, the defendant herein has summarily denied the existence of the will in question, because according to her, the testator herein, being her father-in-law, had rest assured her that he had not executed any will in his lifetime. Apart from that, the defendant herein further informed the court that apart from the two properties as mentioned in the purported will, the testator had two more immovable properties, which were the self-acquired properties of the testator himself. These are the properties situated at 34/2A Baliganj Circular Road, PS Goriahat, Kolkata 700019, and another one is at Bolpur Shantriketan in the district of Birbhum, West Bengal. In reply to question numbers 38 and 40, the defendant adduced evidence in this regard. Question 30 and 40. In this context, it may be pertinent to mention here that despite selling out of one of the properties as mentioned in that purported will, the testator herein had not made out any codicil and or a fresh will thereafter. It is most humbly and respectfully stated and submitted before your lordship that for an eminent retired High Court judge, it is just next to impossible. Hence, for the aforesaid reasons, the disputed signatures, full and initial, of the testator on the purported will must be sent for forensic examination to compare the same with the admitted signatures, full and initial, of the testator as depicted in the deed of conveyance duly executed by the testator herein on 6 May 2011, and or any other documents and or case records which are very much available in this honorable court, since his lordship is a retired judge of this court. Hence, in any event, the probate of such a forged will should not be allowed to be granted in favor of the plaintiff in any manner whatsoever. That's all.
That's all.
So may I'm submitting the written notes of arguments to lordships in course of the day, and I'm also serving the copy of the same.
Yeah.
But my application is otherwise ready. If your lordships,
Okay, when your application will come, we'll see to that. No problem.
lordship.
Yes.
আচ্ছা এটা এই পেপারগুলো এটা করে এই কস্টেরটা বাদ দিয়ে এখান থেকে একটা কপি নিতে হবে।
Your Lordship wants me to argue. I'll not be able to finish. If your Lordship wants me to argue, I'll start. If your Lordship gives me time on the 29th, Mrs. Mukherjee will finish. And he takes up my plate.
Yes.
The testator of the will is Justice Ajit Kumar Sengupta, who is retired. At the age of 75, he had made a will giving his properties to joint executors and joint beneficiaries, being
That is correct. That is, you need not to go on further. You show me how you approve the will. Who are the two attesting witnesses?
I will show that section 63 and section 68 of the Evidence Act. Evidence Act, is it?
Evidence Act.
Yes, 68 of the Evidence Act. As to what do I need to prove? Proof of execution of a document, if your Lordship has.
Yes.
Proof of execution of a document required by law to be attested. If a document is required to be attested by law, to be attested, it shall not be used as evidence until one attesting witness, or at least has been called for the purpose of providing
Give the
its
success and
execution.
Yes, yes. That's why I'm asking
That is
where
why-
your evidence, where that's
No, I have to first indicate as to what I need to prove. Thereafter, I will show you,
show
Lordship.
me the evidence. So the evidence, what evidence you are led to prove the will with regard to the two attesting witnesses. Show the evidence. Where is the evidence of two? There are two attesting
are-
witnesses. Both examined or one examined?
Both of them examine and cross-examine.
Show me that evidence. How you approve?
Lordship, just give me 1 minute. There's so many documents I need to. Finally comes to the evidence of Mr. Surendra Dev Dubey, the second attesting witness. I have been able to locate the evidence of him first, then I'll show the other.
Yes.
Lordship, see, it's recorded on 11th of August 2023. Before your lordship comes to the evidence, I would like to show the attesting witnesses affidavit of affidavit. That
কখন দেখানো
দেওয়া আছে? আমার পেজ নাম্বার করা নেই। But you will see, I, Mr. Surendra Dubey, son of such and such, aged about such and such, stating this, that I am one of the attesting witnesses in the last will and testament of the deceased above named, dated 29 February 2008. The said will is annexed to the petition for grant of probate in favor of one of the joint executors acting severally named in the said will and testament of date of Ajit Kumar Sengupta, deceased. Photocopy of the passport. His passport is there. On 29 February, I, along with Sri Gautam Kumar Mitra, saw the deceased above named executed the said will dated 29 February 2008 by signing his name in English at the foot of the will in my presence, as also in presence of the other attesting witness. Thereafter, at the request of the said deceased, myself and the other attesting witnesses signed our respective names as attesting witnesses at the foot of the said will, all being present at the same time, and all having signed in the presence of each other in the residence of the deceased as specified herein above. This is affirmed in front of the commissioner. Thereafter, during examination, Mrs. Mukherjee had put questions to him. I'll take your lordship through it. How are you connected to the incident proceedings? I was one of the attesting witnesses. Lordship has the folio.
Yes.
I was one of the attesting witnesses of the will made by Justice Ajit Kumar Sengupta. How are you connected with the testator? Professionally, he was a counsel. I used to brief him. Even after his retirement, I used to brief him for opinions and guidance. As your lordship knows, he was a justice of this honorable court, and after retirement also he was working for different matters in arbitrations and for legal opinions and everything. How did you get the intimation that you were required to be an attesting witness of the will of late Justice Ajit Kumar Sengupta? He had called me and asked me to come to his residence for being an attesting witness to his will. A document was shown. What is this document? The will was shown. That was identified. Do you find any signatures in the internal page of the document? Yes, I do. Now, your lordship will kindly take a look at the will at the same time. The will is annexure A.
Yes.
Do you find any signature in the internal third page of the document? Yes, I do. The internal third page of the document, lordship will find. I'm not going to the exhibit and markings. I'm just showing from the examination and what is there in the paper. Thereafter, I'll go out for the exhibits. Can you tell my lord whose signature appears on the right hand side of the internal page number 3 of the document? Justice Ajit Kumar Sengupta. How do you know that it is the signature of the late Justice Ajit Kumar Sengupta? It was signed in my presence. Do you find any signature on the left hand side of the document? There are two other signatures. One is of Mr. Gautam Kumar Mitra and another is myself. He is not only identifying the signature of the testator, he is also identifying the signature of the other witness and himself. How do you know that the first signature on the left hand side of the document is of Mr. Gautam Kumar Mitra? Gautam Kumar Mitra was present at the time when the signature of Ajit Kumar Sengupta was made along with me. He's also saying that Mr. Gautam Kumar Mitra and signing it. Do you see Mr. Gautam Kumar Mitra? Did you see Mr. Gautam Kumar Mitra and the testator late Ajit Kumar Sengupta put their signatures in this document? Yes. Where was this document executed? It was executed at the residence of late Justice Ajit Kumar Sengupta. At the time of execution of this document, who were present? Late Justice Ajit Kumar Sengupta, Mr. Gautam Kumar Mitra, and I was present. Was there anybody else from you three are there? Not in the room where it was signed. It was signed in his chambers. That's what was happening. When was this document signed? On 29th February 2008. Do you recall the day of time, the time of the day when this document was signed? I do not exactly recall, but it was in the evening. Shown document. Do you identify the signatures made at internal page number 3 of the document? The witness identifies 3 signatures in the internal page number 3 of the document, which are already tendered and exhibited as Exhibit E, that of Ajit Kumar Sengupta, Exhibit F, Surendra Dubey, and Exhibit G, Gautam Kumar Mitra, and collectively marked as Exhibit B, because it was identified by the other witnesses as well. Lordship, 3 signatures here of Justice Ajit Kumar Sengupta, of Gautam Kumar Mitra, and of Surendra Dubey in the original will has been identified, has been marked as exhibits by all 3. Shown document, which is Exhibit C in the instant proceedings. Whether there are any other signatures or initials in the said document. There was initials in page numbers 1 and 2. Now Exhibit C is the bill. Kindly takes a look at the bill. Kindly comes to the first page of the bill.
Yes.
On the left hand side of the bill is initial, which has been encircled by the late Justice Ajit Kumar Sengupta. In the second page also, there is an initial on the left hand side, which has also been encircled and has been identified as an exhibit. These 2 signatures were identified, and they had already been marked as exhibit before. Now the next question: whose initials are there in page numbers 1 and 2? Late Justice Ajit Kumar Sengupta. Whether the initials were put in your presence simultaneously at the time of signing of the will. The witness identifies the initials at page number 1 and 2 of the document, which are already tendered and exhibited as E1 and E2 respectively. Therefore, the initials which are made on the first and the second page by late Justice Ajit Kumar Sengupta as identified and exhibited, but also exhibited as E1 and E2, that has also been proved according to me. I am showing you a document which is at page 12 of the probate application. What is this document? This is a declaration made by me. Now we have moved on to the declaration. And I'm not going to bother your lordship with it. So what I had to I am at question number 24, your lordship. I am showing you a document being an affidavit dated 10th October 2012. What is this document about? This is my affidavit as an attesting witness, which has been filed in the instant proceedings, which I showed your lordship. Do you find any signature in the instant document? Yes, this is my signature. Please encircle the signature. Yes, the witness encircled the signature with red pencil. The document is tendered and marked as Exhibit H, and the signature is tendered and marked as Exhibit H by 1. Now, your lordship, I have shown you the signatures which are appearing from the will. The signatures of all the 3 big signatures, the full signatures, have been identified and exhibited by 3 witnesses. This witness has identified them and has been marked as exhibit. The 2 signatures which are appearing in page numbers 1 and 2, the initials, has also been identified. The witness has been shown his own affidavit, and he has identified what the document is. He has also identified and his signature, which has also been marked as Exhibit H by 1. According to me, this, by virtue of the second witness,
yes,
he discharges
what
the
is the
burden of-
cross-examination?
Yes, your lordship, now we'll take a look at the cross-examination. Now, my learned friend has asked a lot of questions. What my learned friend submitted before your lordship, that he has not come up with satisfactory answers. Now, the question I have to ask myself as to the satisfactory answers as to whom? I was very satisfied with whatever I had to ask from the witness, and what my learned friend has asked, kindly we'll take a look at the cross-examination in its entirety, and then your lordship will decide on its own. How many times have you visited? I'm moving serially. How many times have you visited to Justice Sengupta's residence, where you have signed this document? For signing the document, I went there for once. Apart from that, that is the next question. Apart from that, I have known him for a number of years. Whenever he used to call me, I used to visit him in connection with matters brief prior to his elevation and thereafter his retirement. After his retirement, and I do not remember the number. So you obviously know his family members. No. I only know Ajit Sengupta, Tapati Sengupta, and their daughter, Angana Sengupta. Was Mr. Sengupta having any son? I did not know about it. Have you not seen? No, never. At the time of execution of this document, was there anybody else present in the residence of Justice Ajit Kumar Sengupta? In the room, and this has also already been answered, in the room where I was present, only Mr. Gautam Kumar Mitra, Justice Sengupta were present. I do not know if anybody else was there in the house on that day. Was anybody else present in the other rooms of the residence of Justice Sengupta? I do not know. It is not possible for him to know also. How many rooms are there in Justice Ajit Kumar Sengupta's residence? Kindly will see the conduct of the question. We used to visit the first floor where there was one chamber, 2 bedrooms, apart from the dining area and a bathroom. Apart from the first floor, how many floors are there? As far as I know, there is another floor which I have not visited. Is there any specific name of the building? Should I read on, Your Lordship?
Yes.
I do not remember right now. How many floors are there in the building? We were only confined to the first floor. We never visited the other floor. Did Justice Sengupta himself prepare this will? It was already prepared when we went to sign it. Is it a typed will? Do you have any idea who typed this will? No. Do you have any idea whether it has been typed by Justice Sengupta himself? No. Next slide. Lordship will take the next deposition, which is 18th August 2023.
Yes.
Have you gone through the will before signing the same? As an attesting witness, he was shown the will. No, I have not. You did not feel it necessary to go through the document on which you are putting your signature? Since I was only putting my signature as an attesting witness, I thought it was not necessary for me to go through the contents of the document. Your Lordship will recall that he was asked a question as to whether this will was made by Justice Sengupta himself or did he type it. It was not in his domain to know about it, and that is what he has said. Did Ajit Sengupta himself explain you regarding the document? I was only told that this is my will and you have to sign as an attesting witness, and I have signed it. Whether the will was explained to the attesting witness is of no relevance, Your Lordship. Shown the will. Please come to Exhibit F of this document, where your signature is there. Is it your signature? Yes. Now that he has put a question to the same effect, Exhibit F, which has also already been identified the fact, and he is also admitting to it. Have
That
you
is
put
the
any?
affidavit. That is the
That's
affidavit.
absolutely, Your Lordship. That is what I'm saying. Have you put any date over there? No, I have not. Why did you sign this document as an attesting witness? You did not feel it essential to put a date. I did not feel it essential. Whether he signs and puts a date or whether he puts any address,
Yes.
that is absolutely of no relevance. Whether he has signed it in front of the other person, whether the testator has signed it in front of him, or whether the other person has signed it in front of him, is what is relevant here. What about the address you have written? This was my office address at the point of time. Do you have any documentary evidence regarding the same? You have an office at 10 Old Post Office Street. This was objected to for obvious reasons, and he has said I will have. I put it to you that you have signed this document not at the residence of Justice Sengupta. I do not agree. I further put it to you that you have put your signature on this document at your office itself, situated at 10 Old Post Office Street. It is not correct. It was signed at the residence of Justice Sengupta. I further put it to you that you have not signed the document on 29th February 2008. I do not agree with your suggestion. I further put it to you that you have signed the document on some other date and that And that is why you have not put the date under your signature. It was specifically denied. It is not correct. It was signed on 29th of February 2008. The next question. On the request of Justice Sengupta, you had visited his place to put your signature as an attesting witness. Is it correct? Yes. On whose request you have come before this court to depose? Since I have received information from Advocate on Record Mr. Abhijit Chorkar of the plaintiff that as I have signed as an attesting witness to the will, I have to come and depose. I have come before this honorable. Now, he was not required to come, but we felt it was necessary since it is a contested matter. We wanted to produce evidence of both the attesting witnesses. That is why we had asked him to come. Have you received any kind of summons from this court? No. I put it to you that you had been at the residence of Justice Sengupta to sign this document, not at the request of Justice Sengupta, but at the request of Tapati Sengupta. And Tapati Sengupta is one of the beneficiaries and the joint executor of the. It is not correct. I further put it to you that on the request of Mrs. Tapati Sengupta, you have come before this court to depose. Essentially the same question. That is not correct. Shown page 12 of the plaint, which is a declaration. Is it your signature? Now he has been taken to page 12 of the plaint, which is a declaration signed by Mr. Dev Dubey. Your Lordship wants to come to that? The declaration part?
No. Continue.
Where you have put your signature in this document. This signature was put in the office of Mr. Abhijit Chorkar. It's a declaration. On which date? 30th November 2012. Shown the will. Kindly come to exhibit E1 of the will. Is it abbreviated signature of Justice Sengupta? Now, my learned friends shows him the initial, the short signature and asks him this question: is it the abbreviated signature of Justice Sengupta? This is the initial of Justice Sengupta. This was put in front of us on 29th February 2008. Signature which I showed your Lordship on page numbers 1 and 2 on the left hand side of the page. That is also which had been marked as exhibit. He only put a question to that effect, and that has also been stated that it was his signature again. Have you ever seen earlier the initials of Justice Sengupta in other documents? I could not remember. Whether he had seen Justice Sengupta's signature, short signature in other documents, he is not bound to remember as well. It was put in front of him, that is why he remembers, and that is exactly what he has stated. Shown at page number 2 of the deed of conveyance executed by Justice Ajit Kumar Sengupta on 6th May 2011, which has been marked for identification. Can you identify this signature? No. Can you appreciate, Lordship, this is a document, a Xerox copy of a document which has been shown to him and which has not been exhibited for marked for identification, and I do not know what the veracity of the document is.
Xerox copy.
I did not interrupt
copy from
my
the
learned friend.
official website of the Government of Registration. Official website.
He has shown this document. He has said that no. And that document is not part of exhibit. It has not been proved. And so I cannot rely on it, or I cannot show it to your Lordship. As simple as that. You cannot identify the signature of Justice Sengupta. I can see the name in full of Justice Ajit Kumar Sengupta. And it is not the initial signature. It is not similar to the one which was shown to me before. Now, kindly appreciates the fact that the will which was signed and the signatures which were identified by this attesting witness, and as he has stated, the signatures was put in front of him. Whether he remembers or recollects any short signature which was put before in any other document, that he has also stated that he does not remember. After saying that, he has been shown this document and has been asked whether do you know whether this is a signature of Mrs. Justice Ajit Kumar Sengupta? He said, I do not understand, I do not know.
Yes.
And he has been asked whether it appears to be the signature. He said it appears to be the full name of Justice Ajit Kumar Singh. I'm also showing you another signature at page 12 of the document. Is it the signature of Justice Ajit Kumar Singh Gupta? I am not able to confirm, but that name written is also Ajit Kumar Singh Gupta. Now I am showing you a signature at page 16 of the document. Can you identify the signature? That signature is of Mr. Ajit Kumar Singh Gupta. It was a full signature, but I cannot show it to your lordship because it is marked for identification. I suggested to you that Justice Sengupta was always used to put his full signature and not the initial. So far as the will is concerned, the initial was put in front of us. So far as usual practice is concerned, I have no knowledge. And that makes it all clear.
Yes.
There are more depositions. He has been asked more questions.
Yes.
If your lordship permits me, I'll come back on a later date. Can it be on 29th itself, your lordship?
Let me see. Census and suffering for the plaintiff, census and suffering for the defendant. Counsel for the defendant has concluded his argument and submitted he will file the written notes of argument in course of the day. In course of the day. Counsel for the plaintiff has argued the matter at length, but due to paucity of time, hearing could not be completed. Let the matter appear on 29th. Time nahi hai na? What time? 12th February at 12:45.
12th February.
कोई शॉर्ट डेट नहीं है खत्म कर रहे
শর্ট ডেট থাকলে দিন অসুবিধা কিছু নেই
थर्सडे तो हमारा वो है हाउ मच टाइम यू विल टेक
I will take 30 minutes. Whether Mrs. Mukherjee will finish it in a day. In an hour maximum.
कब है नहीं वो फिर 3:45 होगा नहीं उन लोग 1 घंटा चाहिए हाँ 10th March at
10th of March.
Huh? 2 p.m.
Can I take my can your lordship the date which was given to me by your lordship on 3:45? We can try to finish it. If it spills over, your lordship will keep it one other day. We'll finish it.
Again, the same thing will happen. ये तो टेस्टामेंट ही है ना ठीक हो क्या 17 फरवरी 12 फरवरी at 3:45 3:45
Lordship, may I have your written notes arguments to your lordship's court officers.
Lordship, Lordship, may I have your kind leave? My senior has already mentioned and indicated, Mr. Sinha, that we will be filing a short note in the La Martiniere matter, indicating the circumstances which have
you filed?
Lordship, I am ready with.
Give to my court office.
Grateful, your Lordship.